The Committee on Homeland Security, Justice, and Public Safety hearing of September 4, 2025 is hereby called to order. Good morning, colleagues, staff, testifiers, listening and viewing audience. September is Suicide Prevention Awareness Month. Let us take time to raise awareness and normalize seeking help. Madam Clerk, can I have? No. Madam Clerk, can I get a roll call, please? Let me some. Recognize the mic at the clerk, please.
Senator Angel Bolkes Jr. Senator Bolkes absent. Senator Dwayne M. DeGraff. Senator DeGraff present. Senator Ray Fonseca. Senator Fonseca absent. Senator Kenneth L. Gittens. Senator Gittens absent. Senator Franklin D. Johnson. Senator Johnson present. Senator Avery L. Lewis.
Present.
Senator Lewis present. Senator Clifford A. Joseph Sr.
Here.
Senator Joseph present. Mr. Chair, we have 4 present, 3 absent.
Okay, we have established a quorum and we will proceed. Madam Clerk, is there any correspondence to be read into the record?
September 4th, 2025, the Honorable Clifford A. Joseph Sr., Chairman, Committee on Homeland Security, Justice, and Public Safety. Legislature of the Virgin Islands, number 3022, Estate Golden Rock, Christiansted, VI 00820. Dear Chairman Joseph, please accept my apologies for my late arrival to the Committee on Homeland Security, Justice, and Public Safety on September 4th, 2025. Unfortunately, there were no available early morning flights to St. Croix. I appreciate your understanding under these circumstances and respectfully request that my tardiness be recorded as officially excused. Cordially, Senator Ray Fonseca, 36th Legislature of the Virgin Islands. September 4th, 2025. Good day, Chairman Joseph. I hope this message finds you well. I respectfully write to request to be excused from today's hearing of the Committee on Homeland Security, Justice, and Public Safety due to pressing personal matters that require my attention. I note the importance of today's meeting, and in line with standard protocol, I kindly request that all materials from today's hearing that were not previously shared on the Legislative Committee's drive be made available to my office. I will review them and follow up whenever necessary. I apologize for any inconvenience my absence may have caused. Thank you for your understanding, and I wish you an efficient and productive hearing. Kind regards, Kenneth L. Gittens, Senator.
Okay, Madam Clerk, you could record Senator Gittens as excused and Senator Fonseca as tardy. Committee on Homeland Security, Justice, and Public Safety will take a 2-minute recess.
The Committee on Homeland Security, Justice, and Public Safety is back in the record. Madam Clerk, can you please read today's agenda into the record?
The 36th Legislature's Committee on Homeland Security, Justice, and Public Safety will meet on Thursday, September 4th, 2025 at 10 a.m. in the Frits Lawaetz Conference Room on St. Croix, U.S. Virgin Islands. Block 1, 10 a.m. to 12:30 p.m. Bill number 36-0144, an act amending Title 14, Virgin Islands Code, Chapter 113, to define and prohibit assault rifles, ban suppressors and silencers, and requiring safety training for licensed rifles and shotgun holders, prohibiting large capacity magazines, and preventing the illegal sales of firearms, firearm accessories, and ammunition. Sponsored by Senator Clifford A. Joseph Sr. Invited testifiers: Honorable Mario Brooks, Commissioner, VI Police Department. Honorable Gordon Rhea, Esquire, Attorney General of the Virgin Islands Department of Justice. Mr. Antonio Emanuel, Director, Office of Gun Violence Prevention, Office of the Governor. Bill number 36-0105, an act amending Title 7, Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta-6 THC, Delta-8 THC, and Delta-10 THC products in the Virgin Islands and for other related purposes. Sponsored by Senator Clifford A. Joseph Sr. Invited testifiers: Honorable Mario Brooks, Commissioner, VI Police Department. Honorable Gordon Rhea, Attorney General of the Virgin Islands, VI Department of Justice. Honorable Justa Tita Encarnacion, Commissioner, VI Department of Health. Honorable Louis E. Peterson, PhD, Commissioner, VI Department of Agriculture. Honorable H. Natalie Hodge, Commissioner, VI Department of Licensing and Consumer Affairs. Ms. Joanne Moorhead, Executive Director, VI Office of Cannabis Regulation. Ms. Reese Richards, Chair, VI Industrial Hemp Commission. Deputy Commissioner, VI Department of Agriculture. Mr. Dwayne Howell, Executive Director, Arch Institute. Lunch break, 12:30 p.m. to 1 p.m. Block 2, 1 p.m. to 3:30 p.m. Bill number 36-0123, an act amending Title 20, Virgin Islands Code, Part 2, Chapter 43, Subchapter 1, Section 493, making it unlawful for a person who has more than 0.04% or more by weight of alcohol in his blood to operate a commercial motor vehicle, and making it unlawful for a person under the age of 21 years who has any detectable amount of alcohol in his blood to operate a motor vehicle. Sponsored by Senator Ray Fonseca. Invited testifiers: Honorable Mario M. Brooks, Commissioner, VI Police Department. Honorable Gordon Rhea, Esquire, VI Attorney General, VI Department of Justice. Ms. Julie Smith Todman, Esquire, Chief Public Defender, VI Office of the Public Defender. Bill number 36-0136, an act amending Title 23, Virgin Islands Code, Chapter 17, Subchapter 2, by adding new sections 1331 through 1336, mandating lethal weapon training for security guards and investigators. Sponsored by Senator Avery L. Lewis. Invited testifiers: Honorable Mario M. Brooks, Commissioner, VI Police Department. Honorable Gordon Rhea, VI Attorney General, VI Department of Justice. Mr. Gleston E. McIntosh, Executive Director, VI Peace Officer Standards and Training. That concludes the reading of the agenda, Mr. Chair.
Thank you, Madam Clerk. Again, good morning to the people of the Virgin Islands. We have a full agenda today. As it pertains to, no, Madam Clerk, do we have any correspondence to be read into the record?
No, Mr. Chair.
Thank you. As it pertains to Bill number 36-0144, an act amending Title 14 Virgin Islands Code, Chapter 113, to define and prohibit assault rifle, ban suppressors and silencers, and requiring safety training for licensed rifles and shotgun holders, prohibiting large capacity magazines, and preventing the illegal sales of firearms, firearm accessories, and ammunition. Who speaks to this bill?
Aye, Mr. Chair.
Senator Clifford Joseph, Senior, you may proceed.
Colleagues, I rise to offer Bill number 36-0144, an act amending Title 14, Virgin Islands Code, Chapter 113, to define and prohibit assault rifles, ban suppressors and silencers, and requiring safety training for licensed rifles and shotgun holders, prohibiting large capacity magazines and preventing the illegal sales of firearms, fire accessory, and ammunition. Colleagues, I want to make clear from the jump, this bill is not intended to infringe on the Second Amendment rights afforded to our citizens. What this bill seeks to do is to prohibit weapons of war from our streets and prevent suppressors and silencers from being used by civilians. I also want to make it clear that I am a licensed and responsible gun owner, and as such, I want to make sure our community remains safe and that those intending to do harm will not have access to machinery that can damage so many so quickly. The continued availability of assault weapons in our community poses a serious threat to public safety. These military-style firearms are designed for rapid fire, maximum damage. They were not designed for hunting, sports, or self-defense. In the United States, they're used in countless mass shootings as left families shattered, communities grieving, and the country reeling for repeated tragedy. Despite the number of shootings in the territory, we have been spared. Shootings with these weapons and with the approval of Bill number 360144, we can attempt to ensure that this remains the case. Bill number 360144 is straightforward, and in Section 1 creates a definition so that the police department and the Attorney General office will have the clarity on what is lawful. It also provides clear definitions for the public. At the appropriate time, I will be offering an amendment that makes clear in Section 1 what firearms can be licensed for concealed carry. They can still be licensed for home protection, but you cannot have them licensed as a concealed carry. The amendment also makes clear BIPD can offer just compensation to a person surrendering firearm. That too I'm going to remove. There is an error on page 5 of the bill, and it says no, and it should have said just. Section 2 of the bill defines large capacity ammunition magazines, set forth penalties for processing, importing, carrying large capacity ammunition magazines, and creating exemption for large capacity ammunition magazines. Colleagues, after further meeting and discussions, it became clear that this section needs additional work. And at the appropriate time, the amendment will be offered to include language to exempt certain groups, such as the military, police officers, from this section. Make clear that the penalties for violation, which is consistent with the current code, and set timelines for promulgation of regulation by the BIPD. Section 3 of this bill restates and reinforces current laws that requires a safety training requirement and makes clear from whom fire accessory and ammunition can be purchased from. This is necessary so we can track sales and aid our BIPD in performing their duties. Colleagues, I ask for your support of Bill number 360144 and the amendment that will be offered to address some concerns raised by a very small group of individuals. As a licensed and responsible gun owner, I maintain that no civilian needs access to firearms capability of firing dozens of rounds in a matter of moments. And no civilian needs access to gun suppressors and silencers. For the record, there are 8 states and the District of Columbia have banned the licensure of assault rifles. They cannot even have them for home protection. Bill number 360144 only prohibits the concealed carry of the weapons. Further, in the other 42 states that only assault rifles, with the exception of 2 states, they are only to be used for hunting. So Bill number 36-0144 is not a novel, but bans or disallowances exist. Banning assault rifles is not about taking away the rights of and responsibility of gun owners. It is about making responsible, life-saving choices to protect the public. Just as we regulate access to dangerous substances, we must apply the same logic to firearms that poses danger to our community. Opponents will argue that disallowing them to be able to conceal carry assault rifles or to own gun suppressors or silencers infringe on their Second Amendment rights to bear arms. And that focuses on banning specific types of weapons is ineffective, as criminals will find other ways to commit violence. To that I will say, while that may be the case, I can live with knowing that I tried to stop access to weapons of war from being accessible, to ban actors trained to bring harm to people who granted me the opportunity to represent them and their families. And we can and are respecting the Second Amendment rights, but we also recognize that our community has fundamental rights to live free from gun violence. So colleagues, I'm looking forward for your support of Bill number 36-0144. Thank you, Mr. Chair.
Thank you, Senator Clifford A. Joseph Sr. for that. Colleagues, we're going to go straight into testimony. We're going to do a mic check. We're going to start with the Attorney General and work our way to the right, which is their left. Attorney General, put your name and position on the record and where you represent.
Yes, good morning. Gordon Ray, Attorney General. And good morning, Chairman Clifford Joseph, Committee on Homeland Security.
Wait, hold on. That's a mic check.
Just a mic check.
Yeah.
It's working.
Good. As Casey.
Good morning, Mr. Chair and distinguished guests. Sean Santos, Senior Assistant Commissioner, Virgin Islands Police Department.
Good.
Good morning, Antonio Emanuel, Executive Director of Gun Violence Prevention.
Thank you. St. Thomas, if my vision serves me well, I see Detective Velasquez, if I'm mistaken.
Yes, good morning, Mr. Chair. Good morning, Senators on St. Croix.
No,
Richard
Detective, put your full name and position on the record.
Richard Velasquez, Police Officer, Virgin Islands Police Department, assigned to the Firearms Bureau.
Great. Next person next to you.
Sir, good morning. Thank you. My name is Timothy Perry. I serve as Criminal Chief at the Virgin Islands Department of Justice.
Next person.
Good morning, Chief Deputy Attorney General Ian Clement, Virgin Islands Department of Justice.
Say that one more time.
Chief Deputy Attorney General Ian Clement, Virgin Islands Department of Justice.
All right, next.
Good morning, Rhea Richards, Deputy Commissioner, Department of Agriculture and Chairperson for the Hemp Commission.
Good. Thank you very much for that. I think we'll begin with the testimonies. AC Santos, are you prepared to give your testimony?
I am, sir.
You may proceed.
Thank you. Mr. Chairman, distinguished members of the Senate, thank you for the opportunity to testify today in this matter. I am Sean A. Santos Sr., the Assistant Commissioner of Police for the Virgin Islands Police Department. On behalf of Commissioner Mario Brooks, we submit this testimony in support of Bill number 36-0144, an act amending Title 14, Virgin Islands Code, Chapter 113, to define and prohibit assault rifles, ban suppressors and silencers, and requiring safety training for licensed rifles and shotgun holders, prohibiting large capacity magazines, and preventing the illegal sales of firearms, firearms accessories, and ammunition. On behalf of the Virgin Islands Police Department, thank you for the opportunity to testify in support of Bill number 36-0144, an act amending Title 14 VIC Chapter 113 to define and prohibit assault rifles, ban suppressors, silencers, require safety training for licensed rifle and shotgun holders, and prohibit large magazines, and to prevent the illegal sales of firearms accessories and constitutional irregularity, urgently needed public safety reform. Gun violence continues to exact a heavy toll on families across the territory and the nation. According to the Gun Violence Archive, as of August 19 of 2025, the United States recorded 9,504 gun deaths with 17,338 gun injuries and 276 mass shootings year to date. Real-time statistics that underscore the continued crisis and the need for comprehensive prevention strategies like those in Bill number 36-0144. Locally to date, the U.S. Virgin Islands has reported 24 gun-related deaths, 11 on the island of St. Croix, 11 on the island of St. Thomas, 2 on the island of St. John. VIPD supports this bill because of it fits squarely within Supreme Court's Second Amendment framework and is reinforced by the recent appellate decisions. The Supreme Court has long recognized the Second Amendment protects firearms in common use for lawful purposes, while allowing restrictions on dangerous and unusual weapons. Post-Bruin, federal courts has continued to uphold limits on weapons and accessories that pose exceptional public risks. In 2024, the Supreme Court in the United States versus Rahimi upheld the federal prohibition on firearm possession by those subject to qualifying domestic violence restraining orders, emphasizing that the government may disarm individuals or regulate arms consistent with the nation's historical tradition of preventing dangerous conduct. Rahimi confirms that evidence based on public safety measures remain constitutional when grounded in that tradition. In 2024, the Fourth Circuit upheld Maryland's assault weapons law in Biachi versus Brown, concluding these military-style rifles falls outside Second Amendment protection, and alternatively, the law aligns with the historical tradition of regulating excessively dangerous arms. In June of 2025, the Supreme Court declined to review the Maryland decision, leaving it in place. These rulings strongly support this bill. Large capacity magazine restrictions. In March of 2025, the Ninth Circuit upheld California's large capacity magazine ban in Duncan versus Bonta, finding it consistent with historical traditions of regulating particularly dangerous weapon features. The Seventh Circuit has likewise allowed Illinois' statewide automatic weapons large capacity magazine law to remain in effect during litigation. Together, these cases confirm that large capacity magazine prohibitions comport with brewing. Suppressors, silencers are not protected arms. In February of 2025, the Fifth Circuit held that suppressors are not arms covered by the Second Amendment, upholding a conviction for possessing an unregistered suppressor. Other courts have taken the same view on this bill. Suppressors' ban is therefore on firm constitutional footing. In March of 2025, the Supreme Court confirmed that certain weapons parts, kits, qualify as firearms under the Gun Control Act, allowing serialization, licensing, and background check requirements to reach modern pathways of illegal diversion. Provisions in this bill aimed at curbing unlawful sales and trafficking are consistent with this ruling. How does this bill advance public safety while respecting the Second Amendment? Defining and prohibiting assault rifles. By focusing on weapons and features designed for rapid, high casualty potential traits repeatedly recognized by courts as beyond the core of self-defense, this bill targets excessively dangerous arms while leaving intact access to commonly used firearms for lawful purpose. While we understand the intent to address potential risks associated with these types of firearms, we believe that the outright prohibition as outlined in this bill may be overly broad and could negatively impact law-abiding citizens who utilize these firearms for legitimate purposes. Specifically, we propose that instead of prohibiting the firearms defined in Section A of the bill, we consider restricting their possession and the use to the following. A, home protection. Allow the possession of the firearms within the owner's private residence for the express purpose of self-defense and the protection of their families and properties. B, target practice. Permit the use of the firearms at licensed shooting ranges and facilities for target practice and training purposes. This approach would require the following adjustments to the bill. Amend Section 3, prohibitions and penalties. Modify the language to reflect that the manufacturer, sale, offer to sell, transfer, or purchase of these firearms is restricted to specific permitted purposes such as home protection and target practice, rather than entirely prohibited. Repeal Section 4, mandatory surrender. Eliminate the mandatory surrender provision as it would no longer be necessary if the possession is permitted under the specific restrictions. Add definitions and regulations. Include clear definitions for home protection and licensed shooting range. And establish regulations for safe storage, transportation, and use of firearms within the permitted context. This may include requirements for safety training, background checks, and registration. Consider stricter penalties for misuse. Increase penalties for the misuse of the firearms and criminal activities or for violating the restrictions outlined in the law. By adopting this restricted approach, we can achieve a balance between addressing public safety concerns and respecting the rights of responsible gun owners. This approach allows for the legitimate use of these firearms for self-defense and recreational purposes while implementing safeguards to prevent their misuse. Banning suppressors and silencers. Suppressors complicate law enforcement response, crime detection, and runs counterproductive to our current gunfire detection capabilities. Multiple appellate decisions find they are not constitutionally protected arms, supporting a categorical prohibition. Requiring safety training for licensed rifle and shotgun holders. Training prerequisites are long-standing. Common sense safety measures that courts have repeatedly treated as compatible with the Second Amendment text and history approach. Rahimi reinforces the legitimacy of measures designed to prevent dangerous misuse. prohibiting large capacity magazines. Large capacity magazines enable sustained fire that magnifies lethality. Appellate precedent upholding large capacity magazines ban support this provision as consistent with history and tradition. Preventing illegal sales and trafficking of firearms, accessories, and ammunition by tightening controls on parts, accessories, and sales channels. The bill addresses diversion and trafficking pathways, an approach validated by the Supreme Court's treatment of parts and kits. The Supreme Court in June of 2025 denial of review in challenges to Maryland's assault rifle ban, Rhode Island's large capacity magazine ban leaves the laws intact and signals that such targeted regulations can coexist with the Second Amendment. Courts continue to uphold measures aimed at reducing lethality and protecting the victims, most recently with decisions sustaining large capacity magazine restrictions and the appellate rulings confirming suppressors fall outside the Second Amendment coverage. In conclusion, Bill number 36-0144 is a careful constitutional public safety measure. It mirrors approaches that federal appellate courts have upheld post-Bruin, and it directly addresses the tools that drive lethality in shootings, military-style rifles, large capacity magazines, and suppressors, while promoting responsible gun ownership through safety training and curbing illegal sales. For these reasons, the VIPD urges the committee to support this bill. We stand ready to assist with the implementation, public education, and enforcement to ensure that law delivers the intent safety benefits while respecting the rights of law-abiding citizens. Thank you.
Thank you, Assistant Commissioner Santos. Only you giving testimony today, right?
Yes, sir.
Okay, thank you. Attorney General Rhea?
Yes, sir.
You may proceed.
Good morning, Chairman Clifford Joseph.
Hold 1 second, Attorney General. I'd like to recognize the presence of non-committee members, Senator Novelli Francis Jr. and Senator Maurice C. James. Good morning, colleagues. You may proceed, Attorney
Thank
General.
you, sir. Good morning, Chairman Clifford Joseph, Committee on Homeland Security, Justice, and Public Safety members, other senators, legislative staff, and the listening and viewing audiences. I'm Attorney General Gordon Rhea, and joining me from St. Thomas is Timothy Perry, Chief of the Virgin Islands Department of Justice's Criminal Division. It's an honor and privilege to appear before you this morning. The Department of Justice appreciates the opportunity to comment on Bill number 36-0144. The Department of Justice has completed a preliminary review of the bill and offers the following comments. The stated purpose of the bill is to amend Title 14 of the Virgin Islands Code, Chapter 113, to define and prohibit assault rifles, ban suppressors and silencers, and requiring safety training for licensed rifles and shotgun holders, prohibiting large capacity magazines, and preventing the illegal sale of firearms, firearm accessories, and ammunition. Pursuant to Title III of the Virgin Islands Code, Section 114, it's the duty of the Attorney General to prosecute, in the name of the people of the Virgin Islands, offenses against the laws of the Virgin Islands. Today, within the territory, approximately 1/5, or 1 out of every 5 arrests in the Virgin Islands, involves guns. Tragically, firearms are used during crimes of violence to intimidate, to harm, to kill. Firearms are not manufactured in the Virgin Islands, meaning each and every gun in the territory entered either legally through the licensing process, which is overseen by the Commissioner of Police and the Firearms Bureau, or illegally smuggled into the territory. Respectfully, we join with the Virgin Islands Police Department in supporting this bill. We commend the Legislature for continuing to provide law enforcement with the tools necessary to identify and criminalize the most dangerous manifestation of illegal weapons in the territory. Historically, there are certain rights that are sacred in the United States and enshrined in the Constitution and the Bill of Rights. For example, the First Amendment, the right to free speech. The Second Amendment, the right to bear arms. The Fourth Amendment, the right to be free from illegal search and seizure. However, consistent with public safety, there are certain limitations on each of these rights. For example, the First Amendment guarantees the rights to free speech. Americans can believe what they wish and say what they want. However, there are limits to this freedom to protect the community. While a person has the right to free speech, it's illegal to use that speech to start a riot, to disturb the peace, or to harass another. And similarly, the Second Amendment speaks to the right to bear arms. This is not, however, an unfettered right. An individual has the right to bear arms for self-defense. At the same time, a community has legal authority under the Constitution to protect itself. We see this intersection occur often when laws passed by other states to protect the community are challenged by individuals in court and ultimately upheld or struck down. For instance, recently, in New York State Rifle and Pistol Association versus Bruin, the U.S. Supreme Court struck down the New York State's concealed carry law. The Supreme Court held that the, quote, proper cause, end quote, provision was unconstitutional because it interfered with the Second Amendment right to bear arms. And yet, 2 years later, in 2024, the United States versus Rahimi, the same U.S. Supreme Court upheld the state's right to prohibit the possession of firearms by individuals subject to a domestic violence restraining order. In short, the Supreme Court precedent establishes that a state cannot, through discretionary factors, limit one's rights to bear arms. It does not mean that any citizen is free to possess any kind of firearm anywhere for any purpose. These are the words of the justices of the Supreme Court. In Bruin, Justice Kavanaugh emphasized that, quote, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense, end quote. Bruin. Justice Alito, joining the majority in Bruin, noted that the holding in Bruin does not invalidate laws regulating who may lawfully possess a firearm. Quote, we have not disturbed anything that we held in Heller or McDonnell about restrictions that may be imposed on the possession of carrying of guns. In McDonnell, the case that was just referenced, the Supreme Court held that the right to keep and bear arms is, quote, not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. We made it clear in Heller that our holding did not cast doubt on such long-standing regulatory measures as prohibitions on the possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. The regulation of firearms in America can be controversial. The role of the Department of Justice is to enforce the law as passed by this body. The department is not equipped to speak to the hyper-technical elements of this bill, including what is or is not a military-grade accessory, what is or is not a tactical pistol, or what constitutes a rifle caliber cartridge. This will also be the case if asked to prosecute these matters, as we rely on our colleagues and firearms experts at Virgin Islands Police Department to identify and define these elements. I do wish, however, to spend the balance of this testimony in strong support of the provision of this bill that should not be controversial, the addition of Section 2259 to Title 14 of the Virgin Islands Code covering the prohibition of large-capacity magazines. This provision of Bill number 36-0144 has a long history. The proposed law is based on what we were seeing on the street. Increasingly, at crime scenes on St. Thomas and St. Croix, Virgin Islands Police Department is collecting 20 and sometimes 30 or more shell casings. When ShotSpotter records the discharge of 20 or 30 rounds in rapid fire, it suggests all the rounds were shot from a single magazine. These magazines are in our community now. I've attached exhibit number 1 to this testimony. It's a photograph of the multiple high-capacity magazines seized in one recent case on St. Thomas. In this photograph, and under current Virgin Islands law, the unlicensed weapon is illegal. The ammunition is illegal, but The high-capacity magazines are not. Increasingly, when making arrests for unlicensed firearms, officers see illegal guns equipped with extended or drum magazines carrying 50 to 100 rounds. To put this into perspective, our police officers carry a department-issued Glock with a 15-round magazine and 2 backup magazines on their belt for a maximum of 46 rounds. A defendant armed with such an extended magazine could outgun a Virgin Islands police officer more than 2 to 1. If a defendant's gun is equipped with a conversion clip, which this body made illegal under 14 Virgin Islands Code 2253E, one trigger pull can throw 50 to 100 rounds without a reload. In October 2024, Chief Perry and I were invited to a criminal justice roundtable on St. Croix, hosted by the Honorable Senator Gittens. The issue of large capacity magazines came up, and together we prepared a draft bill on this single issue. Much of the language in Honorable Senator Gittens' bill is reproduced in today's proposal for 14 VI Code 2259. Respectfully, the Department of Justice joins the Virgin Islands Police Department in supporting this bill. Similar laws have been passed in at least 14 states and in the District of Columbia. Limiting the size of magazines held by the public is the law of the land in New Jersey, Maryland, Delaware, New York, Vermont, Illinois, Colorado, Massachusetts, California, and Rhode Island, Washington, and the island state of Hawaii. In passing a prohibition on large capacity magazines, the territory will not be an outlier. It will be in good company, as nearly 1/3 of the United States enacted such a ban. The prohibition on large capacity magazines is a common sense law for a number of reasons. First, large capacity magazines have been used in virtually every mass shooting event in the United States. For example, in 2012 at Sandy Hook Elementary School in Newton, Connecticut, the shooter shot and killed 26 people, including 26 children between ages 6 and 7 and 6 school teachers. The shooter carried multiple 30-round extended magazines. The tragedy of incidents like this are why large capacity magazines are regulated by 30 of the states. Secondly, Virgin Islands Code 2259, as proposed, does not limit or infringe upon in any way the right to license and legally possess a firearm in the territory. 14 Virgin Islands Code 2259 does not speak to the types of weapons allowed or disallowed. It does not seek to criminalize a particular make and model of gun or caliber of ammunition. Rather, this portion of the bill limits the number of bullets a person may carry in each magazine before reloading. Note please as well, this bill does not limit the number of 10-round magazines an individual may possess. Third, the preference for a 10-round magazine is already the practice here in the Virgin Islands. The territory's firearm licensing statute, Title 23, Chapter 5 of Virgin Islands Code, vests the commissioner with the authority to promulgate rules and regulations for issuing firearms. Upon information and belief, at present, the Firearms Bureau only issues licensing coupons for firearms with magazines of 10 rounds or less. Fourth and finally, laws prohibiting the carrying of large capacity magazines have already been tested and upheld in court. 14 Virgin Islands Code 2259 is patterned on similar laws as passed in other states which have withheld and withstood judicial scrutiny. Most recently, in the case of Ocean State Tactical LLC versus Rhode Island, the plaintiff challenged Rhode Island's ban on high-capacity magazines. They argued that the 10-round limit was impermissible under the Second Amendment. The First Circuit heard that argument and rejected it. The court noted that the Rhode Island ban on large-capacity magazines was made in rational response to, quote, proliferating mass shootings across the country, end quote, and that the ban on high-capacity magazines promotes public safety because, quote, in a mass shooting incident, every pause to reject a spent magazine and load a new one represents the opportunity to preserve a specific life, or more than one, end quote. The court went on to observe that, quote, the use of more than 10 bullets in self-defense is rare, and most homeowners only use 2 or 3 rounds of ammunition in self-defense, end quote. Notably, after the First Circuit upheld Rhode Island's ban on high-capacity magazines, the plaintiffs appealed the matter to the U.S. Supreme Court, which rejected the writ of certiorari. In effect, the Supreme Court, in light of Bruin, had the opportunity to strike down a ban on high-capacity magazines and declined to do so. In conclusion, this legislature has shown itself repeatedly to be committed to increasing public safety in the Virgin Islands. This package of gun laws does exactly that, provides tools for law enforcement to help keep the community safe. We join with our partners at the Virgin Islands Police Department in support of this bill, and in particular, the provision to add 14 Virgin Islands Code 2259 to the Virgin Islands Code, the common sense prohibition on large capacity magazines. I thank the committee for allowing the Department of Justice to testify on this bill. This concludes my formal remarks. Chief Perry and I welcome any questions that you might have. Thank you.
Thank you, Attorney General Gordon Rhea. And before I go to Antonio Stevens, Director of Office of Gun Violence, not Antonio, Emanuel.
Stevens, that's right.
Emanuel, I got to fire, sorry.
I'm the other handsome guy.
Good. Yeah. Director Tony Emanuel of the Office of Gun Violence. I'd like to recognize the presence of our President, Senator Milton Potter, non-committee member. Good morning, Senator Potter. Before I go to Mr. Emanuel, AC Santos, just for clarity, I think some of the committee members are requesting if you have pictures of or examples of what we're talking on.
Yes, sir.
So let's see if we could try to retrieve them while during the time.
I have that being worked on right now.
Thank you very much. Director Emanuel, Executive Director Emanuel, you may proceed.
Good morning. Good day, Honorable Senator Clifford Joseph, Chair of the Committee on Homeland Security, Justice, and Public Safety, esteemed members of the 36th Legislature of the Virgin Islands, committee members, non-committee members present, and the listening and viewing audience. I'm Antonio Emanuel, the Executive Director of the Office of Gun Violence Prevention, and I'm here to offer testimony in support of Bill 36-0144, an act amending Title 14, Virgin Islands Code, Chapter 113 to define and prohibit assault rifles, ban suppressors and silencers, and requiring safety training for licensed fire rifles and shotgun holders, prohibiting large capacity magazine and preventing the illegal sale of firearms, firearm accessories, and ammunition. Having had experience in both the military and law enforcement, I have an appreciation for efficiently designed firearms. I understand the interest in firearms from the perspective of sporting and as an enthusiast. Many of our citizens who lawfully possess some of these weapons are not where our problem exists. They enjoy their constitutional right to bear arms and feel a degree of security of being prepared to defend their home if necessary. The age-old argument has and will always be what is the need for a citizen to own such a weapon, and another argument about carrying it in public. There can be compelling arguments on both sides. And although I fundamentally believe in and am a supporter of our Constitution and the Second Amendment, which grants us the right to bear arms, I also understand that not everyone should or need access to a firearm or certain types of firearms, and some should never have access. Citizens often ask, should I get a gun for my safety? I typically try to convince them that that is not the answer to personal safety. Concealed carry of certain weapons can be a slippery slope and risky. I have seen too many cases where people who were carrying became victims and their weapons either by their side or stolen after they were killed. Banning weapons is an understood reaction. When faced with violence, senseless homicides, and citizens living in fear of hearing gunshots from heavy artillery on a regular basis, it seems like the reasonable thing to do. If I had to take a side, I would agree doing something is better than doing nothing. Unfortunately, banning things usually pushes illegal activity further underground than it already is. I would offer careful determination of which weapons should be banned. I'm always concerned as to the availability of weapons on the street, and as more people carry, there will be more guns in our communities. The authority to carry a concealed weapon is a heavy responsibility that brings with it unforeseen threats, and granting that privilege needs scrutiny. Certain weapons and alterations of weapons are a problem, and I agree with the proposed legislation that similarly configured and altered weapons pose a distinct threat to law enforcement and the public, particularly due to the concealability, armor piercing potential, magazine capacity, compatibility with suppressors, rifle scopes, and military-grade accessories. And these weapons serve no legitimate civilian purpose for self-defense or sport and are commonly used in criminal activity. Accordingly, their possession and use present an unacceptable risk to public safety and must be prohibited. I'm in total support of the section that refers to prohibition on suppressors and silencers and certain firearm accessories and large capacity magazines. Prohibited large capacity ammunition magazine means in any magazine, belt, box, drum, tube, or similar device which can hold more than 10 rounds of ammunition. I have been a law enforcement instructor for over 30 years, which included being a tactical firearms instructor. When officers are engaged in an active shooting incident, reloading is the most vulnerable position to be in. When the assailant doesn't have to reload, they have a clear advantage over the responding officer. I will always be supportive of any legislation that helps protect our officers. Owning, possessing, even just carrying a firearm comes with incredible responsibility. And from my training perspective, I agree safety training should be required to own, possess, or carry a firearm. This section of the bill that refers to safety training requirements for possession of rifles and shotguns is an important measure that I'm in full support of. In addition, I would suggest that any renewals should require attendance to current training to ensure abilities and refreshed knowledge of the safe handling, loading, and storage of rifles, shotguns, and handguns, firearm maintenance and secure transportation, lawful use of force and applicable local firearm laws, range safety, and marksmanship fundamentals. The weapon by itself is not the problem. The problem is when the weapon gets in the hands of a person that uses it inappropriately for illegal intent or to cause harm to others. Inappropriate and illegal use of these weapons bring fear and trauma to our communities, and any effort to prevent injury and death to our citizens is a move in the right direction. I appreciate Senator Joseph presenting this bill, and I am in support of the amendments presented. Thank you for allowing me to be a part of this process.
I thank you for your testimony, Mr. Emanuel. Is he sent us off out with those visuals?
I have the forensics team about to send those pictures via email, so I could send it to whoever you need it to be sent to.
All right, so just signal me when we're ready.
Yes, sir.
For that. We'll move forward. Colleagues, again, good morning. We heard the testimony from VAPD, our Attorney General, and our Office of Gun Violence. The other testifiers are just supporting cast today. We're going to move to a 5-minute round. The order I have it this morning would be Senator Dwayne DeGraff, Senator Franklin Johnson, Senator Novell E. Francis Jr., Senator Maurice James, Senator Milton Potter, Senator Clifford Joseph, and then myself. So we're going to begin. Sorry. Avery Lewis, then Senator Joseph, since he's a sponsor. I apologize about that. First, A.C. Santos, let me ask you a question. As it pertains to, currently, as it pertains to suppressors and silencers, is there a federal ban on it?
We do know that there's court proceedings happening as we speak as far as the suppressors are concerned. We do know that there are certain states that they are banned.
But does the Virgin Islands Police Department allow you to register them or license them?
No, sir.
With your weapon?
No, sir, we don't.
So nobody comes into the VIPD currently with those?
We have had individuals come by to request to have those registered here in the territory. Those items are, you have to go through a process to get those weapons, and as far as ATF is concerned, if they get it past the border of the United States down here, they're not going to get involved with that because it's pretty much, you know, it's within the state that you purchase that weapon and you get the item, where you purchase that item, that's where it should remain. However, once it gets past those borders and it gets down here, then we have a problem.
I think the weapons of question this morning that really raise awareness or raise alarms with the VIPD is in the bill. It says a Sig Sauer. You mash up my tongue to that. Sig Sauer MCX pistol, a Daniel Defense DDM. Saw. Sorry, buddy. Sig Sauer.
Sour.
MCX pistol, the Daniel Defense DDM 4 PDW, the CCMG, Descent MK4, the Smith & Wesson M&P 15, and similarly configured weapons pose a distinct threat to law enforcement and the public. Currently, do we have any of those types of weapon license?
From my knowledge, Senator, we do, especially the Sig Sauer. I do know for a fact that we have one here in the territory.
Just one?
Just that I'm aware of.
That you're aware of?
Yes, sir.
Your team, your staff in St. Thomas?
Detective Richard Velasquez, sir.
Detective Richard Velasquez. You said he's assigned to the Firearm Bureau?
Yes, on the St. Thomas District.
Detective Velasquez, good morning.
Good morning, Senator Lewis.
To the best of your knowledge, or the best of the information you have, could you place on the record today how many of these firearms in question is registered?
To the best of my knowledge and recollection, we do have approximately two weapons of that nature that are registered in the Virgin Islands, at least in the St. Thomas, St. John, Water Island District.
Oh, media, could we didn't get to see Detective Velasquez, but we did hear his response. And the Detective Velasquez, are these weapons registered to carry or for home protection?
I can only speak of one in particular, and the one in particular that I will speak of right now is for carry.
To carry. Wow. All right, I'll open the floor to my colleagues. Senator Dwayne M. DeGraff, you're recognized for your 5 minutes. Good morning.
Thank you, Mr. Chair. Good morning, colleagues. Good morning, testifiers, all viewing, listening, and present. Well, you know, let me put a couple of things in perspective first. I am a retired Deputy Chief of Police, 26 years as a police, serving this community, serve and protect. I was a SWAT team commander, so I'm tactically trained. I spent 23 years in the military. I am a combat military veteran who spent a year in Iraq, carried firearms, a licensed firearm owner. I also sponsored the bill to ban assault rifles before, and it was held in committee. Now, one of the issues that I found out when I presented my bill was I didn't have any persons who objected to the bill. I think that's one component we need to have also, someone or the entity that objects to this bill, especially licensed firearm owners, because for me it was ban everything, ban everybody. I was happy to hear Assistant Commissioner put in that we need to take into consideration licensed firearm owners, persons who work hard, pay the taxes, go through everything, put safe, put cameras up, you know. Now, to me, the one thing, I just looked at the bill. First of all, I stand in support of the bill, but I just looked at the bill, and the bill does not define what is an assault rifle. It talks about a conversion pistol. A pistol is a handgun that you could apply a conversion kit and make it like a long rifle, like a firearm, like a rifle. So the definition of assault rifle, which is in the short title, an act amending Title 14 Verna's Code, Chapter 113, to define and prohibit assault rifles. In the bill defines and speaks about conversion pistols. Is a conversion pistol considered an assault rifle, Commissioner? Assistant.
Assistant Commissioner Santos, no, sir, but if you would allow me to explain. So the Sig Sauer that was spoken about uses a 300 blackout round, which is a rifle round. It is
excuse me, one with all due respect. Let's keep it where the average person, licensed firearm owner, person on the street could understand. We're going to talk about a 300 round, a 223, a 5.56. People don't understand that jargon. It is professional, no disrespect, but let's have where we can talk it plain, because the conversion weapon that you're speaking of, a rifle is legal in the territory.
Yes.
A pistol is legal in the territory.
Yes.
With a conversion kit, is a pistol illegal?
So that's what I wanted to get to.
Yes or no?
It is.
It is not.
Well, let me explain, Senator.
No, wait. That's what I'm saying. So in other words, what we putting it out into law, you're not trying to convince somebody who is against the bill. We're trying to put it out where a pistol is not illegal, and we're trying to address certain conversions and stuff, but it is not an assault rifle. Two separate animals.
Sir.
Okay, your turn now.
I appreciate you. Thank you.
Go ahead.
There is a rifle, sir. We're going to speak plainly, as you said. There is a rifle there is a pistol. It's classified as a pistol. If you look at it, you would think it's a rifle. You see it as a rifle. The only thing it's missing is what's called a buttstock, which you know, which you would apply to the shoulder to assist you in firing that particular pistol. Without the buttstock, again, it appears to be a pistol. I just sent the pictures so that it could come up on the screen so you could see it. But it appears to be a rifle, sir. But without that buttstock, it's considered a pistol. So to you and I who know that it uses a rifle round or rifle ammunition, it's a rifle. It's a pistol utilizing a rifle round, but it's just that the ATF classified that one particular firearm or make of that. They consider it to be a pistol, sir. But alternatively, once you put a buttstock on it, or if you put a rifle brace on it, it's a rifle. It's an SBR.
Okay, so just in closing, then Attorney General, then should we define what an assault rifle is?
I think the definition would be important, right? Otherwise, we would get the kind of confusion that, or disagreement or misunderstanding that it appears we're getting here. So, yes, I think a clear definition ought to be in the statute.
Okay. All right. Thank you for the time, Mr. Chair.
Thank you, Senator DeGraff. Is Santos, does media have the...
I sent a couple, sir. A couple of pictures.
All right. The Committee on Homeland Security and Justice stands in recess for 2 minutes. Committee on Homeland Security, Justice, and Public Safety is back on the record. Media, could you please show the slides of what we have in? And AC Santos, will you pull a mic closer to you to illustrate what's going on after today, please?
So, Senator, based on the image that you see here, it may appear to be a bit shorter, but it's a high-capacity magazine for a handgun. If we could show the next slide, please. This magazine here that you see is a double drum magazine. A magazine of this caliber here would hold anywhere between a 5.56 or 7.62, but this could hold up to 100 rounds. So this magazine that you see right here is a high-capacity magazine that holds way more than 10 rounds. That magazine could hold anywhere up to 30 rounds of a 9mm ammunition. So these are some of the magazines that we've been talking about. Whereas law enforcement may carry up to 15 to 17 rounds, this magazine holds up to 30 rounds total. And that's the other side angle of the magazine. That's how long the magazines get, and that's for a handgun. This is the pistol style 300 6-hour that we were speaking about, that we mentioned. And for a pistol of this caliber, it uses rifle rounds, but it's classified as a pistol. Now, the minute you go and you place a arm brace on this weapon, pretty much you converting it into a shoulder-fired rifle, into a weapon. Right? And they're saying that, oh, well, we put a pistol brace, it's legal, I ain't gonna shoulder fire. No, you're gonna shoulder fire that thing. And I'm just speaking from my knowledge for over 2 decades of handling firearms. You're gonna shoulder fire that thing. And so they want to be able to carry this, and all we're saying, Senator, is that we're trying to alleviate that. But if you're purchasing weapons of this nature that uses rifle rounds, even though it's classified as a pistol, we would love to just register these as only home protection and target practice, and that's that. And we could do it by the definitions, where we could define it based on the barrel length, and also by handgun, sir, because if it's clearly defined that a handgun and pistol, due to the fact that you have now these type of weapons here classified as pistols, they're definitely not classified as handguns. So that could also assist us in the definitions between pistols and handguns.
That's it?
Yes, Senator.
All right, before I go to Senator Franklin Johnson, let me ask Detective Velasquez.
Detective Velasquez, yes, Senator.
Question, based on what the weapon you just saw on the screen and the illustration that the Assistant Commissioner gave, if we was to pass this measure and go in that direction, what would it do to like those like AR-15s and things that already registered?
Senator, good morning again. Thank you for the question. It would do nothing, sir, because AR-15s, if we're talking about an AR-15 platform rifle, that in and of itself would have a barrel of 16 inches or longer and would be considered a rifle under Virgin Islands law. And the weapon that was shown by Assistant Commissioner Santos is a pistol as defined by ATF and currently under Virgin Islands law because it has a barrel length of under 12 inches. Now, Assistant Commissioner Santos, again, is very much correct that that pistol is shooting a rifle cartridge. And taking something away from Senator DeGrasse, speaking plainly, that projectile, not the entire bullet, not the entire cartridge, the projectile is what is considered a .30 caliber round. That was the most prolific round used from, I'd say, World War II, Korean conflict into the Vietnam War. That round in and of itself has a great lethality rate.
Okay.
And more importantly, when coming out of that type of firearm, it would cause extreme prejudice to anyone that is being fired at or anyone in that immediate area.
Thank you for your response. Senator Franklin Johnson, you're recognized for your 5 minutes.
Good morning. Thank you very much, Mr. Chair. Good morning to my colleagues. Well, it's afternoon. Good afternoon to all my colleagues, testifiers. I want to start off with Detective Velasquez. The rounds that this weapon is discharging right now, is it an armor-piercing round? And if it is, what does that mean in layman terms to your law enforcement officers who has a vest on?
Good afternoon, Senator Johnson. Again, thank you for the question. Armor piercing. Armor piercing is a very tricky type of comment. If you look at it from a military standpoint, armor piercing would delineate a round that could actually pierce an inch of, let's say, steel or armored up vehicle. And as it relates to law enforcement, all law enforcement officers wear a certain level of body armor. Right now, that round would penetrate that body armor.
Thank you for that, and I want to make sure I repeat what you just said. A weapon like that in the hands on the street will cause destruction to our law enforcement officer with their vests on. Am I correct?
Very much so, Senator.
Thank you very much for that information there. And I went to that because in Director Emanuel, in your testimony, Director Emanuel, you spoke about armor piercing, and you talk about when officers are engaged in active shooting incident, reloading is the most vulnerable position. And some of the barrels that was just displayed, are these the type of barrels and stuff you're talking about which will become such a difficult time for law enforcement officers?
Not the barrel, but the magazine capacity. When you have to take cover and do a tactical reload where you're empty and now you got to reload, and the person that you're in the gunfight with is still shooting down range at you, you're at a clear disadvantage, and that's where the fear is with our officers that have to get involved in somebody that has a weapon like that, especially if it's sending rifle rounds down your way. You're outgunned.
That question also goes to AC Santos. Right now, as we speak, our law enforcement officers coming up against a piece of equipment like this, what are their chances to be able to say that they could seduce this person, get this under control, especially with these type of magazine? How much magazine the average officer weapon carries?
I could tell you right now, just the regular officer on the field, Senator, would only carry about 45 rounds.
How much in each magazine?
15.
15?
Yes, sir.
Some of those, the barrel that you showed me carry yourself to 100?
Yes, sir. The magazines will carry up to 100 rounds on one magazine.
And that 6 hour, what size magazine and how many rounds will that be able to carry?
30.
In one magazine?
Yes, sir.
And your officer's magazine carry 15 rounds?
Right. One of a standard officer would carry that amount.
Now, let's say this person get his license for this piece of heavy machine there. How does that individual carry it on his person?
The only way to conceal carry that, Senator, would be in a bag.
So it's impossible for him to put it on his waist and have it, because it's supposed to be concealed while it's carrying.
Yes, sir.
Anybody that have a licensed firearm for carrying protection, they're not supposed to be brandishing a weapon.
That is correct.
Supposed to not be seen by the average person out there.
That is correct.
Does he do that with this particular weapon?
The only way you'll be able to do that, Senator, is with a bag, and of course, with a shoulder strap as well. But you know, the only way to conceal it is with a bag.
Now, I want to ask this question: if you know, how many certified instructors and approved safety course exists today in the territory? Like, how many people? How many instructors do we have? I'm asking this question because a couple parts of the bill talking about folks being trained, being licensed, and stuff like that. Is there any situation where there won't be enough firearm instructor to certify folks in the territory?
We do have territorially, we have several firearm instructors, business-wise, here in the territory. We may need more because it is important to have some sort of training when you are dealing with such firearms. Just off of experience, sir, again, I've been, you know, a couple of decades in policing, but also have over 14 years in the tactical world doing warrants. And not all, we have those type of weaponry, but in not all situations we can use it because of the backstop. So if we're going into a wooden structure, we would not be carrying those type of weaponry because we have to be mindful of the backstop of that round just in case of an officer miss. So that is something that the regular citizen has to be aware of when carrying these type of weaponry, because their thing is, yes, we do understand you want to protect yourself, but you also have to protect the innocent other individuals who are around you, and those rounds could travel, sir.
And you're speaking about the round that's in the 6 hour. He was supposed to try to protect himself. He could end up hurting a lot of people in the
That is correct, Senator. That is correct, Senator.
Thank you very much, Mr. Chair, for your leniency.
Thank you, Senator Franklin Johnson. Attorney General Rhea, as it pertains to we heard about the extended magazines and the drums and everything. If that was to be banned today, you cited a lot of different things, Hella and McDonald and Bruin and everybody. But now in Rhea land, would it be violating anyone's constitutional rights? If that's banned.
Yeah, no, my judgment is no. But I've also asked my criminal chief, Timothy Perry, to be here, and if he could address that issue. He deals with this all the time on virtually on a daily basis. I think he's in a good position to answer that.
Attorney Perry?
Yes, Senator. Good afternoon. Timothy Perry, Criminal Chief, St. Thomas, St. John. Yes, your instincts are right. There is a constitutional provision against unconstitutional or unlawful takings. But I believe this bill tries to counteract that because it provides opportunity for those magazines to be purchased, to be transported off island and sold, or ultimately be collected by the police department. So I think the bill addresses that, at least with respect to magazines.
All right, thank you.
But yes, they have to build in a window so someone who has a magazine that is now illegal in the Virgin Islands, you'd have the opportunity to sell that or transport that off island.
The magazine?
Correct. And the same would apply to firearms. I believe in the other part of the bill, with respect to firearms, there's an opportunity to go through a licensed firearms dealer and then transfer the weapon off island for compensation. The idea being that there wouldn't be an unlawful taking of someone's property.
All right, so AC Santos, before I go to Senator Novelli Francis Jr., one quick question for you. And maybe you may not have it, but Detective Velasquez. In layman terms here today, we're not saying that your firearm, what you currently have, I'm talking about like the Glock 27 and whatever they have. We're just saying we want to limit it to a 10-round magazine.
That is correct, Senator.
Currently, you know, if my memory serves me correct, when you go to firearms, that is a standard, not you don't issue weapon, but that is a standard requirement to have a 10-round magazine. If someone is found today, as we speak, with a 14-round or a 22-round, can the department take any action with that?
We've addressed that through especially at our airport, Senator. We have had individuals come into the territory with magazines exceeding over 10 rounds, and those have been confiscated.
Good. But I'm
they
asking
do have
you,
an option.
if you leave from this building today, you meet John Doe out there with his Glock 27 or whatever it is, and he has a 15 round, what is the consequences to him? Is that a arrestable offense or misdemeanor?
They will be confiscated, Senator. The ammunition will be given back to them, and it will be confiscated. And they do have the opportunity to come back and have it shipped out of the territory.
Thank you. Senator Novel E. Francis Jr., you're recognized for your 5 minutes. 1 second, Senator Francis Jr. I'd like to acknowledge the Vice Chair of this committee, Senator Rhea Fonseca. Good morning. Senator Francis Jr., you may proceed.
Thank you very much, Mr. Chair. Good afternoon to you, to the testifiers, those in the audience, and to the people of the Virgin Islands as well. We're back here. We've had this discussion before in respect to the banning, prohibition, restricting, whatever term you want to use to really just talk about the restriction that's being placed on assault rifle. And I think that when we continue to have this discussion is as a result of some of the actions that we're seeing in our community that's causing us to really continue to ensure from this body's perspective is that we're giving law enforcement the tools to be able to effectively and efficiently carry out the tasks and mandates of enforcing laws in our community and protecting this community against with public safety in mind. So I wanted to hone in a little bit because first of all, I appreciate your testimony, Assistant Commissioner Sean Santos, and your suggestion that we perhaps need to have a more balanced approach. I think is a term that you may have used or insinuated, and I think that speaks well to what we're trying to do here in this conversation. What is the weapon of choice right now by the street currently?
Carbine rifle. Any type of carbine rifle or AK-47 style rifle. Rifles are pretty much the common used.
AK-47, capable of firing 600 rounds from 300 meters. That's almost 1,000 feet away. Capable of killing, maiming hundreds of people at any given time. You know that, well, the street called it a chopper.
Yes, sir.
Right?
Yep.
I've been off the street for a little while. And they're selling for about $5,000-6,000 on the street.
That is correct.
How often are we seeing and responding to calls where choppers are used, AK-47 rounds?
It's been commonly used out there. I would say we've been having an uptick of more 5.56 type ammunition shell cases we've been collecting off the street as well. And a lot of it is due to gun parts being sent via the mail, these weapons being built here within our territory and then sold on the streets. And so now commonly we've been seeing a lot of the M4 style rifles, ghost gun types being picked up.
We are so lucky in this community. AK-47 capable of firing 600 rounds per minute. And we're commonly finding these type of weapons in our streets.
Yes, sir.
We're so lucky.
Yes, sir.
Because we could be responding to scenes where there's multiple bodies that we're picking up. Individuals within their vehicles, individuals within their homes. So that's the magnitude of the situation that we're facing here today. So while we're toying with definitions and things, I think that is important that we really come together to really understand the magnitude of the situation and make sure that we put it in place. Again, giving law enforcement and this community some level of protection there in that respect. Attorney General Rhea, I wanted to ask you, in terms of your research, is there a federal ban on assault rifles?
Again, could I have Chief Perry respond to that because he knows these in detail?
Chief Perry?
Thank you, sir. Good morning, or good morning again from St. Thomas. There was a federal ban for about 10 years, and actually it was backed by President Bush President Reagan, actually, and it was signed by President Bill Clinton. And my understanding is the ban had a sunset, and it was allowed to expire, and it was never renewed. But I also believe, and I cannot quote statistics, but it also showed that during that time, there was a decrease in the level of violence in the country related to high-power weapons. So there was a ban. At present, there are 11 states in the District of Columbia that have bans. There is no federal ban at this time that I'm aware of.
Okay, was that part of the Baker's Law back then?
Say it again, sir.
Baker's? That was Baker's Law? That had anything to do with Baker's Law?
Sir, I believe it was part of the Brady Bill.
The Brady Bill. Okay, Brady. Real quickly before my time get called. Well, assault weapon. We keep talking about assault weapon, assault firearms, assault rifles. Can you give me the type of weapons that you look at in terms of assault weapons? I think I asked this question before. I know you just spoke about the AK-47. What other weapons do you consider assault firearms?
Good question, Senator. The majority of it, and you know, I'm a big Second Amendment guy. I just gotta put it out there. But when we speak about assault weapons, it's just more of a media push narrative to say that it's an assault weapon, because you could assault somebody with a knife as well. So do we call it an assault knife? But I would say definitively, Senator, that the majority of time is any sort of rifle that can fire multiple rounds within a short period of time.
Mr. Chair, if I may just wrap up.
Go ahead, Senator.
So a semi-automatic weapon.
Yes, sir.
Is that considered assault?
No,
weapon?
sir. And it could be, however, it can be converted.
Is a fully automatic weapon considered assault rifle?
Yes, Senator.
Is a M16 considered an assault or weapon?
Well, again, it's the term assault was just given. Assault weapon was just given by the media. It's just been a media buzz, really, but it's not really considered an assault rifle. The military type grade rifles are what's really considered an assault rifle due to the lethality as to how many rounds can be fired from that.
I'm going someplace here. So is an AR-15 considered an assault firearm?
That's what they do consider as an assault rifle, sir.
AR-15?
Yes, sir.
A FN SCAR?
That as well.
Are those currently being licensed here in the Virgin Islands?
As far as the FN, I'm not too aware of. However, there are some FN rifles that mimic the M4 style platform that are being licensed here in the territory, to include some other brands.
I wanted to wrap up by asking you about, in regards to reciprocal license, when individuals come here with certain type of firearms, maybe for hunting purposes or other purposes, do we recognize, are we issuing a reciprocal license to those type of weapons?
At this time, Senator, no, we're not.
Very well. And something off, well, if we have a second round, real quickly, in regards to legislation that was moved recently, where we extended the licensure requirement from 3 years to 5 years, is that currently being done by the Virgin Islands Police Department?
I'll have Detective Velasquez answer that question, Senator.
Detective Velasquez, thank you, Senator Francis. At this time, we are still waiting a level of clarity from this body because there was some ambiguity in the statute. So I would definitely at this point say that we are waiting on some clarity of the statute from the legislature.
Very well, thank you. Thank you very much. And again, I respect these gentlemen. These are all individuals that I've worked with in the past, and I know of their skill set and their commitment to public safety here in this community. Thank you very much, Mr. Chair, for the time.
Thank you. Before I move to Senator Marie C. James for her 5 minutes, I want to ask, I want to say Attorney Perry, and then I'll move to Detective Velasquez. Could you give me a definition in layman terms, the smallest way you could? Speak to the people in the community. No, don't give me the Santos answer with M4, M9, FM10, all of that. Give me the little man answer. The best way you could, Attorney Perry and Detective Velasquez. What's the definition of a pistol, and what's the definition of a rifle?
So, sir, I apologize. In court, Timothy Perry on St. Thomas, Department of Justice. Sir, I apologize. In court, we actually rely on the Virgin Islands Police Department as the experts to come in and educate the jury.
Good. Okay, stop it.
In the latest layperson's terms, a handgun, it should be self-explanatory. It should look like a handgun. It looks like a duck. It quacks like a duck. That's the rule of thumb. That's what the jury, that's what citizens of the Virgin Islands, when they see these guns, when you lay them on the table in front of the jury and they look at a gun, they're not thinking hyper-technical terms. They're thinking, oh, that looks like a pistol, or oh, that looks pretty scary. And the pretty scary generally tends to be the types of weapons that Santos was articulating. But I defer to the expert at my right, sir.
Good. Detective Velasquez, you recognize?
Yes, again, good afternoon. Simple small-man terms. A rifle is a weapon that has a barrel length of 16 inches or more. A handgun or a pistol, it should be able to be operated with one hand and should have what they call a pistol cartridge, which would be 9mm, 38, 357 SIG, 45, things of that nature. Those are pistol cartridges. And sometimes the term pistol and handgun are interchangeable. However, according to the Virgin Islands statute, one that I've most recently reviewed, a handgun is any weapon that has a barrel length of 12 inches or less.
Thank you to you two gentlemen. Assistants. Senator Maurice James, you're recognized for your 5 minutes.
Thank you, Mr. Chair. Good morning, good afternoon, Virgin Islands. Good afternoon, testifiers. Good afternoon, everyone in and outside the room. I am going to quickly just say a few things that I want to say. I want to extend my condolences to retired Command Sergeant Major Hollis McIntosh on the passing of her mom, Annabelle Rosetta Stephen. I also want to say that last week I had the privilege of attending the retirement of Senior Master Sergeant Arita Ventura's retirement at Joint Base Andrews in Maryland, and two people that I know that my colleague knows. And I want to say that my colleague, my military wing colleague, may know this, that I hated weapons squall, hated it, to the point where I almost wanted to file to be a conscientious objector. So on that note, I'm going to yield the balance of my time to my colleague, military wing retiree, Dwayne DeGraff, and allow him to ask questions on my behalf, because I think he's very qualified to help educate the public on this matter. Thank you, Mr. Chair.
Senator DeGraff.
Thank you, Mr. Chair. Thank you to my colleague. And if you didn't call my name, I was looking around to see what you're talking about. But thank you very much. And like I mentioned about bringing a bill and banning assault weapons before, the impetus had nothing to do with the rifle. The impetus had nothing to do with the weapon. Like I said, we could talk, 300 AAC, MDX, RDX, Isuzu, whatever we want to name these firearms. The bottom line is, in my 26 years, if you had to calculate 20 people that lost their life to gun violence, 26 times 20, come to 500 and change. That's 500 and change Virgin Islanders who lost their life to whether we here trying to figure out what is a rifle, what is a 5.56, what is a 223. That was the impetus for me and as to why I support this bill. Now, are the issues that we may get challenged in court? Let it be. Challenge it in court, we may lose, and it might make us more knowledgeable, that we may come back with something stronger. But with the great attorneys that we have, I stand to think on that line of, but I'm saying in layman's terms, we are trying to restrict a weapon that we seeing what's happening in our territory. When somebody here, oh, this person was gone down, they don't care what caliber, they don't care whether it's a pistol or a rifle. They bracing for a funeral. I've been to too many. You know, I've prevented it. I've been in gunfight. I've been in fist fight. You know, so all the legal jargon, I just asking that we put it aside to my colleagues. Let's put it aside and just say, hey, somebody with a gun, we're going to use it. That ain't a licensed firearm. It's a legal weapon. It's a threat to us all in this community. Ain't just a threat to the person we're getting used on. It's a threat to us all. And they don't care who they're taking on. They're taking on men, women, children. That's the impetus of the whole bill to me. So let's not get caught up. And like I said, I just specifically mentioned about what's written on the bill because that's what's going to be defended. What's written on paper, and they're going to say potato, tomato, potato. Foolishness. People losing their lives in our home and around the world, but our home based upon these lethal objects that man gonna take, some reasonable, some ain't reasonable, and gonna do vicious things and wicked things in our community. They're going to do it, they have done it, and they will continue to do it. So if we have a chance now to do something and then have to sit down in a court to defend it, I'm all for let's do it now. Let's support the bill, fix what we have to fix, and move forward. Thank you for the time to my colleague, and thank you for the time, Mr. Chair.
Thank you, Senator Maurice James and Senator Dwayne DeGraff, for your testimony. Senator Milton Potter, you're recognized for your 5 minutes.
Thank you very much, Mr. Chair. Good afternoon to the testifiers who are here today from VIPD and the AG's office, as well as Department of Agriculture. I want to thank you all for the education I've been receiving today on assault rifles and firearms, etc. I wanted to ask AC Santos, your testimony supports the bill, but then proposes major amendments that would effectively gut the assault rifle ban. Clearly tell me what VIPD's position actually is, an outright prohibition or restricted use?
Good morning, Senator. We're more towards restricted use.
Okay. And I think that's a practical approach. I would venture to suggest, and I know this is just anecdotal stuff, that 99% of the gun crimes that we see on the streets of Christiansted and Frederickstead and Charlotte Amalie and in Savannah and in Tutu, wherever, 99% of these crimes are being committed by persons who illegally possess firearms. My question or my concern is whether the outright ban on assault rifles would in fact curb this increase in violent gun crimes that we're seeing on the streets. That is the question. I understand how these imposing rifles look, and nobody's in support of having these things on our streets, right? But from a practical standpoint, does an outright ban on these rifles, and I just learned that assault rifle, it really is just a media imposed title, does an outright ban really statistically do anything to move the needle with respect to gun violence in the U.S. Virgin Islands?
That's a very good question, Senator. The answer is no, and that's why we were more going towards the restriction of it. And the reason, like you mentioned, due to the practicality of carrying such a weapon on a carry position, that individual will be at a disadvantage anyway. As you could see, or you probably saw already circulating social media, a weapon of that platform has been used on our streets. These individuals who utilize these weapons for wrongdoings are already coming at that individual at the ready with it in hand. So when we speak about practicality, like you mentioned, and I appreciate, when the bad element comes after an individual who is carrying that weapon in a backpack, has to take the time out to remove said firearm from the backpack to utilize it to protect himself, when whereas you could have had a pistol at the ready, which is carried in a much different manner. So again, the VIPD stands firm on the restrictive use, so that law-abiding citizens will still have access to those for not only home protection, but also as a sport. Thank you.
I appreciate the response, and I can definitely support the position of VIPD that you just articulated. I wanted to ask Detective Velasquez and about the question the finance chair asked regarding the 5-year license that this body passed. I don't know if it was a year or more ago. And I was the author of that legislation. So my question to you is, you indicated that you're waiting for some clarification from this body regarding the intent of the legislation or the language, because there is some level of, I don't want to put words in, but ambiguity or vagueness in the legislation. But I haven't received any specific request. I don't think this body has received any formal request for clarification. A lot of people have asked me about, y'all
time
pass this bill, but when I go to VIPD, we're still being issued a 3-year license. So I'm just asking you for some clarification regarding the request for information from this body so that we can implement the law.
Yes, Senator. Good afternoon, Mr. President. Any commentary that I would make in regards to whether I have just previously stated I would be speaking, as said in layman's terms, I'd be speaking out of school. Gotcha. That is way above my pay grade. I can only tell you, based upon my understanding of the statute, there are conflicting sections of it.
Understood.
That level of ambiguity would cause concern not only for the legitimate firearms owners, but also for the regulatory body that has to issue those permits. So in that regard, that is what I believe is the situation that is currently facing the Virgin Islands Police Department. Again, any further commentary, I would definitely be speaking way above my pay grade when it comes to that. As one of the firearm custodians who does handle registration process and fills out the paperwork to get people firearms, it is a concern. I've heard it before. However, those are those issues that needs to be addressed.
I will absolutely, based on the feedback that I just got from you, I will absolutely reach out to the commissioner, to yourself, to the Firearms Bureau, so we can sit down and work on clarifying what needs to be clarified so that the law can be implemented.
Thank you, Senator.
For sure.
Senator, that was time. You're asking for a little extra?
But that was time. No, that's good. That's good, Senator. I'm good. I'm good. Thank you very much. Thank you very much for your responses.
Thank you. Colleagues, just for the record, we have a letter, seemed like it just came in from the Virgin Islands Safegun owners, signed by Kosai Ono, and just for the record, it has been circulated and distributed to all senators. All right. So before I move on to Senator Ray Fonseca, Assistant Commissioner Santos, you know, we have a healthy discussion going this morning.
Sir.
But I have to ask this question. We don't have no gun manufacturers in the Virgin Islands.
That is correct.
Where are these weapons coming from? Where are these illegal weapons coming from? Because I just heard you had a conversation with the former police commissioner back and forth, 600 wrong, chopper, rapper, all kind of thing on the government street. Where are they coming from?
Yes, Senator. Different avenues. A lot of it that we've been noticing is parts being flown in or shipped in. And so a gun part is not illegal, right? So these parts coming in one by one. And as they come in one by one, we have individuals who go to YouTube University, learns how to put them together, and then turns around and sells them out on our streets.
So then this body and you need to sit down and have a conversation. So we could tighten up this, because while we had trying to ban weapons that are sold in stores, we have illegal weapons in the street that come, you know, people with illegal weapons that are committing these, you know, crazy acts of violence. And we need to stop that. You know, we need to have a harder conversation to whether our federal partner, somebody may not want to say it.
Absolutely.
They're protecting sea and air and all kind of thing, but the weapon them still coming in, walking in here, they're in the hands of these
we do have
dangerous people, and the acts are committing, and every week we going to a funeral, there's a letter here going rest in peace. I mean, I can't do it no more.
Absolutely. We do have some suggestions, Senator, that we'll be able to get to you later as far as gun parts are concerned.
Well, whether it's gun parts or how we're going to try to stop these illegal guns coming into the territory, whether it's through the airport, through the mail, I don't know. But you got, like, to outnumber us.
Yes, absolutely.
Point of information, Senator DeGraff. You recognize. Please recognize Senator DeGraff.
Thank you, Mr. Chair. Just for the record, firearm parts coming into the territory illegal.
Yes, sir.
You know, we passed that coming through the post office, coming through the airports, illegal.
Yes, sir.
Possessing gun parts in the territory that are not registered and stuff with your department are illegal. Ghost guns in the territory to possess illegal. Yes, sir. We did this body, we were able to get together, and these are some of the initiatives that we did to ban, to address firearms. So all those firearms are illegal. Coming into the territory with a licensed firearm in the States and you don't register it is illegal.
Yes, sir.
So we want to make sure that the public is aware of the things that are being done, putting into law and stuff. So they are illegal. Nothing we taking for granted. We're trying to save the people in our territory. Thank you for the time, Mr. Chair.
Thank you. Senator Rhea Fonseca, you're recognized for your 5 minutes.
Thank you, Mr. Chair, and pleasant good afternoon to my colleagues, testifiers, and all those tuned in. So I am in support of Bill 360144. There are some important issues. I think it's good for public safety, and I can see where with couple amendments, I think the bill can move forward. The chairman did mention, and I have to repeat, there is a letter that I just received this morning from the VI Safe gun owners. It's a group of 120 legal gun owners in the Virgin Islands, and I think it's important that we consider testimony from the legal gun owners, because these are the law-abiding citizens. And legal firearm gun owners are the ones that comply with the laws. And if I was to ask Attorney General Rhea, I'm sure he will tell me, those are not the ones that are committing these mass murderers. The legal gun owners are not the persons. And with the mandatory turn-in, surrender, the 90 days, I think the 90 days, well, really, I'm not going to comment on it, but we don't want to penalize the legal gun owners with this. You know, we want them to turn in the gun owners, but we don't want them to go in jail because they didn't turn in 90 days. So, you know, I'm sure we'll be a little bit flexible. I did some research and with the alcohol, tobacco, and firearms statistics, and they are showing that up to 93% of guns recovered in the Virgin Islands were originally sold in another state. 93% of the guns that they recover were sold in another state. So that means our guns were already bought and purchased in other states and comes to the Virgin Islands, as opposed to only 28% of the guns in nationally. So that gives some information on where the guns are coming from. These guns have already been on the street in another state. They've been purchased in another state. So I wanted to ask you, VIPD, with the shot spotters, how would the silencers affect the shot spotters situation? Would that have any impact on locating crime?
Assistant Commissioner Santos. Yes, Senator, it would.
It would affect it negatively?
Yes, Senator.
Okay. So, Office of Gun Violence, I saw the video that you did with your group in the daycares, the Head Start. That was pretty good. So I wanted to ask you now, there's that group of individuals, I'm going to call them the seasoned, entrenched gun offenders. The seasoned, entrenched gun offenders. What's the benefit of this bill for those seasoned gun offenders that are actually the ones pulling the trigger? How does that reduce their motivation?
Well, it would be a consequence. If they're captured by the police, then they would certainly serve the time and the penalties for what they're embracing. So, do people follow the law? There's some that don't. Just because you write legislation doesn't mean everybody's going to comply, and that's our problem. People are out there committing crimes. They don't really care what the laws are, but we need to have something in place to hold them accountable because of it. Doing nothing doesn't solve the problem either. So I'm in support of this. I'm in support of the bill, and I think that on the tail end of it, that's where we capture the bad guys.
Okay, so I want to follow up on a question from the Budget and Finance Chair regarding the definition of the tactical pistols and the assault firearms. The definition is based on the caliber or the amount of bullets, or whether it's automatic. How would you define that?
If you could give me some clarity on that question, Senator,
well,
on following.
Well, you see, I have never had a gun. I've never shot a gun. As a matter of fact, I've never seen a gun shot. So I don't really know the difference between a tactical and an assault weapon. I don't be in areas where guns are being shot. But there's a definition in here. So tell me so I can know what's the difference between a tactical and an assault weapon, because I thought they were the same.
They're pretty much the same, Senator.
Okay, so the assault is the one, because when you see those shootings in the States, they always say it's assault weapons, but I didn't know that there was a tactical pistol style. I figure it's all of them is automatic and you pull the trigger and they fire. Okay, so I'm in support of the bill, but I want to make sure that we're not penalizing the legal, law-abiding gun owners who go and get the license and do all the training and are cooperating, and they only have a gun to protect their property or their person, not the ones that's committing the crime. So thank you very much, Mr. Chair, for the time.
Thank you, Senator Fonseca, for your line of questioning. Mr. Emanuel, you know, many a times I hear people talk about Office of Gun Violence. Office of Gun Violence, right?
Prevention.
Prevention. Good. So tell me what we're preventing. How are we preventing? Tell me, I'm glad you remind me about prevention. Tell me the prevention steps. You tell me today about prevention. What's going on in the community?
Prevention steps from my office,
yes, sir,
are the mindset. We work very hard trying to teach our young people conflict resolution, personal management, conflict resolution, de-escalation skills. The video that Senator Fonseca talked about was our unit going around teaching Head Start, Department of Public Works, workplace violence prevention, active shooter response, things to help save lives, to change our minds. We have, it's as much as I'm in support of banning weapons and keeping dangerous weapons out of the hands of perpetrators, it still boils down to what causes a person to inflict injury and harm to another person. What is the mindset of somebody that goes in and kills their girlfriend or shoots their girlfriend's boyfriend? You know, that's a mentality piece. And that's why gun violence has been named a health epidemic rather than a crime epidemic. So those systemic issues that have occurred over the years are just systemic issues of our own society. And it's just as much time as it took for us to get to this point is going to be the time it takes us to retreat from it.
So, you know, just from my standpoint, I see you work, you do your thing, VIPD do their thing, the AG do their thing. I think it's now time for us to work collaboratively. Gone are the days when everybody walking by themselves and there's a one-man unit. You know, you're trying to do the prevention, you're making an arrest, you're going to court. You know, we got to work together. We got to try to stop. You know, I also, I thieved this from the good old police commissioner, stop the pipeline to prison. You know, at some point in there, we got to work collaboratively. One government, one community, one territory. You know, everybody act like there's a one-man show. No. You're trying to do prevention, you're making an arrest, your team don't talk to his team ain't talking to his team. Something going on between the AG and the court, everybody going in like a revolving door, coming back out. I don't know. I said it, yes. We got to stop. I was a classroom teacher. For 17 years, I buried more than 20 students already. I stopped counting. I tell them, don't send me no T-shirt. I don't want none. I come in, but don't send me no T-shirt. It's becoming more like a style. I don't know. But if you all could tell me, I'm willing to help. And I'm pretty sure I could speak for my 14 other colleagues, that let's sit down together, let's see how we could tighten up things. In the Virgin Islands, if I'm wrong, y'all correct me, I know we have some of the strongest gun laws in the book. But what is being done, I don't know. Every day we out there, AC Santos and his team, you know, roadblocks here, roadblock there. We warning the criminals. You look at social media, police, Basin Triangle, police. Beniski said, I mean, like, come on. And I'm speaking to both ends too, you know, but the community got to work with us too. And I think we as the leaders, the government entities, we have to do something too.
I want to, and I agree with you, all agencies have to work together, but I want you to know that the police department and gun violence prevention are working together. We run a collaborative PAL unit together, and we're working that hand in hand. With the schools, our unit is working collaboratively with the school and has been since my office opened up. With health department, human services, we also collaboratively working together. We run programs, wellness programs through all the communities in both on St. Thomas and St. Croix. So there's a lot of collaborative work out there. Maybe you don't know about it. Maybe it's not publicized, but we are working together.
Well, we're going to debate that, right? I refuse to do that one today because I know I be out there and the most police doing for you is holding the traffic. So I ain't going to debate that one here today. Attorney General, before I go to this point of information here, you're seeing an uptick in violence with guns. do your agency have a prevention unit in it as well?
We have a prevention unit for violence by guns.
Yes.
We don't have a unit specifically set up for that, no. Obviously, our criminal prosecutors handle the prosecutions that involve that, but we don't have...
You don't have no special funding for that? None? Okay.
Right, no,
No problem.
nothing for that. I would just mention, if I might, one of the things I really wanted to do when I became Attorney General was to see if I couldn't get more cooperation and understanding between the different departments. And that is making great progress. I can tell you, for instance, yesterday I spoke with Commissioner Mario Brooks 3 times. We talk frequently, and we've been trying to set up meetings with our prosecutors and the police so that we start to get much more of a community spirit, cooperation between the agencies. And that's very big on my agenda. That's one of the things I wanted to push as much as I could. And that's something we're trying to do.
That's good to know that we're trying to work, the Attorney General Office and the VIPD trying to work together.
Very much so. And I've also been doing the same with our federal counterparts, with FBI. I talked to them this past week and had a very good relationship with Delia Smith, the former U.S. Attorney, and the new one I talked with a good bit too, Mr. Sleeper. I'm trying to make law enforcement, help make law enforcement communal. One big piece of it, obviously, is the community plays a big part in this as well, because the police can't do their job unless people report crimes, unless they're willing to come forward and testify, et cetera. So it really is a big picture, but it's something that I take very seriously.
And that's the piece I'm talking about. AC Santos ain't afraid of a mic. He ain't afraid of a TV screen. He ain't afraid to get out there in public. He done it when he was chief. I know the caliber of work he could do. Detective Velasquez is not afraid of anything to speak to. We need to get out there. You have good people on the team. Get with gun violence. Let's get out there in the community. Maybe so at a lot of times when I'm in the classroom, the people we're speaking to ain't the people who really need to hear the message. Point of information, Senator Fonseca.
Yes, thank you, Mr. Chair. Going back to the point of a lot of our guns being, confiscated by ATF coming from other states, particularly Florida. A lot of our guns come from Florida. And as you know, the Florida lawmakers have consistently supported expanding gun rights, often framing it as a defense of constitutional freedom. And in 2023, the governor, Ron DeSantis, he signed legislation allowing permitless concealed carry, meaning eligible adults can carry concealed firearms without license, background check, or training. So I think on the broader picture of where the gun's coming from, we probably need to collaborate with Florida, because a lot of planes coming here from Florida, the ships coming here from Florida, even some of our mail come to Florida. As a matter of fact, efforts to restrict gun access, such as regulating and requiring background checks for ammunition, are banned, and during hurricanes, Floridians can buy guns almost in mass. So I think in the broader picture of the guns, a lot of them are coming through Florida. That's what the statistics saying, and we probably need to work collaboratively with the state of Florida. Thank you, Mr. Chair.
Thank you, Senator Fonseca. Colleagues, we're going to go to a quick burn-in. We're going to to a quick burn-in question. You good? Senator Dwayne DeGraff, gone out. Senator Franklin Johnson, she good? Senator Novelli Francis, Jr., good? Senator Mary James? Senator Milton Potter? Oh, sorry. Senator Ray Fonseca? Great. Now we're going to go to the sponsor of the bill, Senator Clifford Joseph. You're recognized.
Yeah, good afternoon again to everyone. First, what's touching to me is I've been to a funeral about a month ago, and it was amazing to see an older brother that was to a funeral for his younger brother. And he said, I so frustrated with the killing around here, because 9 out of 10 times is a gun. Second, his frustration was to the point where he said he already forgive the person for killing his brother because he just wanted to see us in the border living in peace. And again, if you look at most of the stateside shooting, school shooting, everything else, most of them is from individual, from licensed homes, in stolen guns that hitting the schools in the states are killing anybody. So if we want to start to compare about legal gun owners, the only thing I have to ask the assistant commissioner is, how much guns are stolen? And after they're stolen, are they not used in criminal activities?
It's a good question, Senator. Yes, we have collected firearms that were stolen from scenes, from crime scenes. Yes, we have.
Okay, I mean just from a regular break-in.
Yeah, I don't have the exact number, but we have had homes that have been broken into that had registered firearms, and then later down the road found those same firearms on crime scenes, homicide crime scenes as well.
Okay, so again, I mean, I'll tell all my colleagues, the short title, we don't write the short title, and we all know that. But the effect that allowing these kind of weapons to be concealed on our roads are not as safe. It's not safe for this community. It's small. I mean, I listen to all the testimonies. I listen to my colleagues ask questions about what could penetrate and what can't penetrate. And it's for clear. I do have an amendment coming that will fix a few of the issues that we had in question. And for sure, it's to ban suppressors. So there ain't no question. That's where the ban is coming in. And for those large ammunition rounds. Because if you have them, it's going to cause, most of the last set of shootings that's happened in Croix, if you listen to the news in the morning, spot shatter, 60 rounds. 60 rounds. Two weapons in Glen, 60 rounds, 60 rounds. So I'm just showing you that it's consistent, that if we go focus on what's really some of our problem, we could slow down on the threat. So this measure, again, is to deal with who going to be carrying and what's not going to be able to be carried, because that's the bottom line of this bill. So at the opportune time, we're going on a break, but I'm just again asking for the support. Amendment is here to come here this afternoon, but I'm asking for the support of Bill 36-0144. Thank you, Mr. Chair.
The Committee on Homeland Security, Justice, and Public Safety is in recess for 10 minutes. Good afternoon. The Committee on Homeland Security, Justice, and Public Safety is back on the record. Colleagues, we have exhausted all our line of questioning this morning. Do I hear a motion? Motion. You may proceed, Senator Joseph. You recognize your motion.
Mr. Chair, I move to offer amendment 36-526 to bill number 360144, offered by myself, Avery Lewis, Senator Maurice James, Senator Novell Francis Jr., Senator Franklin Johnson, Senator Ray Fonseca, bill number 360144 is amended as follows. A, Section 1, Internal, Section 2253A, subsection 2, is amended by inserting for concealed carry after firearms in the subsection title. B, Section 2, Internal, subsection 2259 is amended, 1, by inserting felony, misdemeanor, or civil violation at the end of the section title.
Motion.
And
motion. Recognize Senator Fonseca.
Thank you, Mr. Chair. Mr. Chair, I move to waive the reading of amendment number 36-526 to bill number 36-0144. I so move.
Properly moved by Senator Ray Fonseca. Seconded by Senator Franklin Johnson. Hearing no objection.
I so move.
So ordered.
I so move.
I so move.
Second.
Great. So now we have to have the motion on. Yes. It's moved and seconded by Senator Clifford Joseph.
Motion.
No. Hearing no objection. So ordered. Seconded by Senator Franklin. No. Senator Ray Fonseca. Hearing no objection. So ordered.
Motion.
Go ahead, Senator Joseph.
Mr. Chair, I move that bill number 360144, as amended, be approved by the Committee on Homeland Security, Justice, and Public Safety, and be forwarded to the Committee on Rules and Judiciary for further consideration. I so move. As amended.
Properly moved by Senator Clifford Joseph, seconded by Senator Franklin Johnson, Senator Ray Fonseca. Roll call.
Senator Angel Bolkes Jr. Senator Bolkes, absent. Senator Dwayne M. DeGraff. Senator DeGraff, yes. Senator Ray Fonseca. Senator Fonseca, yea. Senator Kenneth L. Gittins. Senator Gittins, absent. Senator Franklin D. Johnson. Yes. Senator Johnson, yes. Senator Avery L. Lewis.
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph.
Yes.
Senator Joseph, yes. Mr. Chair, you have 5 yes, 2 absent.
Thank you. Colleagues, bill number 36-0144 has been voted on favorably and will be forwarded to the Committee on Rules and Judiciary as amended for further vetting and discussion. Colleagues, we're moving into bill number 36-015, the Act amending Title 7, Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6 THC, Delta 8 THC, and Delta 10 THC products in the Virgin Islands and for other related purposes. Who speaks to this bill?
Chair.
You may proceed. You may proceed, Senator.
Colleagues.
Joseph. Before?
Colleagues, I rise to offer Bill number 360105, an act amending Title 7 Virgin Islands Code, Chapter 13, Chapter 3, by prohibiting the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6, THC, Delta H, THC, and Delta 10, THC, products in the Virgin Islands and for other related purposes. The 2018 Agriculture Improvement Act Farm Bill legalized hemp-derived cannabinoids with less than 0.3% Delta THC by dry weight. Delta 6 THC, Delta H THC, Delta 10 THC, THC, and THCA are psychoactive cannabinoids derived from legal hemp. That exploits the 0.3% loophole. These variations that the bill seeks to ban are often chemically altered to produce effect similar to Delta 9 THC, packaged and sold without regulation. Colleagues, I want to make it clear, Delta 9 THC is commonly known as cannabis and is legal in the territory and remains legal in the Virgin Islands. Bill number 360105 does not in any way impact the adult use cannabis law that exists in the territory. The Office of Cannabis Regulation retain oversights of the legal cannabis industry in the territory. For the record, the U.S. Food and Drug Administration, FDA, has not approved Delta 8 products for safe use. The FDA currently does not consider CBD to be generally recognized as safe for use in foods or supplements. Even with this information, there are products sold in the territory that includes edibles that are marked and available to young Virgin Islanders. There are currently no federal or local regulations regarding potency, purity, labeling, or age restriction from hemp-derived cannabinoids. The short and long-term effect of hemp-derived cannabinoids are not fully understood, and we should not allow our children to be used as guinea pigs in this arena. There are initial studies and evidence that suggest that the hemp-derived cannabinoids cause psychoactive effects including impaired coordination, altered judgment, and anxiety. Retailers of these products will say that there are no conclusive research on the hemp-derived chemical altered cannabinoids. But we have all heard stories on the danger, and we must move to protect our community as they could potentially pose significant public health risks. Colleagues, our children and our community are being exposed to products that are not regulated. There are reports from the CDC and the FDA that have noted that sharp increase in calls to poison control on harmful events related to hemp-derived cannabinoids, to include vomiting, hallucination, and loss of consciousness. Children have been hospitalized right here in our territory due to the accidental ingestions of Delta 8 edibles that mimic candies or snacks. It is the intent of this measure to protect our children and our community from becoming part of this statistic. Colleagues, these products are often marked in bright packaging, fruity flavors, and marketed in other forms that mimics popular candy products. This approach combines with weak oversight, increase the likelihood of the use and abuse, likelihood of our youths use and abuse. The Virgin Island laws relative to legal cannabis market impose strict quality and age and dosage regulation. The sale of these products in gas stations, retail and convenience stores undermine the legal framework established by the legislature for adult use cannabis in the territory. At the appropriate time, I will offer an amendment to further clarify the definition in intoxicating hemp. Banning hemp-derived cannabinoids reinforce the integrity of the regulated cannabis industry. Colleagues, I ask for your support of Bill number 360105. Thank you, Mr. Chair.
Thank you, Senator Joseph. Just for my check, we'll start from my right to walk to the left, starting with Commissioner Hussein Encarnacion. Give your name and position on the record, please.
Good afternoon, everyone. Husna Encarnacion, Commissioner of the Virgin Islands Department of Health.
Good afternoon, Senators. Horace Graham, Assistant Commissioner, Department of Licensing and Consumer Affairs.
Good afternoon, Senators. Sean Santos, Assistant Commissioner, Virgin Islands Police Department.
Good afternoon, Senators. Gordon Ray, Attorney General.
Good afternoon. Excuse me. Acting Deputy Attorney General Patricia Lynn Pryor here in St. Croix.
St. Thomas, starting with, sorry.
Good afternoon, Senators. Wilbur Francis, Director of Enforcement, Department of Licensing and Consumer Affairs.
Good afternoon, Senators. Ruben Malloy, Assistant Commissioner, Virgin Islands Department of Health.
Thank you. And my vision is working properly. I see Dr. Sims.
Good afternoon, everyone. Dr. Nicole Cragwell-Sims, Assistant Commissioner, Department of Health.
Good afternoon, everyone. Ian Clement, Chief Deputy Attorney General, Virgin Islands Department of Justice, and member of the Hemp Commission.
Good afternoon, Rhea Richards, Department of Agriculture and Chairperson of the Hemp Commission.
Okay. We're going to begin with the testimonies. Begin with Commissioner Hussein Encarnacion.
Thank you, sir. Good day, Honorable Senator Avery Lewis, on behalf of the Honorable Senator Clifford A. Joseph, Sr., Chair of the Committee on Homeland Security, Justice, and Public Safety, Vice Chair Senator Ray Fonseca, committee and non-committee members, and of course those who are viewing and listening. I am Justa Encarnacion, Commissioner of the Virgin Islands Department of Health. Also joining me today are Assistant Commissioners Dr. Nicole Cragwell-Sims and Ruben Malloy, Chief Legal Counsel McKeish Taylor-Jones, and Deputy Commissioner Brennan Steele was supposed to be here but was called to court, so is no longer here. But we do have someone from Environmental Health just in case you have questions for them. I would like to take a moment to highlight the Environmental Health Division, the team which continues to inspect high-risk businesses and with high impact on our community members. Their dedication to the goals and objectives of the VI Department of Health, and more specifically the policies and mandates identified by the Food and Drug Administration, or FDA, is admired and appreciated. A big thank you goes out to all of the members of the VIDOH team for their work in keeping our community healthy and safe. We thank the Honorable Governor Albert Bryan Jr. and Honorable Lieutenant Governor Tregenza A. Roach for their continued support of our mission, which is to reduce health risks, increase access to a quality health care, and enforce health standards. Thank you, Chairman, for the opportunity to testify on Bill number 36-0105, an act amending Title 7 of the Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sale, or manufacture of tetrahydrocannabinolic acid, or THC, A, Delta 6 THC, Delta 8 THC, and Delta 10 THC products in the U.S. Virgin Islands and for other related purposes. While Delta 9 THC, the primary psychoactive component of cannabis, has long been regulated, other derivatives like Delta 6, Delta 8, and Delta 10 THC are increasingly being marketed and sold as legal alternatives. Many of these products are manufactured synthetically, often using unregulated chemical processes, and can pose serious risk to consumers. Recent reports from the Center for Disease Control and Prevention, or CDC, and the FDA underscore the dangers associated with these products, including increased reports of adverse health effects such as dizziness, confusion, vomiting, and hallucinations, contamination risk from untested manufacturing processes, and accidental poisoning among children and adolescents due to misleading packaging and labeling. The potential for addiction, cognitive impairment, and long-term neurological harm makes proactive legislation essential. The dangers Delta, 8, and similar derivatives pose to children cannot be overstated. Too often, these products are packaged and marketed and to resemble candy, snacks, or soft drinks, deliberately designed to entice young people. One moment of accidental ingestion can result in hospitalization or worse. Without clear regulatory frameworks, these products circumvent existing cannabis controls and put our children at considerable risk of early exposure. The Department of Health is fully prepared to implement Bill 36-0105 through our existing regulatory infrastructure and Food Code Authority. Our Environmental Health Division currently conducts routine inspections at retail food establishments across the territory, and we will integrate enforcement of this prohibition into these established protocols. Under Food Code Section 3-202.12 and 3-201.11, we have clear authority to embargo and remove products containing unapproved food additives from retail establishments. The FDA has explicitly classified Delta 8 THC as an unapproved food additive, making food product containing these substances adulterated under federal law. When our inspectors identify Delta 8, Delta 10, or THCA products during routine inspections, we can immediately issue hold orders under Section 8-903.10 and coordinate with DLCA and the Industrial Hemp Commission for follow-up enforcement actions. This approach requires no additional infrastructure or policy changes. It is simply the application of the established food safety standards to protect Virgin Islands families from products that have generated over 2,300 poison control calls nationwide, with 41% involving children. The department stands ready to begin enforcing and implementing immediately upon passage of this legislation. This legislation recognizes the paramount responsibility we hold to protect our youngest and most vulnerable. It draws a clear line, ensuring that no economic interest can override the duty of safeguard our children and families. Prevention must come before a crisis. By prohibiting possession, sale, and manufacture of these substances, if passed, this legislation can reduce youth access, protecting brain development, and decrease the likelihood of future dependency issues. Beyond regulation and enforcement, prevention requires responsible advertising and proactive community in education. The Department of Health is committed to leading efforts that ensure the public receives accurate, transparent information about the risks associated with hemp-derived intoxicants and all cannabis-related products. We call upon industry partners, community organizations, and media outlets to join us in rejecting marketing practices that glamorize or misrepresent these substances. Advertisements must never target youth or vulnerable populations, nor should they obscure the potential harm. Instead, messaging should reinforce safe, legal, and responsible use while discouraging misuse. Equally important is education. Through school-based programs, public awareness campaigns, and partnership with healthcare providers, we can equip Virgin Islanders, especially our youth and families, with the knowledge to make informed choices. Education about product labeling, safe storage in the home, and recognition of signs of intoxication will strengthen community resilience and reduce preventable harm. In closing, we must continue to foster innovation and economic opportunity, but never at all the expense of public health. This bill strikes the right balance, supporting economic development while standing firm against unsafe and unregulated products. Several U.S. jurisdictions, including New York, Colorado, and North Dakota, have already acted to restrict or ban synthetic or semi-synthetic THC derivatives due to similar concerns. Supporting this bill aligns the Virgin Islands with national public health best practices and demonstrates our commitment to evidence-based policymaking. Furthermore, the FDA has elevated or adopted or approved Delta 8, Delta 10, or related compounds for safe use in any context. Given the lack of federal oversight, local action is both necessary and urgent. The Virgin Islands Department of Health is committed to protecting the health and well-being of our residents. By supporting Bill number 36-0105, the legislature will take a crucial step towards reducing public health risk, protecting our youth from early substance exposure, and ensuring safer, evidence-driven policies around cannabinoid regulation. Our department is prepared to work together with the legislature and other partner agencies to build upon the progress made and strengthen our system. We thank the sponsor of this bill for his proactive leadership and urge the committee to advance this measure. The VI Department of Health stands ready to work with lawmakers, community members, and healthcare providers to ensure its effective implementation. Mr. Chair, committee, and non-committee members, thank you for your time, attention, and unwavering commitment to the health and well-being of our community. We welcome your questions and remain available to provide any additional information or support as needed. Thank you, Senator.
Thank you, Commissioner Canisiong, for your testimony. Mr. Graham.
Good day, Honorable Senator Clifford Joseph, Chair of the Committee on Homeland Security, Justice, and Public Safety, esteemed members of the 36th Legislature of the Virgin Islands, committee members and non-committee members present, the listening and viewing audience. I am Horace Graham, Assistant Commissioner of the Department of Licensing and Consumer Affairs, appearing on behalf of Commissioner Natalie Hodge. Along with me, I have Director Wilbur Francis of our Enforcement Division. We are appearing on before the committee today to offer testimony in support of Bill number 36-0105, an act amending Title VII Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6 THC, Delta 8 THC, and Delta 10 THC products in the U.S. Virgin Islands and for other related purposes. We commend the sponsor's leadership in prioritizing consumer protection and public health, and we recognize the importance of establishing a coordinated regulatory framework for emerging hemp-derived compounds such as Delta 8, Delta 10, THC, and THCA. To support the legislative intent and improve legal clarity, enforceability, and interagency collaboration, we respectfully recommend the following amendments to the bill. 1, Bill number 36-0105 attempts to strengthen the regulatory framework by addressing intoxicating hemp products. However, the definitions included in the current draft require greater precision to ensure consistent application by regulators, law enforcement, and industry stakeholders. We recommend including, along with the bill's definitional edits, a comprehensive framework including the following. Chemically converted cannabinoid should be identified or defined as a cannabinoid produced by chemical reaction outside the plant, including isomerization of CBD. 2, intoxicating cannabinoid should be defined as any cannabinoid, whether naturally derived, chemically modified, or synthetically produced, that when introduced into the human body is reasonably likely to cause intoxication or impairment based on known effects or on perception, cognition, or behavior. It has a psychoactive effect comparable to or greater than delta-9 THC at customary levels, or is marketed or labeled as having euphoric, intoxicating, or psychotropic effects. This includes but is not limited to delta-8 THC, delta-10 THC, delta-6 THC, THCA when decarboxylated, and any analogs, isomers, or synthetic derivatives with similar effects. We'd like to recommend further that enforcement authority under the current draft of the bill is vested primarily in the Industrial Hemp Commission. However, the Commission does not have adequate staffing, budget, or enforcement personnel to ensure effective oversight. And so to provide robust and sustained enforcement, the authority that should be explicitly stated with existing shared with existing agencies such as the DLCA, the Department of Health, VIPD, who already possess enforcement capacity in these areas. Establishing joint jurisdiction among these agencies will ensure comprehensive oversight, prompt action against violators, and promote seamless interagency coordination in protecting public health and consumer safety. To prevent illegal or hazardous products from remaining in circulation, the bill should empower DLCA and DOH, Department of Health, in coordination with the Hemp Commission to seize and safely dispose of non-compliant products. A documented chain of custody should be required for all seizures, and disposal must be conducted in compliance with environmental and public health standards. To uphold consumer safety, informed use, and decision-making, it is critical that the bill also establish clear standards for testing, labeling, and packaging of hemp-derived products. We recommend that the bill require mandatory third-party testing conducted by laboratories duly registered in the area where these products are manufactured. These laboratories must be compliant with applicable federal accreditation standards such as ISO IEC 17025. Testing must be supported by including valid certificates of analysis, which could be made easily accessible to consumers. For example, through scannable QR codes placed on product labels. And additionally, labeling should provide consumers with accurate and transparent information, including cannabinoid content, dosage information, batch identification, health warnings, and clear age restrictions. Such information is essential to ensure safe and informed use, particularly for new or unexperienced customers. Packaging must adhere to strong safeguards to protect public health and prevent unintended use. Specifically, products should be sealed in packaging that is both child-resistant and tamper-evident. Packaging should also be designed in a responsible manner that does not appeal to minors, avoiding the use of cartoon imagery, bright or flashy colors, or designs that mimic snacks, candy, or cereal. By embedding these safeguards into the law, the legislature will promote consumer safety, support responsible business practices, and guard against the marketing of products to vulnerable populations. To promote procedural fairness, the bill should also establish a formal administrative hearing process for permit or license revocation with input from DOH and DLCA, depending on the nature of the violation. And then age restrictions. The regulation of hemp products must include strong age controls, including for online sales. The products should never be accessible to youth, and the law must make that clear. Bill number 360105 should prohibit the sale, marketing, and delivery of hemp-derived products to anyone under the age of 21. This rule should apply to all areas of access, stores, delivery, and special events to protect young people and ensure consistent enforcement. The bill should also require government-issued ID checks for every purchase, whether in person or online, to close any loopholes that might allow underage access. And finally, retailers and distributors must be held accountable. They should be required to keep records showing that they followed age verification and delivery rules. This will strengthen enforcement and prevent negligence and support the bill's goal of protecting public health. In conclusion, Bill number 360105 addresses an urgent regulatory gap concerning intoxicating hemp products. The bill is a necessary and timely measure to close loopholes that threaten the health and safety of our residents. With the proposed amendment, the bill will provide the regulatory clarity and enforcement strength needed to truly protect consumers, especially our minors. We extend our gratitude to the Honorable Governor Albert Bryan Jr. and Honorable Lieutenant Governor Tregenja Roach and the Brian Roach administration for their steadfast support in advancing consumer protection. We also thank the committed men and women of the Department of Licensing and Consumer Affairs, along with our partners at the Department of Health and the Office of Cannabis Regulation, for their dedication and collaboration in this effort. We thank the committee for the opportunity to present this testimony and respectfully urge the passage of Bill number 360105 with the suggested amendments, as we believe they will help advance a balanced, enforceable, and science-based regulatory framework. Thank you for your committed or continued support, and we welcome any questions the committee may have.
Thank you, Assistant Commissioner. Assistant Commissioner Santos, you may proceed.
Thank you, Senator. Mr. Chairman, distinguished members of the Senate, thank you for the opportunity to testify today in this matter. I am Sean Santos, Sr., the Assistant Commissioner for the Virgin Islands Police Department, on behalf of Commissioner Mario Brooks. We submit this testimony in support of Bill number 36-0105, an act amending Title 7, Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sale, or manufacture of THC acid, Delta 6, Delta 8, Delta 10 products in the Virgin Islands and other related purposes. On behalf of the Virgin Islands Police Department, thank you for the opportunity to submit testimony in support of this bill. I submit this testimony in support of Bill number 360105. National data underscores that the urgent need for action according to the U.S. Food and Drug Administration, Delta 8 THC, and similar derivatives have not been evaluated or approved for safe use and are often marketed in ways that put public health at risk. Between December of 2020 to February of 2022, the FDA received over 100 reports of adverse events from Delta 8 THC products, including hallucinations, vomiting, tremors, anxiety, dizziness, confusion, and loss of consciousness. More concerning, 55% of these cases require medical intervention, and 41% involved children or adolescents. The Center of Disease Control and Prevention has also documented a significant rise in poison control centers calls associated with these products. In just 1 year, National Poison Control Centers receive over 600 calls related to Delta 8 THC exposure, with 39% involving children under 18 years old. Additionally, many of these products are manufactured with little to no regulatory oversight, leading to contamination with heavy metals, solvents, or synthetic byproducts. Such risks are compounded by misleading packaging, often designed to resemble candies, snacks, or other products attractive to youth. By prohibiting the possession, sale, or manufacture of these products, the Virgin Islands will be aligning itself with more than a dozen states, including Colorado, New York, and Kentucky, that have already taken strong regulatory or prohibition measures to safeguard their residents. While the intent of this bill is commendable, its current framework vests primary enforcement authority in the Industrial Hemp Commission, and with limited staff, no dedicated enforcement personnel, and insufficient budgetary resources, the Commission is not adequately equipped to serve as a sole enforcement body for this measure. To ensure robust, sustained, and effective enforcement, we recommend that the enforcement authority be explicitly shared across agencies that already have the capacity and statutory mandates to regulate, investigate, and to protect public health. The VIPD enforce the provisions of this bill, conduct investigations, seize illegal products, and provide the necessary law enforcement support. With our partners, DLCA, conduct business inspections, issue citations, impose fines, and suspend or revoke license for non-compliant establishments. DOH oversee public health standards, enforce labeling and packaging requirements, and monitor reports of adverse health events related to these substances. And the Industrial Hemp Commission to retain oversight and permitting responsibilities to ensure consistency with existing hemp regulations and agricultural policies. With all four agencies working together under this bill, we will have a strong and realistic enforcement plan one that protects the public, supports our local businesses that follow the rules, and ensures no single agency is left trying to do an impossible job alone. In conclusion, Bill number 36-0105 addresses a critical and emerging threat to the health and safety of our Virgin Islanders by both prohibiting the harmful and unregulated products outlined in the bill and strengthening enforcement authority through interagency collaboration. This legislature has the opportunity to take a decisive action to protect our community. This is not just about law or policy, it is about our people. It's about protecting our children from being targeted with unsafe products. It's about ensuring parents don't have to rush a child to the hospital because of something they thought was safe. It's about sending a clear message that in the Virgin Islands, we value the health and safety of our residents above all else. I respectfully urge the members of the 36th Legislature to pass this measure with the recommended enforcement amendments to ensure it is both enforceable and effective. Thank you for your leadership and commitment to the well-being of the Virgin Islands.
Thank you, Assistant Commissioner Santos. Attorney General Rhea.
Yes, good afternoon, committee members, other senators, and listening and viewing audience. Thank you for inviting the Department of Justice to testify on Bill number 36-0105. My acting Deputy Attorney General for St. Croix, Patricia Lynn Pryor, who is here at the table, has spent some time investigating this and has pulled together testimony, and I would ask that she be permitted to testify about the details.
Thank you. Good afternoon, committee chair, senators, legislative staff, and the listening and viewing audience. We do thank you for inviting us to testify on this bill. It is my pleasure to appear before you all today. The Department of Justice serves as the attorney for the people of the Virgin Islands, and we stand ready to enforce the laws of the United States Virgin Islands as enacted by this legislative body. That includes any laws pertaining to marijuana, hemp, cannabis, or other chemical compounds. However, the Attorney General of Virgin Islands and I have no particular position regarding the implementation of Bill number 36-0105 at this time. The Attorney General's office agrees that it is important to develop and enforce stronger regulations governing cannabis and hemp-derived products, particularly those that pose health risk or harm to minors. As Bill 36-0105 notes, Delta 8 and other similar THC products are not regulated by the Food and Drug Administration. The lack of FDA approval precludes assurance that any of these products labeled as Delta 8, THC, or others are safe for use, that they contain precisely what is claimed on the label, and that no dangerous chemicals or other habit-forming substances are included. The products that are labeled and marketed, particularly in an effort to appeal to minors, are even more disturbing. Those issues certainly deserve attention by this body. Following the enactment of the Virgin Islands Cannabis Use Act, our office has met and collaborated with the Office of Cannabis Regulation and would defer to them as more of a subject matter expert in this field. It is our understanding that OCR does support this, the inclusion of, in their words, age gating protocols, rigorous testing requirements, and clearly defined product safety and labeling standards. We agree that such safeguards are important to protect customers in the Virgin Islands and to ensure that any cannabis or hemp-related products sold here are in compliance with the legal and public health requirements. The Department of Justice also defers to the Virgin Islands Industrial Hemp Commission in matters pertaining to their expertise. Unfortunately, it appears that Bill 36-0105 creates some overlap between these two agencies. We would encourage the legislature to include both agencies and to direct them to work in partnership in the implementation of any new laws or regulations, to define a regulatory framework and to ensure compliance. The primary concern of the Attorney General's office with this particular bill is that the Cannabis Use Act, Act 8680, was previously enacted for the purpose of regulating the cultivation, manufacture, and sale of cannabis, and providing oversight of the cannabis industry to protect public safety, improve public health, and create economic opportunities for the Virgin Islands and its residents. Yet this bill contemplates changes to the laws that fall under the regulation of the Virgin Islands Industrial Hemp Commission. The Virgin Islands Cannabis Use Act is codified in Title 19, Chapter 34 of the Virgin Islands Code. However, this bill proposes additions to Title 7 and Chapter 13 of the Code, which pertains to the cultivation of hemp. There's a certain amount of confusion between the two sections of the Code, and having two different regulatory bodies deal with these very similar plant-based products creates concern about how this bill will be implemented and who will be responsible for the enforcement and regulation. We believe that it is imperative for the laws pertaining to regulation of cannabis and hemp products to be in accord so as not to cause more confusion if there becomes a conflict between the two. Furthermore, Bill 36-0105 appears to criminalize some products that may have already been legalized in the Cannabis Use Act. The overlap of the current hemp and cannabis laws and regulations creates its own form of uncertainty, and we're sure that this legislative body does not intend to create any further contradictions between the two. Particularly the enforcement of the proposed code provisions, the enforcement of the proposed code provisions may be difficult or ineffective if there isn't a clearly defined regulatory oversight. The Department of Justice would defer to the Office of Cannabis Regulation and the Virgin Islands Industrial Hemp Commission for their guidance on potential conflicts, and we would encourage a collaborative effort by now all of the agencies that are in attendance to implement any changes deemed necessary by this 36th Legislature of the United States Virgin Islands. This concludes my remarks. Thank you for your time and attention today.
Thank you. Before I go to St. Thomas, Executive Director, Mr. Dwayne Howell, please place your name and title on the record before you begin with your testimony.
The mic is on.
Right.
It's on now. Dwayne Howell, Executive Director of Access to Racial and Cultural Health Institute. Good afternoon, everyone. Good afternoon, Chair. Good afternoon, Honorable Senator Clifford A. Joseph, members of the Committee on Homeland Security, Justice, and Public Safety. My name is Dwayne Howell. I am the Executive Director of Access to Racial and Cultural Health Institute, or ARCH Institute. We are a 501c3 nonprofit organization operating in its 22nd year. While our base is here on St. Croix, we serve and work with adolescents across the territory on emerging health threats. We are also working closely with Facing It Together in the Virgin Islands, a 501c3 nonprofit organization funded by youth to build youth capacity on St. Thomas and St. John. 13% of high school students reported current marijuana use in 2025 as measured by the Core Measures Survey. More alarming is only 67.7% of high school students believe there is a moderate to great risk in using marijuana. More than 10% of out-of-school suspensions are a result of drug use on campus, primarily some form of cannabis. Merchant compliance of underage buyers continue to hover around 66%. Bill 36-0105 will assist in protecting our most vulnerable population from accessing drugs, and we're speaking about youth specifically. This legislation is welcome as it restricts access to Delta 8 and other variations in the local marketplace. But I must reiterate, measures must also fund prevention programs to ensure we build community capacity and increase protective factors for our youth population. In subsection 209 of the proposed legislation, it directs 50% of fines collected to the Agriculture Revolving Fund and 50% to the Consumer Protection Fund. While I agree with the latter, my mask, I don't really like to take off my mask, but I'm a strong mask wearer. While I agree with the latter, I must ask the bill's sponsor to consider amending the legislation to direct the former to a fund to support substance abuse prevention initiative at the community level. The Consumer Protection Fund is important to support merchant education and to conduct shoulder-tap programs, ensuring merchants remain in compliance with the law. While Bill 36-0105 has the potential of reducing access of cannabinoid products to the community in general and underage users in particular, consistent compliance checks, including shoulder taps, must be conducted. It is a fact merchants' compliance rate as measured by various compliance data sources is below fear. What I'm not sure about is e-commerce and how this bill impacts or rather restricts purchasing products online. While the bill bans local merchants from selling these products, it does not address e-commerce restriction to prevent the shipping of Delta 8 and other variations to the territory. As you know, we live in a resource desert, and local consumers rely on the e-commerce market to access and purchase products. Delta 8 and other Delta variation come in various forms: edibles, oils, tinctures, capsules, vape concentrates, buds, and skin products. The latter, I believe, will need to be specified as it is often used in the category of medicinal cannabis, but is also for recreational use. No different to any other Delta 8 product, skin products are also not regulated and do have psychoactive effects. All these products can easily be obtained from the e-commerce marketplace. Just yesterday, UC San Diego Today published an article entitled Delta 8 THC Use Highest Where Marijuana is Illegal, Study Finds. University of California at San Diego researchers published their findings in American Journal of Preventative Medicine on their research about jurisdictional marijuana bans and users' use of alternative products like Delta 8 THC. Public policy must take into consideration that banning substance will not curtail use. This is why in the beginning of my testimony I mentioned funding prevention. While Bill 36-0105 will only address one piece of the puzzle, which is access, it must be coupled with some funded public health prevention policies to decrease use, increase perception of risk, and increased protective factors for youth. Arch Institute and Facing It Together in the Virgin Islands believe there is value in Bill number 36-0105 being enacted. Collectively, we'll continue to deploy sound environmental strategies to curtail use and increase protective factors within the confines of our limited funding. While we support this measure, we ask the sponsors and committee to consider identifying funds to support evidence-informed prevention programs and projects, amend where the penalties are being directed, and to take into consideration e-commerce access. I'm here to answer any questions if you have. Thanks.
Thank you, E.D. Howell. I'll go to St. Thomas, to D.C. Rhea Richards.
Good afternoon. Thank you very much. Good afternoon, Honorable Clifford Joseph Sr., Honorable Avery Lewis, Chair, and other distinguished members of the 36th Legislature. Thank you for having us as the members of the Hemp Commission appear before you today to testify on Bill 36-105, an amendment to Title VII VI Code that would prohibit the possession, sale, and manufacturing of tetrahydrocannabinolic acid, Delta-6 THC, Delta-8 THC, and Delta-10 THC products in the Virgin Islands and for other related purposes. I am Rhea Richards, Deputy Commissioner for the Department of Agriculture, and I serve as the chairman of the Hemp Commission. I want to publicly thank the members of the Commission for their confidence in my ability. It is an honor to present to you and to acknowledge the members of the Commission and their designees. The Honorable Justa Encarnacion, Commissioner of Health, Dr. Janice Valmond, Deputy Commissioner, Department of Health. Also today here with us is Dr. Nicole Sims from the Department of Health, the Honorable Nathalie Hodge, Commissioner of Licensing and Consumer Affairs, Mr. Horace Graham Jr., Assistant Commissioner. Seated next to me is Mr. Ian Clement, Esquire, Chief Deputy Attorney General. The Honorable Mario Brooks, Commissioner of Police. The Commission has also included the Director of the Port Authority, Mr. Carlton Dow, who is represented by Mr. Jerome Sheridan, Airport Manager. Dr. Usman Adamu represents Dr. Sophia George, who is the President of the University. I represent, as his designee, the Commissioner of Agriculture, Dr. Louis Peterson, Jr. And present with me in the chambers on St. Croix is Mr. Clifford Joseph, Jr., the Director of the Hemp Program. I also would like to acknowledge Ms. Joanne Moorhead, who is the Director of OCR, and she's in the audience. And we have a very good working relationship. It should be noted that hemp, known as Cannabis sativa L, is one of the oldest cultivated crops known to mankind. Hemp is not suitable for recreational use and is better suited for industrial use. For example, making rope, textiles, paper, animal feed, and even being a food source. The 2018 Farm Bill legalized the cultivation and sale of hemp and hemp-derived products that contain less than 0.3% THC. It is for this reason we are here to fully support this proposed bill offered by Senator Joseph. According to the bill's summary, the purpose of the bill is to ban compounds like Delta, 6, 8, and 10 THC. Section 1 removes intoxicating derivatives of cannabis from the definition of hemp, which is good. However, what is needed is a clear definition of hemp or industrial hemp. It should be noted that when these compounds are removed from the definition of hemp or industrial hemp, they may fall under the purview of the Office of Cannabis and the Cannabis Act. This bill currently falls predominantly under Title 7, Section 200, et sequence, but the intoxicating cannabis products fall under Title 19, Section 775, et sequence. There does not appear to be any reference to the cannabis use or OCR. There is a concern that if Delta 8 is completely banned, retailers will not apply for permits from the Commission. The retailers would not be inclined to want to sell non-intoxicating hemp. There also exists the possibility that they may import products with packaging that outwardly complies with this bill. As a body, the Commission supports the fact that the legislation would offer clarity by formally excluding psychoactive cannabinoids such as Delta 6, 8, and 10 THC from the hemp classification. The drawback, however, is the possible proliferation of products coming in through the retail market that are untested and could contain Delta 6, 8, and 10 THC that are often derived synthetically. This does pose a very serious health and regulatory problem. Equally important would be the ban on products that are packaged to mimic brands that are children's snacks, beverages, and candies. The consumption of these products by children and vulnerable populations, to include our seniors, is an important public health issue. We can, however, regulate based on the counterfeit packaging itself under 12 VIC 101 and 102 as deceptive trade practices and through DOH regulations. The Commission does want Deltas 6, 8, and 10 to be banned. However, it lacks an enforcement arm and a budget for enforcement. Under VIR and Regulation 77-5, the OCR is required to collaborate with the Commission and the VI Police Department on enforcement. The process of referring violations to the Department of Licensing and Consumer Affairs requires enforcement. An officer must go into a convenience store, seize the offending products, and issue a summons. This summons would be for an administrative hearing on the possible violation. The bill as it is would have to provide for notice and an opportunity for the offender to be heard. And it should also state who would have to conduct the hearing and issue the fines on these violations. The Commission has great and broad local government representation, as we have health, justice, police, the Port Authority, agriculture, and the University of the Virgin Islands. All of these agencies collectively create a structure that the Commission does not have by statute. The Department of Agriculture does not have staff specifically assigned to perform administrative tasks, nor do we possess enforcement officers. Mr. Joseph Jr. and I do the administrative tasks, and we would rely on the departments of police, health, licensing, and consumer affairs for enforcement. As we contemplate the reality of banning Deltas 6, 8, and 10 THC without having a laboratory or access to one, it is chilling. As I previously stated, we can anticipate that our territory would be inundated with products with the Delta 6, 8, and 10 product THC, and that would definitely be problematic. We have had complaints about persons purchasing these products, ingesting them, and having adverse reactions to the products. The Commission does not, and I emphasize, the Commission does not want this problem to become the norm within our communities. it is imperative that we address the issue of laboratories and testing of products. Mentioned earlier that we can hold retailers accountable through deceptive trade practices. We urge that the legislation make accommodations for this course of action, and the Office of the Attorney General can provide information on the legal process for this course of action. I want to boast that this group of people on this commission are all committed to ensuring that the commission functions effectively and efficiently to safeguard our community and towards building a viable hemp industry. All the members of this commission or their designees have attended all the official meetings of the commission, and I want to put on the record and publicly thank them for their diligence and commitment, as you all saw today in their presentations. In conclusion, thank you, Senator Joseph, for your work on this legislation, and thank you for allowing me to make this presentation, and for my colleagues who also made their outstanding presentations today. I will ask the rest of you senators to please support this legislation with some amendments, as it has great potential to generate revenues for the territory. Thank you, and we are ready to answer your questions.
Thank you.
I also, Senator, if you will indulge me, I also mentioned the idea of deceptive, charging and using the provision in the law of deceptive trade matters. And if there are any questions, the Attorney Clement is here. He can elaborate a little more on that.
Thank you.
Thank you.
Thank you. I was made to understand there's a correspondence from Ms. Joanne Moorhead, Executive Director of the Virginia Office of Cannabis and Regulation. Madam Clerk, could you please read that into the record?
September 1st, 2025, Honorable Clifford Joseph Sr., Chairman, Committee on Homeland Security, Justice, and Public Safety, 36th Legislature of the Virgin Islands. Dear Senator Joseph, thank you for your letter dated August 21st, 2025, inviting Ms. Joanne Moorhead, Executive Director of the Office of Cannabis Regulation, OCR, to provide testimony on Bill number 36-0105 at the scheduled hearing on September 4th, 2025. Please be advised that I am currently out of the territory on work-related business, as indicated in my email dated August 25th, 2025, and am therefore unable to appear at the hearing. Nonetheless, the OCR wishes to express its full support for the development and enforcement of stronger regulations governing cannabis and hemp-derived products, particularly those posing public health risks. The OCR endorses the inclusion of age gating protocols, rigorous testing requirements, and clearly defined product safety and labeling standards. These safeguards are essential to protect consumers and ensure that products marketed in the Virgin Islands adhere to best practices and are compliant with both local law and public health objectives. That said, we respectfully raise two important concerns with the current draft of Bill number 36-0105. First, while the bill seeks to prohibit the possession, sale, and manufacture of intoxicating hemp-derived cannabinoids, such as THCA, Delta-6 THC, Delta-8 THC, and Delta-10 THC, it does not designate a specific agency responsible for enforcement. Without clearly defined regulatory oversight, compliance and implementation efforts could be fragmented or ineffective. Second, the bill risks overlapping with existing provisions under the Virgin Islands Cannabis Use Act, Act number 8680, which regulates the legal cannabis market. Specifically, some of the cannabinoids listed for prohibition under Bill number 36-0105, including THCA, may be present in products authorized for sale within the regulated cannabis framework. Without more precise statutory language distinguishing between naturally occurring cannabinoids permitted under the Cannabis Use Act and synthetically altered or unsafe variants, there's potential for legal ambiguity and disruption in the emerging legal cannabis industry. While I am disappointed that I am unable to attend this hearing to provide in-person testimony, the OCR remains committed to working with the legislature to develop a well-regulated, safe, and effective cannabis and hemp marketplace. We appreciate your leadership and look forward to ongoing collaborations. Sincerely, Joanne Moorhead, Executive Director.
Thank you, Madam Clerk. Media, there's some pictures. Could you put them up for us, please? I'm not certain. Huh? I'm not certain who would like to speak to them, but I mean, I think these are some of the products that's floating around our community that our children are being lured towards and taking care of. Mr. Graham, you want to take a stab at it?
Yes, I'm certainly. In collaboration with, and what you'll see in the various testimonies you heard, there's a significant degree of collaboration between our agencies here, and what you see on the screen is what looks like, it says Kellogg's Fruit Loops, and what we're finding in the community are retailers that are selling products that look like this, but it's CBD-based or THC-laced products. This clearly seeks to appeal to children, sensitivity and sensibilities of children. And so these types of things, we believe, pose an inherent risk for unauthorized access, and we believe that part of what the legislation is doing is to make sure that these types of products are not available to our children. In some of the testimonies, you would have heard requests for consideration for particular packaging, and even if we take the steps to eliminate the intoxicating cannabinoids, the fact that the way packages are made for those things that are legitimate and allowable can really make a significant difference on who accesses these items. So as you can see, this is bunny pills. It looks like something that a child would lean into. And that type of marketing of products that are potentially harmful must be mitigated. Again, sour crawlers, or they look like those standards, sour worms or whatever those things are that we typically see children gravitate towards. And again, the marketing and packaging of these items with no significant detail on what is inside or what the makeup and or contents are is a very dangerous situation. Yeah.
Oh, wow.
Now, the last two slides, if you could go back one, it'll be helpful. Just if you can, I don't know if he's able to go back. Yes. So this is a Chester's fries, which is, we're accustomed to, right? We know these types.
No, we're accustomed to Cheetos.
Cheetos, okay. Right? Go next. This is a Cheetos, flaming hot, crunchy. And the bags that they sell these products in look exactly like the same. It might be a slight difference in one of the letters or something, just to sort of throw you off, but these are CBD-based products, THC-laced products that have no indication of content, amount, and so on, and can be tremendously harmful. And you know what's interesting here, Senators? These are all things that we have either confiscated or we find available. People have notified us of the availability of these products throughout the territory. This law, this bill, certainly takes a step in eliminating this type of deceptive activity in our retail environments. Thank you.
Thank you, Assistant Commissioner Graham. Colleagues, we're going to go to a 4-minute round and moving on. But Assistant Commissioner Graham, I have to tell everybody here, what's scary is I remember during election time, we had a thing called at the hospital, trunk or treat. You know, you set up your trunk, your truck, whatever it is, and the children them come by, a new way of doing trick or treat, Instead of going door to door, they come around in the hospital parking lot, and most of those candies and things there, most of those packaging look just like some of the candies that were given away. Geez, body. You know, people that said that's boardwalk, my son. But anyhow, moving on. Senator Dwayne DeGraff, you're recognized for your 4 minutes.
Thank you, Mr. Chair. You know, those products will get me fast too. I'm a sweet tooth, they're going to get me good. So let's get a handle on this here. Is hemp legal here in the territory? No, I would like to hear an answer, not a shake head. Is hemp legal in the territory?
Yes, the answer is, Horace Rhea, I'm Assistant Commissioner, Department of Licensing and Consumer Affairs. The answer is yes.
Okay, so then is there any regulation of hemp now?
Yes. I would defer to the Hemp Commission personnel, but the Hemp Commission is tasked with the regulation of hemp in the territory.
Right, so these things aren't legal. Are these products legal?
From the Department of Licensing and Consumer Affairs, who issues the business licenses for the hemp retailers that many of whom we have tracked, those who are violating this process, many of them we have issued licenses to, those individuals have received, like I said, licenses from us. We issue terms and conditions that specify that the sale of those types of consumables are not authorized.
So how many licenses have you revoked?
We have not revoked any licenses.
How many licenses exist through License and Consumer to hemp dealers in the territory?
I'll defer to our Enforcement Director to capture that.
Wilbur Francis, Director of Enforcement. There are currently 79 approved hemp retailers licensed.
79 approved hemp retailers. All 79 of them selling those products?
No, sir.
Okay, so that's what I'm saying. So what makes the product illegal? In other, unless you know the content isn't written on the package, or is it?
And so in some instances it is, but in the instances where it's not written, this is where we work together with the Virgin Islands Department of Health, and as we work there under their embargo capacity, along with Enforcement Division, to seize such products and remove them from the marketplace.
Okay, and what kind of seizures have we had to date?
Quite a number of those. Dr. Francis, could you please, or Department of Health, who work together with us, are capable of...
See, because, you know, regardless of how we spin this, by the time we take to get this bill passed to the next committee, these things are being sold. Mm-hmm. And who they're being sold to 9 out of 10 times our children. So, I mean, there is like a lack of urgency to me to wait for a bill to pass for us to address this. And what's taking place now? What is the defense that we have now until this bill comes online? What's the defense?
If I may.
Yeah.
If I may.
Sure. Yeah, I only got 4 minutes, so I mean, if you don't, sure.
Ruben Malloy, Assistant Commissioner, Virgin Islands Department of Health. We are currently enforcing, based on the Food Safety Code, these items are, since hemp is not authorized for human consumption, it falls under the Food and Drug Administration, and it's not for human consumption. So that is the basis from which we are seizing these products.
Right. Thank you. Just in closing, Mr. Chair, but this is the narrative I just heard. We have 79 businesses legitimately licensed here in the territory. These things exist in these businesses. And, you know, we have this issue. That's what was just told. So why aren't some of these businesses where you find these products being closed down and the license revoked? That's all I'd like to hear you can answer in the chair's time. Thank you for the time, Mr. Chair. Wait, you can answer for.
I want to, Mr. Graham, you want to respond?
Assistant Commissioner Horace Graham, Department of Licensing and Consumer Affairs. So the process is not that we are not taking those particular actions. We are, and we are addressing those as they come to us. We have a process where we bring them in for a legal hearing and we go through that step. The key part here is that when we identify those, like I say, again, not every retailer are retailing those types of products, but in the event that we identify those, we have seized them and first of all, remove them out of the market. But what we're asking in this piece of legislation and what we're confirming and agreeing with is the fact that making it patently illegal to have, possess, and or sell these products. Many people have made the arguments over time, Senator, that the Farm Bill broadly allows for these things. And what we recognize that, along with other local jurisdictions, that they have taken specific action, such as you guys are contemplating in this bill, to be able to restrict the availability of such type of products in the U.S. Virgin Islands. A timely bill, I believe.
All right, Senator Franklin Johnson, recognized for your point of information.
Thank you very much, Mr. Chair. My point of information to the Director and Health. The areas or the places that you're confiscating these items from, are any of them licensed or are licensed hemp supplier?
Yes, some of them are licensed hemp retailers.
Okay. And are there any that are not licensed hemp retailers that are distributing them in, like, let's say, regular gas station? Are those gas stations or little small mom and pop store hemp retailers?
It is important. Horace Graham, Assistant Commissioner, Department of Licensing and Consumer Affairs. It is important to note that many of the individuals who are retailing these items are licensed. A number of them have been identified as not having the appropriate license, and when we come upon those types of establishments, we take the appropriate action. We issue citations, bring them into compliance, and seek to get them fully regulated.
I think Department of Health wanted to supply some information.
Just to add some, Ruben Molloy, Assistant Commissioner, Virgin Islands Department of Health. Just to add some clarity to the discussion, the Food Safety Code, food may not contain unapproved food additives. So hemp is described as having a less than or equal to 3% THC. These products contain more. So we need to make the distinction between what's hemp and what's cannabis. Cannabis is anything above 0.3%. In addition, which allows us to enforce what we're doing, is food shall not be obtained from sources that do not comply with the law. Or food must be obtained from sources that comply with law. With synthetic and semi-synthetic manufacturing of these hemp-based products, we have no idea how they're being manufactured. They may contain residual metal. They may contain above what is in them is not properly labeled. So that's another issue. So we have under FDA, we have the regulatory authority to place a hold on these food products. Bottom line is CBD and Delta A, THC, are unapproved additives for use in any human or animal food product.
Thank you, Senator Johnson. Commissioner Canción, before we move on to Senator Johnson for his 4 minutes. He just had 3, but I'll give him 4. I wish Ms. Moorhead were here. Do we have a testing lab to test these products?
In terms of testing?
Yeah.
We do have a certified public health lab.
Speak into the mic, could barely hear you.
Can you hear me? This is better. Yeah. We do have a certified public health lab. We are not currently up and running with the testing capabilities of hemp or cannabis. It's something that we actually just spoke yesterday, DLC and I working together with the company to be able to come down and actually, right now we're moving the lab. When that's done, then we can actually look forward to that. So there's a plan that we have in place, and once that actually occurs, then we'll be able to test for the synthetics as well as the regular, and we'll also be able to test for the level of components within each.
So the reason I'm asking is because I know when your team and licensing goes out, and some of these products, I think by law they should have the ingredients on it. One may try to contest that my product don't have it in. Try to look for some invoice somewhere in a back room or something. So I'm just saying what recourse we as the government have.
Well, I have to say that that's one of the reasons why this bill is so important. It's that for the ones that do not have the labels within it, those are the ones that we can actually target in reference to confiscation as well as closure.
Mr. Graham?
Yes. Exceptional. One of the things that I wanted to say, Horace Graham, Assistant Commissioner, Department of Licensing and Consumer Affairs. The department working along with the OCR, we have recently acquired what we call presumptive, some field test kits that are now capable of identifying whether the THC levels are above a certain point. Keep in mind that these are presumptive tests. And so ultimately, when we have a lab in place, we can also take those items that test higher and have them evaluated. And so there are a number of key steps that the departments are taking, given the current state of affairs. Remember, a couple of years ago, hemp was not known. But now everything is sort of moving in a direction, and we are ramping up our capabilities, Senator, to make sure that we can regulate it effectively.
Thank you. Point of information, Senator Clifford Joseph, Senior.
Thank you, Mr. Chair. Assistant Commissioner Graham, you say you gave out hemp retailer license. So what kind of product do we produce in the Virgin Islands from hemp?
Well, it's not necessarily products produced in the U.S. Virgin Islands. Currently, there are no hemp-based products produced in the U.S. Virgin Islands. Hence the reason why our terms and conditions were extremely restrictive, specifically identifying that we were not approving any consumables and the like. So we were very, very clear of that. In addition, while we don't have any products developed in the Virgin Islands, we maintained that any product that was sold had to have a third-party lab testing capability. Our terms and conditions were very clear in regards to that.
Okay, thanks for your answer. Thanks for your answer. Thanks for your response.
Senator,
thank you, Mr. Chair.
May I have a readout from our public health lab director? May I read that so that the community can actually know where we are in terms of our lab?
Go right ahead.
All right. First of all, our intention is to support the state programs to ensure public health safety. The Public Health Lab will ultimately be able to provide scientific, diagnostic, and technical expertise in order to ensure regulatory compliance and accurate, standardized, and unbiased testing. The Public Health Lab is still undergoing relocation and will develop capacity for regulatory compliance, for example, validate potency claims for enforcement, as we were just speaking about, provide contaminant testing when necessary, example, pesticides, heavy metal, etc., assistant in method development and standardization, provide surveillance and investigation support. The laboratory is in possession of all necessary equipment and has submitted a position description to hire an analytical chemist to assist in building environmental testing capacity. The laboratory plans to complete its relocation this year and then will begin onboarding environmental testing equipment, staffing, and training. And as I said before, DSC and I, as well as the Lieutenant Governor's Office, will be working concurrently so that we can actually get them licensed and up and running as soon as possible.
Thank you. Thank you. And I know. So, just out of curiosity, when we confiscate, how we just get rid of, dispose?
I wouldn't want to tell you where we maintain it.
No, you don't want to tell me where?
Yes.
We're disposing, right?
What we do is once we bring them to the hearing, we would then take action to dispose. If you notice in my testimony, I did say that the bill, we did ask that we create some sort of clear guidance as to the confiscation and disposal of the product, because I think that making that clear in the legislation would be an important aspect of this process.
Thank you, Senator Franklin Johnson. You're recognized for your 4 minutes.
Good afternoon. Thank you very much, Mr. Chair. Good afternoon to the testifiers. Good afternoon to the colleagues, viewing and listening audience. You know, this bill is well needed, but what bothers me the most about what's going on with these candies and Cheetos and that, it's trickery. It's a very dangerous game to our young children. You could easily go into the store with your child and you tell your child, pick up a bag of Cheetos, and if you're not paying attention, your child picking up a bag of hemp. And you as a parent, if you're not aware of this, you're going to pay for that product. Because when you see the pictures that we showed on the screen there, it's a hard take to pick out if it's Fruit of the Looms, if it's the fiery, what you call them? Fruit Loops. I mean, French fries and I mean, you name it. I'm so thankful I don't have no young child, but I have grandchildren. So they're at risk. Because if parents are not paying attention closely, a lot of times you say, "Man, go and get a bag of chips." You don't look at what a child bringing. You see this orange bag and it said Cheetos, and you say, "Okay, the child got the Cheetos. I'm paying for the Cheetos." But you ain't paying for Cheetos. You're paying for something that's going to be very harmful to your child, that could affect that child's entire life. Not just that one day. Because a lot of folks ain't every one of us are make up the same. And some are very fragile, and only God knows what this could do to some of these children that could just put them to a spin for the rest of their life. And I appreciate what Mr. Howell said, that this measure starts the ball, but it doesn't complete it, because the education part of it is so important. And my question to the Commissioner of Health, beyond just us picking the stuff up, what resources is needed, or do you have resources to start getting into the schools and educating, you know, people about this, especially parents?
Thank you for that question. We actually already go into the schools. We have a program coming out of MCH.
Yeah.
We do have a program coming out of the Maternal Child Health Division. Also, actually just now received a grant that MCH will be working alongside Behavioral Health. And like I said, Deputy Commissioner Steele is not here, but that grant actually allows for us to go back into the schools even more. So what we're doing is requesting access for funding for more therapists to actually be into the schools and working along the students so that they can actually teach. Because it's not just the therapists going into the schools, but it's also teaching the staff members, the teachers, to what to look for, because that's critical as well. We did have an incident right after COVID where we had students actually consuming edibles, and at that point in time, that's one of the reasons we started our intervention school-wise. So we go into schools at least weekly to discuss these issues with the students, parents, and staff.
What about communication with human service? There are those that at the first of the month, you go in the store and you see the cart full of these things. How are we communicating with those parents, especially, who get their stamps, or whatever you call it?
Food stamps?
Yeah, food stamps that go in and purchase, because if they're, again, not paying attention, they'll put the whole thing in the cart and walk out with it, not knowing what to walk out with. So how are we making sure that this information gets to those families who, a lot of folks don't understand what's going on with these things, you know?
And let me just say, thank you for that, because we try to really think of every single thing and every single population we're supposed to touch bases with. So of course we go into schools, we go into Head Starts, and that's one of the areas, of course, we'll touch those individuals. But at the same time, I think that just rethinking what we're doing and how we can actually get into different areas. And one of the things, of course, is our social media, as well as our website, and how we can actually get to those individuals who have younger kids that are willing to listen, but to do it in a creative way that they want to really listen to what we have to say. And PTA, of course, is one of the other areas or zones that we will be going into.
And then if I may wrap up on this, go ahead, Mr.
Go ahead.
May I? Horace Graham, Assistant Commissioner, Department of Licensing and Consumer Affairs. I'd just like to also add to what Commissioner Encarnacion, as one of our partners, have articulated. The Department of Licensing and Consumer Affairs, working very closely together with the OCR. OCR has crafted a presentation, slide decks, and they've been going into the schools, meeting with school administrators and the school teachers, etc., notifying them very clearly about the risks that's involved. It's not just sort of one thing that's happening. There's a multi-pronged approach that's actively going forward and trying to educate the public on these matters.
And I think you kind of touched on my last question. I want to find out what kind of coordination DLCA, VIPD, DOH, and the Health Commission has working together as far as the enforcement segment of this piece of legislation, or the enforcement section of these type of candies just being out there. How are you guys working together? If you have that working relationship, and if not, if you plan to do it, because it's going to be needed, because there's no one person going to solve this problem here.
I'll start and I'll turn it over to AC. But I have to tell you that we're all on the cannabis, well, both the cannabis and the hemp board together. And I think that under the leadership of we will definitely continue working together, finding areas for regulation, as well as deploying into the field and holding everyone accountable that should be held accountable.
Assistant Commissioner Graham, Department of Licensing and Consumer Affairs. It's almost like a kumbaya moment here, because literally what we're saying is that we took this very seriously. No one that I've spoken to, Senator, has felt that this is not a serious issue, especially because of the risks to public health and to our younger, most vulnerable population. The Department of Licensing and Consumer Affairs works very, very closely with the Department of Health presently as a team. Our enforcement units work very closely together at every instance where we have done any sort of embargo or seizure or investigation. We have done most of the times jointly. We've had, within the Hemp Commission, ongoing conversations. The DLCA, working together with the Hemp Commission, have, even before the legislation, worked to sort of transition a lot of the guidance and permitting and verification to the Hemp Commission. That conversation is ongoing, and so this legislation really bolsters and supports, and it's clear that this is the direction that we need to go, and I wholeheartedly support what this legislation is seeking to accomplish.
Thank you very much. I want to say thank you to the sponsor of this piece of legislation, and what I want to say is there is no such thing as a perfect bill, but what you do with a piece of measure like this is you continue amending and adding on to it to perfect it. So how it starts is not how it's going to finish. So, you know, I heard of all the amendments that need to happen, and we welcome that. But we need to get it started, because that's the only way we're going to start adding on and doing whatever else need to do. And if funding needed, come back to the legislature and see where we can fund, especially what Mr. Howell is speaking about, because sometimes it will need that funding. So definitely appreciate and say thanks to the sponsor. Mr. Chair, Department of Health Assistant Commissioner wants to say something else, and he'll do it at his time. He got a lot of time.
Just wanted to add, we've talked about prevention, and we've talked about enforcement, and thus far the team has only been able to remove the products out of circulation. However, what this bill does is establishes a fine. So it serves as a deterrent, could serve as a deterrent to folks engaging in this activity. And please make sure that you know that we supported Act 8688, and we support the hemp, the appropriate use of hemp, and its economic advantages.
Thank you. Commissioner Encarnacion, Mr. Graham, AC Santos, Attorney General Rhea. Just like I said in the first round this morning, we don't have no manufacturing company here for these things. So our federal partners really have to work with us. I think we need to start. I don't know, y'all could correct me. Like the good senator said, I seem like I have a lot of time. We ain't got much. Because time is of the essence when our children are being opened up to these type of dangers. First round we had about guns, now we hear about candy, which is dangerous. I mean, hemp products. How is our federal partners playing a role in this? I don't want to say I guess prevention would be the term to use, and enforcement at the same time.
Thank you, Senator. Assistant Commissioner Santos. We have had events before where we've been called in from our federal partners for these shipments coming in. We've teamed up with our partners with the Department of Licensing and Consumer Affairs to investigate those situations right here at our ports. So we definitely have a good communication with them and also with our local partners as well.
And the point I bring up is because even before they get to the shelf, they should be taken away. Yeah. You know what I mean? Don't even leave the ports. Like, before you get to the shelf, you know, I don't know. Maybe there's something we ain't getting here. If it's legal to get to the shelf first, I don't know. But that's why we're here to try to fix that. But before you get to the shelf, it should be taken away.
Yeah, Senator, the Department of Licensing and Consumer Affairs have worked very, very closely with CBP in terms of, you understand there's some interdiction opportunities that's there when certain products come in. I'd like Director Francis to kind of highlight a little bit of that interaction. That engagement has been really, really fruitful. And I believe what's happening in this piece of legislation actually adds teeth to that. Can you imagine that the federal partners, recognizing the Farm Bill's broad allowances, have been sort of careful in restricting some of these items? This piece of legislation that says it will be illegal to be able to possess and or bring in those type of intoxicating cannabinoids would do a major boon in helping us advance our collaborative efforts. Director Francis, if you may.
Sure, if you had me. Wilbur Francis, Director of Enforcement. As AC Graham mentioned, we do work closely. AC and Graham and Santos mentioned, we do work closely with our federal partners. As of late as yesterday, we were discussing a concept to be able to address this on a larger scale, number one. Number two, I also learned that because of our hemp terms and conditions that we've shared with them and the continued conversations that we've been having, their intel department has begun prohibiting began seizing products from coming through. Right now, what they're experiencing more on a larger scale is folks are now getting hip to that, and they're sending it through other means to be able to get that to pass, recognizing that the feds are stopping one thing but allowing the next. So we're always playing catch up, and right now we just do our best to stay on the tails of whatever we have.
Thank you.
Lewis, may I speak, please? This is Rhea Richard St. Thomas.
All right, go. You recognize, and then I'll recognize Mr. Executive Director Howell.
I want to correct myself. I apologize to Ms. Moorhead. I said in my testimony that she was present here, and I'm so sorry. I really thought I mistook her for somebody else, so I apologize for that. I just want to share that is why we had the Hemp Commission when we first reorganized. We had the foresight to include the director of the Port Authority, and he does have a representative in the form of Mr. Jerome Sheridan, who is the airport manager. And I also want to add that one of the things that we will put on the agenda is doing, and for discussion for one of our next meetings, would be doing outreach and education. It is very important because when I saw those Cheetos, those spicy Cheetos, I had I was taken aback because my grandchildren, my one grandson was buying those things and eating them. And I mean, it looks as if it was addictive because he just kept wanting to buy this thing all the time. So we really do have to, and I didn't know it was a dangerous product. So we do have to develop a strategy. The commission is going to take that on as a strategy to get out into the community to warn not only our children, but also our seniors in our community about the dangers of some of these products. Thank you.
Thank you. Senator Fonseca, you're recognized for your 4 minutes.
Yes, thank you. Thank you, Mr. Chair. And I too support. Yes, thank you. I too support Bill number 36-0105. Like the senator from Frederickstead said, no bill is a perfect bill. Most of the testifiers here, I think other than the Attorney General, came out in support of this bill. And so it's something that I think we need to have, specifically the THCA products, like the flowers, the patches, and the eligibles are promoted as safe for children and elderly, but they vary widely in potency, and of course they're not regulated. They may contain pesticides, molds, or other residual solvent. With the Office of Cannabis Regulation testimony, they were in support of the bill, but they questioned the bill did not designate a specific agency responsible for enforcement. So I have a question for the Assistant Commissioner of License and Consumer Affairs. Cannabis have enforcement officers on staff right now, the Office of Cannabis?
Horace Graham, Assistant Commissioner, Department of Licensing and Consumer Affairs. Senator, yes, the OCR, Office of Cannabis Regulation, do have enforcement officers presently.
Okay, so I guess I'll ask you for them. So what is the gray area with who is responsible for enforcement? This, to me, would seem to be the Office of Cannabis Regulation.
Well, it's not a gray area in the sense that the bill, I think, addresses the fact that the Hemp Commission would bear responsibility for generally for the area of hemp-related activities. What we are testifying to today is saying that we recognize that the multiplicity of agencies that have worked together in this area before and have the capacity to assist in enforcement should be an added element to the bill that clearly says which agencies, or we have identified our agencies as functioning jointly to be able to
Okay, thank you,
regulate.
thank you. We have to move on. Okay, so regarding the banning of the Delta 8 and the Delta 10, those are sold under the assumption that they're legal because they are derived from the hemp. And of course, some states are moving to restrict it. And with this bill, the Virgin Islands would join that. That's one of the reasons why I fully support this. But now, I wanted to go back to you, Assistant Commissioner Graham, specifically on the dispensaries, because a question came up on the dispensaries. And my research shows that, and correct me if I'm wrong, there's 2 dispensaries that have been approved, Virgin Abyss on St. John and Healthy Alternatives on St. John. Are there other dispensaries that have been approved?
Senator, I'm not sure the source of that. I'll be very cautious in putting that out. I do not know
and
that
then
there
my
are any
research,
dispensaries.
yeah, I got you.
that
You
have
said you're
been-
not sure, so that's the answer. Sorry for interrupting you, but not sure is an answer. And then there's no medical cannabis testing lab have been approved or licensed. The commissioner mentioned a lab which can do the testing, but as far as the medical cannabis lab, there's none that's been approved. Is that the correct information?
It would be the same, if I may, this is Commissioner Canasian. It would actually be the same lab. It's a certified public health lab, and that's one of the labs that we know we're looking at, if I may continue, Senator, that we're looking at. So that has actually been certified and can Right now, we're in the process of moving the lab from one area to the next once that's moved, which we're working very hard to get that done. Then we could build upon the testing.
Okay, and Mr. Chair, if I can just briefly wrap up. And so I congratulate you on the urgency and the attention by the Commissioner of the Health being so actively involved. I know that, you know, some action is going to get done with this Office of Cannabis Regulations. But to answer the question specifically because it came up, right now it's still illegal to purchase the cannabis in the territory, or is it legal? Because that is a point of clarification. I want to make sure that it's clear.
Senator Horace Graham, Assistant Commissioner, Department of Licensing and Consumer Affairs. We do not have any licensed dispensaries at this time. And so, but yes, we don't have any licensed dispensaries at this time, so that the purchase of cannabis is not yet available for the public.
Okay, so you hear that? I mean, ain't legal yet. That's what I mean. Thank you, Mr. Chair, for the time.
Thank you,
Chair?
Senator Fonseca. You may respond, Commissioner.
No, I really wanted to go back a little bit because I don't want a misconception in the community in terms of purchasing Cheetos or any of the other products that we've shown. It's important to note that the education and the attention given to what you're purchasing is really what's needed. Because Cheetos, a lot of children, a lot of adults like Cheetos. So we're not saying don't buy Cheetos or not to buy any of the other products that we showed, but to make sure you're taking the time to read and scrutinize exactly what you're purchasing so that you, just like any other food, so that you can actually make sure that you're giving your loved ones a safe product.
Mr. Harley wanted to weigh in on this.
Yeah.
What's your name on the record?
Yeah, Dwayne Howell, Executive Director, Arch Institute. To that very point is that Arch have been investing a lot of time in merchant education because we realize that compliance is not the greatest. And especially on the St. Thomas, St. John district, merchants just don't comply. This is just the reality. And making sure that merchants and their employees understand that while it is technically legal to sell CBD products to anybody, there's some ethical principles that they should have to don't sell to minors, right? And so we've been trying to push that, where that, you know, you don't sell to minors. Also, it's for the most part, I would say that these products aren't just in the open style. They're pretty segregated. So it's not so easy just to slip up and just mistakenly take one of these items. They're kind of segregated. But merchant education is critical at this point, even as you asked about now, right? What do we do now? And the answer now is really continuing to do merchant education so that they understand the implications.
Thank you, Mr. Harley. How about with Howell? How about us tell the merchant, don't put it in your store at all?
That's a different.
That's AC Commissioner Malloy. Go ahead.
Good afternoon again, Assistant Commissioner Ruben Malloy, Department of Health. I think we need to clarify some issues. The 2018 hemp farm law allowed for the use of hemp, which is defined as equal to or less than 3% 0.3% THC. That is hemp. Cannabis is above 0.3% THC. There's a big difference. Hemp is not authorized for human consumption. The Act 8680 in the territory authorized the use of cannabis above the 0.3% for medical use and recreational use. So, and in addition, what is being exploited here by those people who are selling, who are put under the guise of it being hemp, is that the 2018 law addressed the natural growing. It did not address the synthetic, which is what we're talking about here. So we're talking about something that is unregulated, unapproved by all. So this bill specifically deals with the Delta 6, Delta 8, Delta 10, and not the synthetic and semi-synthetic versions of hemp. So I just wanted to make that clear. Hemp, cannabis, naturally, not synthetic. What is legal and what isn't.
Thank you. Senator Milton Potter, you're recognized for your 4 minutes.
Thank you very much, Mr. Chair. Good afternoon, colleagues. Especially good afternoon to the testifiers who are before us here today. I wanted to ask the Commissioner of Health, or maybe the Assistant Commissioner of DLCA, if we have situations, and just in talking about educating retailers and educating the general public, have we had situations where juveniles entered a store, purchased a product, got sick, and it required some intervention from the Department of Health Enforcement folks or DLCA? Is this something that has happened on a local basis?
This is Commissioner Kennison. I'll begin. We spoke about the fact that right after COVID, we actually had an incident where some of the items are actually being manufactured and sold here within the territory. And we actually had to intervene. We had to do a lot of education was completed in terms of educating the students, the teachers, the principals. Everyone needed to be re-educated, as well as family members. So we occasionally see bumps and bruises in terms of how these things are actually consumed. And so this is one of the reasons why we want to continue the education process. And prior to you coming in, we actually spoke about the education continuing on a daily basis, weekly basis, at the school systems with the help of MCH, Maternal and Child Health Division within the Department of Health, as well as our Psychiatric Division or Behavioral Health Division within the Department of Health.
I know you have cookies and these edibles that are not necessarily packaged and, and all of that, right? I know that, to my knowledge, has been the source of some of the problems, some of the health challenges that we've seen in this community. So, where are those products being sold?
I'll pass
to the
it
best
over
of
to you.
They are.
Question, can you repeat that? Somehow I didn't get the detail.
No, I was talking about those edibles that, to my knowledge, we have seen the problems that we have experienced with young people ingesting some of these edibles that are laced with whatever whatever the term is, the THC 9 or whatever. We are seeing the problems with those types of edibles more so than these packaged products that look like Cheetos and all of that. My question is, where are these, or who is manufacturing and selling these cookies that our children seem to be ingesting, more frequently and more often? And is there a role for DLCA or the Department of Health with regards to just monitoring and enforcing, enforcing the laws?
Right. Senator Horace Graham, Assistant Commissioner. Specific to the question, I don't know of any specific locations where the edibles are being manufactured or sold. In order for them to do so, they would require having licenses with the Department of Licensing and Consumer Affairs. But we do know that the effects of consumption has been known to impact some of our youth within our school systems. I know VIPD has had to respond to some of those. I don't have a specific location. Some of the concerns may have been that these kids may have obtained it from home, and so I don't have a specific place that I am aware of that's actually manufacturing and distributing those types of
if I may.
commodities.
Wilbur Francis, Director of Enforcement. To answer your question specifically, the reports that we've gotten with regards to individuals, these minors consuming these products, to the best of our knowledge, they are coming from folks who are making them in their own house and carrying them to school and sharing them out with other kids at school. That's the reports that we've gotten from the hospital, as well as what has been mentioned by Virgin Islands Police Department officers responding to cases.
Can I also?
I appreciate the feedback on that. I mean, I know that I have heard of students talking about purchasing these items, but I guess that's something for you and your investigation team to delve into. Just my final question, I know my time was called, and I wanted to really talk about data when it comes to the U.S. Virgin Islands. I know we spoke about, we cited 2,300 poison control calls nationwide. What's the rate per capita when you're looking at other household products, medications, or alcohol? Have we been able to zero in on, when you're talking about poison control calls nationwide, have we been able to zero in on those products versus, you know, the medications or alcohol?
Senator, this is Commissioner Canasiung, if I may. I think that's one of the things that I could ensure that our our Division of Epidemiology takes a hold on and connect with the poison control and make sure that we actually pull some of those data. I can't say we have that data on hand, but it's something that we can actually do some research for and get back to you as soon as possible.
Okay, so we don't really have local statistics on these things. That's really my point. Most of the data that we look at and we evaluate is national data. But when it comes to how is it specifically impacting us, you know, we don't have those numbers. So I think that is an area where we fall short, not just the Department of Health, but just data in general. So that we can be more practical and specific in terms of the laws and rules that we implement here in the territory.
If I may. Dwayne Howell, Arch Institute. When this issue became an emergent threat, we actually published infographics because we did some key informant interviews and focus groups on the issue. And as was stated, students reported that they either was making the products themselves or they were buying the products from people who are making it in their homes. So that's to answer you specifically, Senator Potter. In terms of data, there is data. The data is just not in one place, but one place that has data is CERC. And CERC do have some of this data that you're talking about. And we capture core measures data and a modified core measures data we capture each year as well. In addition, Department of Health is working on YRBS right now, and I think that should be published soon, right?
We actually had YRDS and the youth surveillance survey, and we actually conducted that earlier this year. And in the next month, we're working with education again to start another round of YRDS evaluations. So you'll be hearing about that shortly.
Good, thank you. And Commissioner, before I go to...
Excuse me, Mr. Chair, may I add something? This is Dr. Sims St. Thomas. Look at your face, you forgot about it.
Go ahead, Dr. Sims.
Thank you so much. I just wanted to add, and it was really to Senator Potter's point, that yes, some of those were being made at home. We're talking brownies, cookies, and those were the episodes we were seeing. But when it comes to the education component is all-inclusive. It does not delineate between hemp and the deltas and marijuana and the seed. It's all-inclusive because it is mind and physical body altering, period. So the Department of Health stance is for everyone. It's not just the children, don't do it, don't eat it. It's like when we had the abstinence discussion decades ago, right? That became abstinence plus education. It is what happens to you. Because with edibles, you have something like a cookie or brownie. It's not going to affect you as soon as you swallow. That goes through your digestive system. So for a lot of young people who are not thinking, it's like, okay, well, nothing is happening right now, so I need to just bag this whole thing. It happens to adults too, like, let's be real. So the real discussions have to happen from everywhere, and I'm glad that the Hemp Commission is like, we're gonna start education, because that has to come from every side and attack all at once. And that's a leveled education. It cannot be hemp and weed and marijuana. It's all-inclusive discussions around it, yeah.
So Dr. Sims, while you graciously took the mic, let me ask this question here. In your education campaign, I think one of the things, we had a lot of information that was said here in this short space of time today. I'm asking you and the team, you know, I know the commissioner is busy, but you and the team along with education and so forth. I think we've seen some pictures here and we have a lot of information and data that I think at different intervals of the school year, we could interject some different flyers and pamphlets and things to go home so parents could see these different pictures and different things and what to look out for. I know, you know, the commissioner has her medical degree. We could lean on to find out side effects parents could look at and so forth. Sometimes I wonder, sometimes just being truthfully honest, like, every time I drive by, I see a young person like having some issues, like a mental breakdown, and I wonder what happened. So maybe all of this is a culmination, or a little part of it. I really don't know. You know, my heart goes out to them. But I'm just saying, while we're regulating and educating campaign, let's make sure parents have all this information. And to the DC from agriculture, yes, for even our seniors who grandparents were, you know, picking up these kids in the afternoon or whatever. Let's make sure that all the information is out there.
In various ways.
Whatever means of communication we have.
Understood.
Thank you. Senator Clifford. Sorry, Senator Novell. E. Francis Jr., you're recognized for your 4 minutes.
Thank you very much, Mr. Chair. Good afternoon to everyone. Commissioner, how are you doing? My condolences again.
Thank you. Thank you very much.
Is it okay? You're still in mourning, huh? You okay?
Yeah, I'm fine. Thank you.
Very well. Good afternoon. Thank you all for your testimonies. And I liked the fact that you took the time to really put some research into the testimony here that was submitted. So we truly appreciate that. I also want to commend the bill sponsor on this piece of legislation. It's good legislation. It's timely and certainly necessary. So I want to commend him and his team for putting forth this piece of legislation. To the commission, have you completed the rules and regulation yet in regards to hemp?
Chief Deputy Attorney General Ian Clement, the rules and regulations are in draft form, but the passage of this bill would go a long way of helping me to refine those rules, and hopefully we'll get them published soon.
Okay, any timeline in which we're moving towards getting this? Because we moved this hemp legislation for quite some time now, and we're hoping by now that the rules and regulations would have been in place. So any timeline set to be able to get this implemented?
Well, maybe by the end of the year, but I would say that because the draft rules in them talk about Delta 8 and some of these other compounds, if they're banned, it's going to be heavily revised. So how this legislation is amended and finally put into place will have a great effect on what the Commission's rules and regulations state, especially the fact that there will be a definition of hemp and these compounds will be excluded from that. So There may be a reconfiguration of the entire scheme, but it really depends on how this legislation is put forth.
Okay, very well. And the Attorney General's office, I heard your discussion in respect to some of the, I guess, code conflation of some of the measures that's attempted to be moved here today, but you generally in support of it, correct?
Yes, generally. And Acting Deputy Attorney General Patricia Lynn Pryor, we are in support of the measure itself. Our position was that we weren't taking a position right now just because we felt like some of those things needed to be defined and fleshed out and make sure that it is a bill that can be adequately enforced. I will just mention briefly that Assistant Commissioner Santos brought up some other states that have enacted similar bills. Kentucky was one of them. I was involved in that process over the years, and I think one of the things we want to be really cautious of is being too specific about what we're outlawing here.
Yeah.
Because every time that a synthetic cannabinoid is produced and outlawed, someone will create another one. And
Yes.
so we want to make it general enough that we are able to address all of the synthetic marijuana products that are out there.
Yeah, we'll certainly make the necessary tweaks as we move forward, but I think it's so important that we at least ensure the public safety, the safety of our children in this regard. I think that when we talk about life and safety, that is more important to me than anything else in respect to this. The adjustments can be made. We'll take it up to the various appeal systems, but we got to be able to save life on this measure. So for me, I think that enforcement will be the key to this whole issue. We're going to always have bad actors wherever we go, and we need to ensure that we're enforcing. And bad actors are always lurking. They're always lurking, waiting for that opportunity to be able to make their money. And the only way we're going to be able to make examples of them is for us to do enforcement and then show the community, show the public, what's happening here throughout. So far, have we determined, I don't know if the Department of Health, in terms of the addiction, or what are we seeing in terms of the level of THC that may be involved in some of this chemical used in these what you call maybe fake Cheetos or fake instrument that they're using now to place these THC in? Is it highly addictive?
More so than addictive, I think that what we're looking at is the signs and symptoms that we're seeing. One of them is psychosis. And then, of course, I have a list of symptoms, and I have to say that AC Malloy has been really beneficial in reference to what, but if you look at some of the symptoms that we're looking at, from a neurological and cognitive effect, dizziness, confusion, hallucination, cognitive impairment, we could go on and on, psychiatric and behavioral health, anxiety, paranoia, panic attacks, agitation, physical, psychological, physiological effects, nausea and vomiting, dry mouth. I'm just picking and choosing some of them. Pediatric specific risk, accidental ingestion, overdose potential, hospitalization, safety risk, chemical contamination, labeling inaccuracies, and we've spoken about that. Lack of testing right now that we're working on, undocumented adverse events, looking at, we spoke about some of them, and dizziness, confusion. But one of the things that I wanted to say is that this is not just focused on the youth. The elderly population can also be severely affected by this as well. Any vulnerable group, when exposed, can actually get hurt.
You talk about those of us that like Cheetos, right?
Love Cheetos, yes.
Yeah. Yeah, so my time was called? Was my time called?
30 seconds.
Okay. So, of course, yes is also important. But my colleague spoke about the fact, the Senate President spoke about the fact that, yes, we know of these structured package type of sale of this particular product is the unknowns, those that's then laced with marijuana, cannabis that's being sold to our students that's not properly packaged. How are we going to be able to address some of those concerns? Any thoughts and how we could look at those?
You go back to, like you said, enforcement, but enforcement is good, but I always go back to the behavioral factor. If we continue to say, okay, just enforcement, what are we doing to actually look at the cause? Causation is really important. So why is it, like you spoke before, parents are home actually concocting these things at home, and the children are bringing them to school? So what is the cause of that? So looking at this month is Suicide Prevention Month. We are going up into a suicide prevention campaign, educating, preventing. Those kind of things are really important. And you know, one of the things we don't speak about a lot is really and truly looking at the clergy and bringing them in a little bit more. And we speak about that ever so often, but that's one of the things that I think we need to think about. Looking at what the little children, are they going to school? Are they going to Sunday school? Are they hearing from a different perspective? So it's a global, and I think that Dr. Sims touched on it. We actually have to look at education from so many different facets and be able to do it in different ways. I have to tell you that Dr. Hunt and I spoke at someone that's working with the RT Park, and how do we actually produce change within the public health environment. And it's not just doing the same thing over and over again, but looking at it in different ways. How do we introduce education to different age groups? And it has to be in a way that they want to or are able to receive.
Okay, very well. My time has been called, but I agree that definitely enforcement and education is critical here. But I too would like to see where there is some, in terms of the penalty phase, that there's a gradual scale. Okay. That kind of, you know, your first offense is the $1,000, but I think the second and third offense should really be an escalation, you know, so that we can send a strong message and be able to hold individuals accountable. Thank you very much, Mr. Chair, for the time and the leniency.
Thank you. I know today, starting to what the previous senator said, sometime in the rules of licensing, they bill poor product. So, you know, one expired can is an offense, another expired thing. So, you know, so we got 10 pack of Cheetos, according to what the good senator says, at $10,000, right? Easily. You see? That's why we don't need them draconian measures and everybody stop the foolishness.
I got you.
Senator Clifford Joseph, you're recognized.
Yes, colleagues, I ask for your support of Bill number 36015, 0105. I'll be making the appropriate amendments in the Committee on Rules. But since it just came in, I'll go ahead and move it today. But when we start to talk about states that also banned intoxicating hemp, we got South Dakota, North Dakota, Wyoming, Arkansas, Alabama, Florida, Montana, Oklahoma, Rhode Island, and as Tuesday just passed, Texas have just got theirs through. So it's not something that we're doing outside that what's affecting other children around the mainland. So the Borden Islands is not a separation from the behaviors. So that's where we at. So.
All right. Colleagues, the Committee on Homeland Security, Justice, and Public Safety stands in recess for 2 minutes.
No, adjourned.
Good afternoon. Again, the Committee on Homeland Security, Justice, and Public Safety is out of recess. Before we move, colleagues, Commissioner Hussein Kanasiong asked for a special favor this afternoon, so we're going to indulge her. Commissioner? So, by way of Senator Maurice C. James.
Yes. I honestly actually was going to say this because I thought we were going to be able to close out, but I really wanted to take an opportunity to really honor one of our past servants to the community, and that is my sister, Rhea, or Tony Encarnacion. Today would have been her birthday, September 4th, and she actually meant not just a lot to the Department of Education and, of course, our Alpha Kappa Alpha sorority, but to our family and everyone in this Virgin Islands, St. Croix, St. Thomas, and St. John. Maurice was her classmate, Senator James was her classmate. So I really wanted to take the opportunity to identify and really wish her a very happy heavenly birthday today, coming from me and all members of her family.
Yes. Happy heavenly birthday.
Thank you so much for that opportunity.
Thank you. Though I think I'm hearing a motion somewhere. Motion, Senator Joseph.
Motion. I move amendment number 36-527 to bill number 36-0105 is amended as follows. In section 1, internal section 200A.
Motion, Senator Fonseca.
Thank you, Mr. Chair. Mr. Chair, I move amendment number 36-527 to bill number 36-0. I move to waive the reading of amendment number 36-527 to bill number 36-0105. I so move.
Moved by Senator Rhea Fonseca and seconded by Senator Franklin Johnson. Hearing no objection, so ordered.
I so move. Motion. Okay.
Moved by Senator Clifford Joseph, second by Senator Rhea Fonseca. Hearing no objection, so order as amended.
Motion.
Motion, Senator Joseph.
Mr. Chair, I move that bill number 36-0105 as amended be approved by the Committee on Homeland Security, Justice, and Public Safety and be forwarded to the Committee on Rules and Judiciary for further consideration. I so move.
No, you have to read a short part. Please restate the motion.
Let's get that clear. Yeah, this is here. Back on my motion. Over the one motion. Motion. Mr. Chair, I move that bill number 36-0105, as amended, approved by the Committee on Homeland Security, Justice, and Public Safety, and be forwarded to the Committee on Rules and Judiciary for further consideration. I do so move. Bill number 36-0112. No, that ain't.
Bill number 36-0105 has been properly moved by Senator Clifford Joseph and seconded by Senator Franklin Johnson. Roll call.
Senator Angel Bolkes Jr. Senator Bolkes absent. Senator Dwayne M. DeGraff. Senator DeGraff, yes. Senator Rhea Fonseca.
Yay.
Senator Fonseca, yay. Senator Kenneth L. Gittins. Senator Giddens, absent. Senator Franklin D. Johnson? Yes. Senator Johnson, yes. Senator Avery L. Lewis?
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph Sr.? Senator Joseph, yes. Mr. Chair, you have 5 yes, 2 absent.
Bill number 36-0105, an act amending Title 7 Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6 THC, Delta 8 THC, Delta 10 THC products in the Virgin Islands, and for other related purposes, has been properly moved, has been favorably voted upon in this committee and will be moved to the Rules and Judiciary for further vetting and discussion. This committee stands in recess for 2 minutes.
Committee of Homeland Security, Justice, and Public Safety is back on the record. Madam Clerk, can you please call up the bills in block number 2?
Block 2, 1 p.m. to 3:30 p.m. Bill number 36-0123, An act amending Title 20, Virgin Islands Code, Part 2, Chapter 43, Subchapter 1, Section 493, making it unlawful for a person who has 0.04% or more by weight of alcohol in his blood to operate a commercial motor vehicle, and making it unlawful for a person under the age of 21 years who has any detectable amount of alcohol in his blood to operate a motor vehicle. Sponsored by Senator Ray Fonseca. Invited testifiers, Honorable Mario M. Brooks, Commissioner, VI Police Department. Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice. Ms. Julie Smith Todman, Esquire, Chief Public Defender, VI Office of the Public Defender. Bill number 36-0136, an act amending Title 23, Virgin Islands Code, Chapter 17, Subchapter 2, by adding new sections 1331 through 1336, mandating lethal weapon training for security guards and investigators. Sponsored by Senator Avery Lewis. Invited testifiers, Honorable Mario M. Brooks, Commissioner, VI Police Department. Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice. Mr. Gleaston E. McIntosh, Executive Director, VI Peace Officer Standards and Training. Mr. Chair, that ends Block 2 of the agenda.
Who speaks to this bill? Bill number 36-0123.
I do, Mr. Chair.
Please recognize.
Thank you. Thank you, Mr. Chairman. Colleagues, I now present for your consideration Bill number 36-0123, which amends Title 20, Virgin Islands Code, Section 493, to strengthen our laws against impaired driving, particularly for individuals operating commercial motor vehicles on our roads. Impaired driving dramatically increases crash risk. Alcohol reduces reaction time. It impairs judgment and it distorts your perception. All these are critical for safe driving. Thousands of fatalities occur due to impaired driving. Bill number 0123 aims to prevent tragedies before they happen. This bill makes it unlawful for any person with a blood alcohol content of 0.04% or greater to operate a commercial vehicle. These vehicles, whether carrying passengers, heavy cargo, or hazardous materials, pose heightened risk on our highways. Even small amounts of alcohol impairs judgment, reaction time, and coordination. And when combined with the size and weight of commercial vehicles, the consequences can be catastrophic. Thank you. By setting a clear standard, we align the Virgin Islands with federal safety thresholds and make proactive steps to prevent and protect both drivers and the public. Through Amendment 36-516, we listened to communities' concern and made important changes. The provision that would have suspended licenses for drivers under age 21 will be removed by this amendment, and instead we establish a system of graduated penalties for commercial drivers convicted of operating with a blood alcohol content of 0.04% or higher. Currently, the Virgin Islands law, a first conviction for driving while intoxicated is classified as a misdemeanor, punishable by up to 1 year of imprisonment or fine of not less than $500 or $700 if the offense involves an accident or both. Mr. Chairman, the additional penalties I'm about to highlight would apply specifically to commercial motor vehicle operators who are convicted of drinking and driving. These penalties would be imposed in addition to those already on the books. Colleagues, we believe that stricter consequences are warranted for individuals operating these large vehicles. I respectfully ask for your support of Bill number 36-123 as amended by the proposed amendment number 36-516. Thank you so kindly, Mr. Chairman.
Thank you, Mr. Senator Fonseca. Who speaks to the bill number 36-0136?
That would be me, Mr. Chairman.
You recognize Senator Avery Lewis.
Good afternoon, colleagues and members of this community. Testifiers here this afternoon. I come before you today humbly, but with confidence to introduce the bill that I believe is critical for the safety and professionalism of private security in the United States Virgin Islands. This legislation, Bill number 36-0136, Lethal Weapon Training Bill for Security Guards and Investigators Act, is designed to ensure that any privately employed agent who carries a lethal weapon in the course of their duties is properly trained, certified, and accountable. It is not about limiting opportunities for employment, nor is it about adding unnecessary bureaucracy. Rather, it is about protecting our communities, our citizens, and our law-abiding security professionals. Under this bill, all privately employed agents carrying lethal weapons will complete a specialized training program administered or approved by the Commissioner of the Virgin Islands Police Department. The program will cover handling lethal weapons safely, understanding the law, and protecting the right of citizens. Candidates will undergo appropriate screening for physical and psychological fitness, ensuring that only qualified individuals are entrusted with lethal force. Certification will be issued, maintained, and monitored to ensure continued competency and good standing, including renewal requirements every 5 years. Retired police officers and active police officers already trained will receive waivers, respecting their prior experience while maintaining public safety standards. This is a win for the USVI. For our citizens, it ensures that anyone carrying a lethal weapon in a private capacity has the knowledge, skills, and accountability to do so safely. For security professionals, it raises professional standards, credibility, and trust. For law enforcement and regulators, it provides a clear framework for training, certification, and oversight without overstepping or replacing the vital work of the police department. I want to be very clear. This bill does not diminish, circumvent, or replace existing law enforcement authority. It strengthens it by ensuring that private agents who carry lethal weapons operate under consistent, accountable, and transparent standards. By enacting this bill, we are sending a strong message. The United States Virgin Islands values safety, professionalism, and accountability. We are making our communities safer while giving our private security sector the tools and structure they need to perform responsibly. I ask my colleagues to review this legislation thoughtfully, and I welcome your input. Together, we can ensure that the USVA continues to set the standard for safe, professional, and effective private security. I ask you humbly for your support on this bill. Thank you very much.
Thank you, Senator Avery Lewis. At this time, I will recognize the testifiers for bill number 36-0123. I guess start with you, Mr. Attorney General Gordon Rhea.
Good afternoon, Chairman Clifford Joseph, Committee on Homeland Security, Justice, and Public Safety members, other senators, legislative staff, and the listening and viewing audiences. I'm Attorney General Gordon Rhea. It's an honor and privilege to appear before you this morning. This afternoon. My mistake. The Department of Justice appreciates the opportunity to comment on bill number 36-0123. We've completed a preliminary review of the bill and offer the following comments. The bill seeks to amend Title 20 of the Virgin Islands Code, Part 2, Chapter 43, Subchapter I, Section 493, to make it unlawful for a person who has 0.04% or more by weight of alcohol in their blood to operate a commercial motor vehicle, and making it unlawful for a person under the age of 21 years who has any detectable amount of alcohol in their blood to operate a motor vehicle. While states work in tandem with the federal government to regulate the transportation of goods across the United States, the standards for commercial transportation are governed by federal law. The Commercial Motor Vehicle Act of 1986 was designed to enhance road safety by creating nationwide guidelines for the testing and licensing of commercial drivers. Additionally, the Act provided the legal framework for later regulations covering alcohol and controlled substance testing for employers and drivers, as well as federal laws limiting the blood alcohol concentration, or BAC, to 0.04% for commercial drivers. Although the testing and the disqualification requirements created as a result of the Commercial Motor Vehicle Act of 1986 and enforced by the Federal Motor Carrier Safety Administration do not specifically apply to U.S. territories, federal laws generally override conflicting state and territorial laws through federal supremacy, a legal principle established through the Supremacy Clause of the U.S. Constitution. Instead of engaging in a debate about which federal statutes are applicable to the VI through Section 3 of the Revised Organic Act of 1954, let us instead focus on what happens when local laws are compatible with federal legislation. Although states and territories often have the right to self-govern and make policies independent of external influence, particularly the federal government, jurisdictions often enact laws that align with federal regulations for a number of reasons. These reasons include avoiding conflict, ensuring fairness, and promoting unity. Because federal law is considered the supreme law of the United States, there is a legitimate interest in making sure territorial laws are not created in conflict with federal statutes, which prevail due to their supremacy. Additionally, by mirroring federal laws, states and territories can help guarantee citizens are treated consistently and fairly, regardless of their location, and reduce confusion by creating unified legal standards. Although there may be drawbacks to states and territories adopting laws that match federal laws, including the loss of autonomy and the fear of federal overreach, there is no real hindrances to amending the code to make it unlawful for a person with a BAC of 0.04% or higher to operate a commercial motor vehicle within the territory. In fact, there are a number of reasons, other than matching federal law, to enforce a stricter BAC for drivers of commercial vehicles, with enhanced public safety chief among them. Oftentimes, commercial vehicles are significantly larger and heavier than standard passenger cars. As a result, the potential to cause catastrophic damage, including severe injuries and death, with a commercial vehicle is greater. It's commonly understood that alcohol is a central nervous system depressant, which can slow down brain activity and impair a person's speech, vision, coordination, judgment, and reaction time, all of which are vital when operating a commercial vehicle. By reducing the BAC limit for commercial drivers, the territory can help protect the lives and property of its citizens. Similarly, all states have zero-tolerance laws for underage drivers, reducing the legal BAC for drivers under 21 to 0.02% or lower. The National Minimum Drinking Age Act of 1984 incentivized states to adopt a minimum drinking age of 21 and enforce these zero-tolerance laws by 1998 or risk losing federal highway funds. States had the autonomy to set the reduced BAC limits for drivers under 21 within their boundaries, leading to varying limits between 0.00 and 0.02%. The most common BAC limit for drivers under 21 is 0.02%, with more than 30 states electing it as their limit. The second most preferred BAC for drivers under 21 is 0.00%. There are no legal concerns with the legislature making it unlawful for anyone under the age of 21 to drive, operate, or be in physical control of a motor vehicle with a detectable amount of alcohol in their system. In fact, doing so makes the territory compliant with the federal standard. Should this legislature decide to approve Bill number 36-0123, the Virgin Islands Department of Justice stands ready to enforce these amendments to the law and prosecute violations. I thank the committee for allowing the Department of Justice to testify on Bill number 36-0123. This concludes my formal remarks, and I welcome any questions you may have. Thank you.
Thank you. Assistant Commissioner Santos.
Yes, good afternoon, Honorable Senator Clifford Joseph. On behalf of the Virgin Islands Police Department, I have Director Daphne O'Neill who will be providing testimony regarding this bill.
Go ahead.
Good afternoon to the Chair, the Honorable Clifford A. Joseph Sr., legislative body and staff, members of the VIPD team, and to the listening and viewing audience. My name is Daphne O'Neill, Director of the Office of Highway Safety for the United States Virgin Islands Police Department. I come before you on behalf of Police Commissioner Mario M. Brooks to discuss an act amending Title 20, Virgin Islands Code, Part 2, Chapter 43, Subchapter 1, Section 493, making it unlawful for a person who has 0.04% or more by weight of alcohol in their blood to operate a commercial vehicle, and making it unlawful for a person under the age of 21 years who has any detectable amount of alcohol in his blood to operate a motor vehicle. Thank you for the opportunity to testify on this matter. On behalf of the Virgin Islands Police Department, we respectfully submit the testimony in support of Bill number 36-0123, sponsored by Senator Ray Fonseca. This bill tightens two critical areas of impaired driving law. One, it adopts a low per se blood alcohol concentration, BAC, threshold for commercial motor vehicles operators. And two, it establishes a zero tolerance rule for drivers under the age of 21, any detectable alcohol. The VIPD supports the intent of the proposed bill addressing BAC limits for commercial vehicle drivers and younger drivers, and as an important step towards improving roadway safety. However, we respectfully recommend amending the bill as follows: to establish a zero BAC limit for commercial vehicle drivers. Given the heightened responsibility associated with operating commercial vehicles and the potential risks to public safety, adopting a zero tolerance policy will better protect all road users and align with best practices for preventing impaired driving related crashes. To establish a zero tolerance rule for drivers under age 18, any detectable alcohol, given that alcohol consumption is legal in the territory at age 18. The proposed penalty should be applied to drivers under 18. Between fiscal years 2020 and July 31st, 2025, a total of 453 drivers were involved in crashes following alcohol or drug use in the territory. The demographic analysis of these DUI drivers shows that 81.9% were males, and middle-aged older adults, 35 to 55 and older, were the demographic mostly charged with DUI offenses at 73.25%. The age group 16 to 20 made up 1.3% of the offenses. Alcohol impairment remains a meaningful factor in crashes in the territory. In fiscal year 2023, the territory recorded 2 fatalities resulting from driving under the influence. In fiscal year 2024, there was 1 DUI-related fatality, and thus far in fiscal year 2025, 1 has been recorded. The department already set goals to reduce impaired driving crashes, for example, using a combination of education, outreach, and high visibility enforcement to reduce impaired driving crashes 20 to 25% from the FY 2023 high figure of 101, and to decrease and maintain alcohol impaired driving fatalities to 0, showing both the problem scale and an institutional commitment to countermeasures. Adopting the recommended changes in Bill 36-0123 will provide law enforcement with clearer statutory tools to support these objectives. Territory level traffic data indicate modest improvements, but also underline the need for continued action. The National Highway Traffic Safety Administration, NHTSA, their data underscores the lethality of alcohol-impaired driving. NHTSA's analyses show thousands of deaths each year tied to alcohol-impaired crashes. Therefore, any action taken which reduces impairment on the road saves lives. Legislative action is one of the strongest tools available to protect the citizens and visitors in the territory. For commercial motor vehicle drivers, Title 49 CFR, Section 39.4 and Section 392.5 forbid the consumption of alcohol or being under the influence within 4 hours of operating a commercial vehicle. No one, regardless of age, should be operating a commercial vehicle while impaired from alcohol or any type of drug prescribed or over the counter. The USVI adopted this section with its Motor Carrier Assistance Program. This is consistent with national countermeasures. In fiscal year 2025, the VIPD and the Office of Highway Safety continued territory-wide impaired driving campaigns and high visibility enforcement, including sobriety checkpoints and public education, reinforcing the need for statutory alignment so that enforcement, prosecution, and prevention efforts can operate with maximum effect. In fiscal year 2023 to July 31st, 2025, the DUI arrests total 179. BAC reported cases were 55. BAC reported rate 30.7%. However, BAC not reported or refused were 124. The results show that almost 1/3 of DUI arrests had BAC results officially reported. The remaining 69.3% either had no BAC data reported or involved individuals who refused the testing. This gap underscores the ongoing challenges in obtaining consistent BAC documentation during DUI enforcement initiatives and further underscores the need for zero tolerance. Of these cases reported above, the analysis shows that the mean BAC level ranged from 0.136% lower level impairment to 0.249% high level impairment, indicating once more that zero tolerance should be the norm for the territory. The Office of Highway Safety plans during fiscal year 2023 to 2025 described impaired driving projects and listed enforcement initiatives implemented in partnership with VIPD. These are the local data points that VIPD relies upon when developing enforcement and prevention strategies. The territory recorded 1.4% decrease in total crashes in fiscal year 2024, a positive trend, but one that still leaves alcohol-impaired driving an actionable risk area identified in planning documents. We continue to emphasize high visibility enforcement during holiday periods and campaign months. For fiscal year 2025, the VIPD and Office of Highway Safety launched the Drive Sober or Get Pulled Over mobilizations and other outreach to coincide with summer and holiday periods. These mobilizations demonstrate ongoing enforcement activities and public education office efforts. Stronger laws will make these efforts more effective. Commercial vehicle operators operate larger, heavier vehicles that present exponentially higher risk to other road users in the event of a crash. Numerous jurisdictions and federal guidance for CMV safety recognize that impairment at lower BSCs can significantly degrade the complex, sustained attention and motor skills needed to operate commercial vehicles safely. Lowering the current statutory limit is a positive step towards improving roadway safety. However, as referenced earlier in the testimony, our ultimate goal should be to establish a zero-tolerance policy, thus requiring CMV drivers to have a 0.00 BAC while operating a vehicle. This measure will, A, provide VIPD with clear statutory authority to take action when CMV drivers exhibit any measurable impairment, and B, better protect passengers, pedestrians, cyclists, and other motorists by reducing the likelihood of high consequent crashes. The legal drinking age in the territory is 18 years old, and the driving age is 16. Although the amendment aims to impose strict consequences for younger, inexperienced drivers, this age group, 16 to 25, is not overrepresented in the local data on DUI crashes and arrests. Nevertheless, young drivers should be educated and deterred from developing the habit of driving while impaired. A zero-tolerance rule, any detectable alcohol for drivers under the legal drinking age is an evidence-based measure used in many U.S. states and territories that reduce underage, impaired driving, and help shift cultural norms around youth alcohol consumption and driving. The Office of Highway Safety's youth-oriented impaired driving outreach and the VIPD's enforcement of impaired driving among underage drinkers will be more effective when supported by a statutory zero-tolerance standard. In the territory, the older age groups, 25 to 55 and older, are the core groups of violators. Middle-aged and older adults, ages 35 to 55 and older, were the most affected groups, making up 73% of all DUI cases. These violators overwhelmingly male, 81%, with Black and Hispanic drivers leading the category for race and ethnicity. Lower CMV per se BAC and zero tolerance for younger drivers provide bright line statutory standards that simplify enforcement decisions, probable cause, testing thresholds, and strengthens prosecutorial cases where impairment contributed to a crash. Reduced allowable impairment for CMV operators will directly protect pedestrians, cyclists, and occupants of smaller vehicles. The statutory changes would align with the Office of Highway Safety's enforcement goals and the territory's highway safety plan objectives to reduce alcohol-impaired crashes and fatalities. This legislative action would make education, checkpoint activity, and high visibility enforcement more likely to change behavior and reduce recidivism. Even small reductions in impairment at the population level reduce crash risks. National research and Office of Highway local goals both indicate that combined strategies of strong laws, high visibility enforcement, and public education are necessary to reduce alcohol-impaired crashes and fatalities. Bill number 36-0123 strengthens the legal piece of that three-pronged approach. For the foregoing reasons, the Virgin Islands Police Department strongly supports Bill number 36-0123 with the proposed amendments, which will increase public safety by eliminating the presence of impaired CMV operators on our roads, protect young drivers and the public by setting a clear zero-tolerance standard for drivers under 18, strengthening the enforcement and prevention collaboration already active through VIPD and the Office of Highway Safety, and community partnerships to fulfill the territory's highway safety plan. We respectfully urge the committee to advance the amendments to Bill number 36-0123 with a favorable vote and final enactment. The department stands ready to assist the legislature with implementation details, training guidance for officers, standard operating procedures for CMV stops and testing, and public education messaging, so the law achieves the intended safety benefits as quickly and effectively as possible.
Thank you for your testimony. At this time, we'll receive testimony for Bill number 36-0136, starting with the Assistant Commissioner Santos.
Thank you, Mr. Chair. Mr. Chairman, distinguished members of the Senate, thank you for the opportunity to testify today in this matter. I am Sean Santos, Senior Assistant Police Commissioner of the Virgin Islands Police Department on behalf of Police Commissioner Myra Brooks. I submit this testimony in support of this bill, number 36-0136, an act amending Title 23 of VI Code, Chapter 17, Subchapter 2, by adding sections 1331 and 1336, mandating lethal weapon training for security guards and investigators. On behalf of the Virgin Islands Police Department, thank you for the opportunity to submit the testimony in support of this bill, which would require standardized mandatory lethal weapons and use of force training, initial certification, reoccurring requalification, de-escalation and reporting requirements for armed security guards and investigators in the Virgin Islands, is a public safety measure grounded in national evidence and best practices. The private security sector is large, operates widely in public spaces, and too often functions under inconsistent training and oversight. Requiring robust, standardized training will reduce the risk to the public and to the security officers themselves and to the communities they serve. Across the United States, there are more than 1 million security guards on duty every single day. In fact, they often outnumber sworn police officers. They stand guard on posts in shopping centers, hospitals, schools, airports, and government buildings. Many of them are the first line of defense when trouble arises. But unlike police officers who training is standardized and rigorous, the training of security guards varies widely from state to state, and in some places, it's shockingly minimal. That patchwork system has consequences. National studies and case reviews of shootings show that simply having a firearm does not mean someone is prepared to make a life or death decision in a split second. In fact, under stress, untrained individuals are more likely to freeze, make poor decisions, or escalate a situation instead of calming it. Research confirms that when security personnel receive robust training, especially scenario-based training that mimics real-world stress, their decision-making improves. They handle weapons more safely, and they use force more responsibly. We have seen too many examples nationally of armed guards who were put in difficult situations without the skills or judgment to handle them. That is a danger not just for the public, but also for the guards themselves. Passing this bill means we stop leaving it to chance. It means we set a clear standard. If you are going to carry a lethal weapon on behalf of the public, you must prove that you are competent, trained, and accountable. The specific requirements in Bill number 36-0136, initial certification, ongoing training, annual requalification, de-escalation, instruction, and mandatory reporting of incidents are exactly what national experts recommend. These steps aren't about making life harder for security officers. They're about giving them the tools they need to succeed and keeping the public safe at the same time. Some may worry about the cost of requiring more training, but the truth is the cost of not requiring it is far higher in lives lost, in injuries sustained, and in the liability that comes when preventable tragedies occur. By raising the standard now, we reduce those risks and create a professional security workforce that the public can trust. This bill doesn't just protect the public, it also protects the responsible security officers who want to do their jobs the right way. When they are properly trained, their professionalism shines through and they gain the confidence of the communities they serve. Mr. Chairman, Senators, Bill number 36-0136 is not just a legal amendment, it is a statement of values. It says, we will not leave the public safety to chance, and we will not arm individuals without ensuring they are fully prepared for that responsibility. For these reasons, we, the VIPD, respectfully and strongly urge you to pass this measure, and we thank you for your time and consideration, and we stand ready to answer your questions. Thank you.
Thank you, Assistant Commissioner Santos. Attorney General Gordon Rhea, for your testimony. You're recognized.
Good afternoon, Chairman Clifford Joseph, Committee on Homeland Security, Justice, and Public Safety members, other senators, legislative staff, and the listening and viewing audiences. I'm Attorney General Gordon Rhea. It's an honor and privilege to appear before you this afternoon. The Department of Justice appreciates the opportunity to comment on Bill number 36-0136. It's completed a preliminary review of the bill and offers the following comments. The stated purpose of Bill number 36-0136 is to amend Title 23 of the Virgin Islands Code, Chapter 17, subchapter II, by redesignating existing sections 131 and 132 as 1337 and 1338, respectively, and inserting new sections 1331 through 1336 to mandate lethal weapon training for security guards and investigators. Within the United States, states and territories have the authority to mandate lethal weapon training for security guards and other safety personnel by enacting laws and regulations requiring background checks, training programs, and instructor certification, among others, before they can carry a firearm while on duty. Because each state and territory has the autonomy to create its own laws, these laws and regulations can look different from jurisdiction to jurisdiction. There are, however, some common licensing requirements for armed security guards, including age requirements, background checks, fingerprinting, training, including firearm training, and recertification timelines. As presented, Bill number 36-0136 covers the basic framework for the education and training requirements for armed security guards, the powers and duties of the Commissioner of the Virgin Islands Police Department, the qualification to enroll in an improved training program, certification, and good standing. The proposed legislation also includes the fees for certification and licensing and applicable definitions. It does not, however, set any legal standards or key licensing requirements. The decision to codify lethal weapon training for security guards and investigators is a good one. The territory has a responsibility to ensure public safety and to regulate the use of force. By establishing uniform rules and policies for armed security guards, the Virgin Islands can do both. The Department of Justice supports Bill number 36-0144. With that said, however, I would consider moving proposed sections 8 and 9 to follow subsection 3, since each address the schools to be approved. I thank the committee for allowing the Department of Justice to testify on Bill number 36-0136, which we strongly support. This concludes my formal remarks, and I'd welcome any questions you may have.
Thank you for your testimony. Executive Director McIntosh, you're recognized for your testimony.
Good day, Honorable Senator Clifford A. Joseph Sr., Chairman of the Committee on Homeland Security, Justice, and Public Safety, distinguished members of the 36th Legislature, legislative staff, ladies and gentlemen in the chamber, members of the media, and our viewing and listening audience. My name is Gleston McIntosh Jr., and I serve as the Executive Director of the Peace Officer Standards and Training Council, also known as POST. It is both an honor and a privilege to provide testimony today in support of Bill number 36-0136, an act amending Title 23 of the Virgin Islands Code, Chapter 17, Subchapter 2, by adding new sections 1331 through 1336 to mandate lethal weapon training for private security guards and investigators. Importance of the bill. Private security professionals are often the first responders to incidents at businesses, schools, government facilities, and public events. They frequently encounter threats before police arrive and must make critical split-second decisions at the cost of lives. Currently, unlike sworn peace officers who undergo post-certified academy training, private investigators and security guards who carry firearms are not held to the same standards. This creates a gap that puts both officers and the public at risk. Bill number 36-0136 closes that gap by establishing mandatory training, certification programs, and lethal weapon handling, law enforcement practices, and protection of citizen rights under the administration and oversight of the Commissioner of Police. By mandating lethal weapon training, it will ensure weapons are handled safely and responsibly. It will reduce the likelihood of negligent discharge and unlawful use of firearms. It will provide security professionals with training in de-escalation, decision-making under stress, and constitutional protection. Increase public trust that armed private security officers are properly vetted, trained, and certified. Clarification on investigator definition. It's also important that the law clearly defines who an investigator is. Having a clear definition avoids confusion, supports proper enforcement, and keeps compliance and oversight consistent. Recommended training components. The training program to be administered under the Virgin Islands Police Department should include firearms proficiency and safety, proper firearms storage, and a post-approved firearms qualification course, use of force, de-escalation, force continuum, conflict resolution, decision-making under stress, crisis intervention, legal and ethical standards, local and federal laws, detention and arrest authority and liability awareness, scenario-based training to include active shooter response, workplace violence, crowd management, and coordinated response with VIPD. Life-saving skills is also important, like first aid, CPR, trauma response training. The inclusion of VIPD training division in oversight will ensure consistency, accountability, and ongoing compliance. Certification and continuing qualification. To maintain high standards, the legislation should require all firearms qualifications to ensure continued competency. A yearly refresher course in use of force and constitutional updates. And 8 hours of continual education annually is in situational awareness, community engagement, and professional ethics. Consideration of psychological and physical fitness screening to confirm readiness to safely carry a firearm. Role of law enforcement and implementation. The police commissioner and the training division must be directly involved in administering, monitoring, and enforcing training standards. Their leadership will guarantee proper certification, periodic review, and enforcement of compliance. Benefits to the territory. The passage of this legislation will enhance public safety by ensuring all armed private security guards and investigators are trained to professional standards, reduce liability exposure to private security agencies and government entities territory-wide, promote partnership between private security guards and law enforcement, improving coordination and response to public safety challenges, and align the Virgin Islands with national best practices for armed private security guards and investigators. In conclusion, Mr. Chairman and members of this committee, Bill number 36-0136 is both timely and essential. It strengthens accountability, closes dangerous training gaps, and ensures that anyone carrying a lethal weapon in the capacity of a private security guard or investigator is fully prepared, certified, and held to the highest standards of professionalism. On behalf of POST, I respectfully urge the legislature to make these amendments to the bill and provide the Virgin Islands Police Department and its training division with the necessary support to implement effectively. Thank you for the opportunity to provide testimony. I am available to answer any questions you may have.
Thank you for your testimony, Director McIntosh. At this time, we'll go to our my colleagues. The first, for a round of question, for a 4-minute round of question. We start with Senator Dwayne DeGraff.
Thank you, Mr. Chair. Good afternoon, colleagues. Good afternoon, testifier. I vote yes for both bills. 0.04. What is a national? Isn't 0.05 for the BAC, or it is 4 is the official standard now by law? Okay.
Attorney General Gordon Ray. Yes, the federal statute, the Commercial Motor Act the Commercial Motor Vehicle Act of 1986 states it as 0.04.
Okay.
Right, and that's the federal standard. I know that the proposed act locally has that same standard. And I think that's a good idea because there's a very good argument that the supremacy clause of the Constitution would require us to follow the same number, and that's why I suggested that.
Okay, and Commissioner VIPD, Assistant Commissioner, regarding to Bill number 36-0136, in regarding to the fee of $50. What's your take on that? I think it should be more than $50, but what's your take on that?
So, as far as the fee is concerned, you know, that's just a minimum, and we should be basing it based upon the licensure, because I think there should be some sort of a licensure and classification when we're dealing with these individuals come in for license. Because let's say, for instance, you have an individual who's coming to just be a certified security guard versus an armed security guard as well. So I just feel like that should be a minimum.
No, the fee said no more than $50.
Okay.
So I think when you take renewal more than $50, okay, so initial would be $150. Still, okay, I mean, it's much needed, so I do stand in full support both of these bills. Now, for Director O'Neill, in regards to the zero tolerance that you mentioned for under 21, then that's an amendment you gave to the sponsor of the bill?
It's a recommendation.
A recommendation, okay. So between 00 or 02?
That's what it is now federally, and we can...
Okay, yeah, put your name on the record, please.
I'm sorry. Daphne O'Neill, Director, Office of Highway Safety. It's 0.00 to 0.02. And I mean, given the size of our territory, our roads and everything, I think that zero tolerance should be considered.
No, I agree with you 100%. The only thing is, once you slam dunk a child, because that's a child, under 21, you have a child driving, you take and you slam dunk them, then we probably destroy the career a lot of times going forward. So not that it should be any less, but I think 00 to 0.2 we could all keep an eye on. So thank you for the time, Mr. Chair.
Okay, this question is for you, Ms. O'Neill. I'm looking at you, we're speaking about alcohol, and a while ago we were just speaking about cannabis in itself. So I don't see where, if we're talking about being fair and across the board, shouldn't it be alcohol and cannabis? Drugs, I mean, you mentioned prescription drugs, but I just want to make sure that controlled substance in the whole.
Daphne O'Neill, Office of Highway Safety. We can only go by what is on the books for us to follow. Impaired driving covers a whole gamut, whether you're impaired from recreational drugs or something like that. But if we can't enforce the penalties for recreational drugs, then we have to stay with what we can enforce. But maybe I should defer this question to Sergeant Joseph.
Sergeant Joseph, could you respond?
Arthur Joseph, Commander, Traffic Investigations Bureau. Senator Clifford Joseph, thank you for the question. Let me be crystal clear. Until you witness horrific, violent loss of a life at a scene of a crash, and you have to tell that parent at 2 o'clock in the morning that the child ain't coming home, you'll get a better sense of why, if you're operating a commercial vehicle and you're under any amount of alcohol, you are not going to be the victim. Everybody else will be. So when it comes to alcohol and commercial vehicle, I agree for 0, full stop. When it comes to marijuana, which is something you will also find in a lot of the commercial drivers' system, I agree that there should be zero. No amount of, even if it's recreational, DOT prohibits the use of marijuana on or off duty. They give you a limit of 0.04 for alcohol, but there's nothing precluding this territory from enacting zero, full stop. So if you want to protect our citizens and the business owners who allow these people to drive their vehicles, we must be responsible with the legislation that we purport. I don't know if that answers your question, but that's my position. That's the way I answer your question, sir.
Thank you for your response, Sergeant Joseph. I now recognize the mic of Senator Franklin Johnson.
Good afternoon. Thank you very much, Mr. Chair. Good afternoon to the testifiers and all. I want to stay on that line of questioning because I think Mr. O'Neill said that the percentage of accidents have been with older persons with DUI. Am I correct to say that?
Daphne O'Neill, Director of Office of Highway Safety. Yes, the older age drivers.
You know, I find that a little alarming in a way because the way how the young people are drinking today, I don't understand. But I find that a lot when you gave out those numbers. That was, for me, was a little alarming. I expected to see some higher numbers in younger drivers. And you're saying that younger drivers are not.
They're not overrepresented.
Oh. And now, Sergeant Joseph, you spoke a little bit about the cannabis or marijuana. What kind of a test would you do to determine? Because if I'm correct, and I could be wrong by far, marijuana stays a little longer in the system.
Yes, Senator.
Slow down. So an individual might have smoked maybe a couple of days ago. And he might have been working long and hard the whole day. And now he goes and do what type of a test? What type of test is there to prove that he was just smoking or he smoked 3 days ago?
There is no test that would tell you when he last smoked.
Yeah.
All the tests will indicate is that there's THC in the system. So Title 2493C of the Virgin Islands Code speaks directly to any person who has in his control, physical control, a motor vehicle in the territory shall be deemed to have given his consent to a chemical testing of his blood, breath, or urine for the purpose of determining the drug or alcoholic content. And so we already have the means to determine if an individual is under the influence. We can just simply merge that into the commercial drive CDL code. Because currently, I don't know if this body is aware, but the Bureau of Motor Vehicle is currently moving towards a CDL license program. In that program, the individuals must comply and will be educated about the use of alcohol and marijuana as CDL operators. And so once all those things come together and everybody is on the same page, I think it'll be in the best interest of everyone.
But you said under the influence. And again, my question still lies. What test is there? Let's just, for argument's sake, someone got in an accident.
Yes.
Officer pull up. You don't smell no marijuana. You don't smell no alcohol. It could just be neglect, right?
No. What happens in a situation when a crash occurs and you're treated by the hospital, we will then subpoena your results of what you were tested. They're going to test you because they can't treat you unless they know what's in your system. So we would subpoena that information, and that will tell us whether or not alcohol, cocaine, whatever is in your system, and we'll go from there.
You know.
But it doesn't, Senator, it does not tell us necessarily when you last smoke.
Your answer going on a slippery slope. Why I say your answer going on a slippery slope, you're making me go off topic here. Because
I'm sorry.
My nephew lost his life from a drunk driver. And
Time.
in the court, and I need to follow up. I need to, if I may, Mr. Chair.
You could take a minute, because we have to take a break for this.
Yeah, in the hearing, whatever took place in the hospital was not admissible. So the tests and stuff that they did to the young man was not admissible, and the entire case got thrown out. And that's why I say your response took me down in a very uncomfortable position, something that I sometimes want to just try and get over. But it's difficult hearing what you just said today and know what I experienced, because I went to court with my brother when he lost his son. So I'll leave this at that at the appropriate time. I'll support both measures. But thank you very much. Thank you very much, Mr. Chair.
Thank you, Senator Johnson. At this time, the committee stands in recess for 2 minutes. Committee is back on record. We now recognize Senator Noble Francis for his 4 minutes, Junior, for his 4 minutes.
Thank you very much, Mr. Chair. Of course, I'm not a member of this committee, but you know, these are the important discussion to me, and I want to commend both of the bill sponsors on these two pieces of legislation moving forward. Thank you very much for your testimony as well, testifiers. The first bill in regards to 36-0123, I wanted to ask the highway safety, what is the status of the CDL, commercial driver's license?
Daphne O'Neill, Director, Office of Highway Safety. Currently, that falls under the leadership of the Director of Bureau of Motor Vehicles, and she is spearheading that. I know that we went on a fact-finding mission in Washington, D.C. to get some background information together with her, and she's putting together what will be classes, a curriculum, and you would have to get more information from Director Barbara McIntosh.
So we currently we don't have a CDL in place currently?
No, we do not.
Okay. All right. Sergeant Traffic Commander Joseph, is there a situation where medication could actually impact the blood alcohol test? A person that have taken certain medication could impact the results of the blood alcohol test?
They may be. In my experience, I have not had any experience to know that, and anything is possible. But most of the situations that
you have trained extensively. Have you come across any such discussion in respect to certain medication could actually impact blood alcohol test results? A person that may be suffering from diabetes or maybe taking certain medication?
No, I have not had that in my 22 years.
You have not seen any such
that.
results there? Okay.
No, Senator.
What is the current blood alcohol test to be conducted to determine if a person is under the influence?
When you conduct the 3 standardized field sobriety tests, it is understood that a person's blood alcohol level, once they fail the 3 standardized field sobriety tests.
One of the 3, right?
Yes, once they fail the standardized field sobriety test, it is specifically the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test. It is presumed that the individual blood alcohol level is above 0.08 or higher.
Okay. And the proposed legislation is now reducing it to half of that for commercial vehicles.
For individual, it is based on what I have researched and read. The 0.04% is specifically for operators of commercial vehicles.
Right.
Operators of any other vehicle would be 0.08%.
Okay. And the highway safety is suggesting that it should go down to 0. Are you in support of that?
I am in full support of 0% when anyone is operating any vehicle, even a bicycle.
You know something I've always crawled my blood? Juve morning. Watching these tractor trailer heads with individuals, you know the amount of people I've taken out of tractor trailer heads during Juve morning because they, Mr. Chair, if I may just wrap up.
Yes, you can.
They're drinking alcohol and the catastrophe. That's the word, right? Well, Papa, that's the word? The catastrophe that could result from an individual driving or operating those tractor heads during Juve morning if they get lost control of that. And they got Hennessy bottle in their hands, between their legs, all kind of thing in terms of trying to hide from the cops. Those times have always crawled my blood in those situations. So this is easy for me to support moving forward. Mr. Chair, I just want to conclude by asking the Post Director in regards to what entails or what's the training requirement for the use of a lethal weapon or deadly force? What's the amount of hours of training involved in that?
Executive Director McIntosh Post. In reference to lethal weapon training, when it comes to firearms, it's 80 hours, and that's what's under the post standards. And when it comes to the use of force, that varies. AC Santos can probably tap in on that because the standard has changed or the amount of hours have changed. I think it went from 24 hours to maybe, I think it might be 32 or 40 hours.
Yes, that is correct. Assistant Commissioner Santos, that is correct. We have went up to about 40 hours in use of force or more. Then you have like the ASP baton. That training has went to about an 8-hour training, if I remember correctly. But we also implemented others such as the pepper spray, and we just encompass all of those total with firearms as well.
And are we recommending the same amount of hours for security guard and investigators, or some hybrid training?
It will be hybrid, Senator.
Be hybrid.
Yes, sir.
Very well. My time has been called. I don't want to abuse my time. Thank you very much, Mr. Chair, for the time. Thank you for your responses.
Thank you, Senator Francis Jr. Chair will recognize Senator Rhea Fonseca.
Yes, thank you, Mr. Chair. Daphne O'Neill, Sergeant. I just wanted you to just to expound on the program that Drive Safer or Get Pulled Over, because I know you do, and you ought to be commended for all that you do with advertising these kind of issues. So just to summarize what that program means for the community, because sometimes some people don't see it. So give us a summary.
Daphne O'Neill, Office of Highway Safety. I have the program manager for impaired driving, Ms. Katanya Petrus, and I will defer to her, give her a chance to speak on her program.
Hello, my name is Katanya Petrus, the Impaired Driving Program Manager. To answer your question, Senator, we do a slew of everything possible to reduce impaired driving. It's one of the toughest, hardest jobs in our community because alcohol is so abundant and is everywhere, and everyone have this invincibility that they know the consequences, but they don't care about the consequences. So we do advertisement from radio, TV, even YouTube. We have sub-recipients in our community that we use. We put up posters, we put up crashed vehicles every Christmas season. I don't know if you guys see that every year, because it wants to show what the risks are and what can happen or does happen. As far as we have training, we have enforcement with VIPD, which is tremendous in helping us get a message across. And we're still in the process of creating more. We can do so much more, and it starts with the legislative body in order for us to do more within the community and become more aware.
Thank you.
You're welcome.
And so, you know, in the bill 360123, there's going to be some penalties. So I think if the bill is voted on favorably in the Rules Committee, I want to do an additional amendment so those fine monies will come back to you so that you can continue to do that program. So that, because we don't just want to penalize the drivers, we want you to drive responsibly. That's the main thing. But if you don't, then there'll be a penalty, and we want some of the money to come back to you so you can continue your programs, because you're doing a fine job. Thank you, Mr. Chair, for the time.
At this time, the chair recognizes Senator Lawaetz.
Thank you. Mr. Chairman. Commissioner Santos, as it pertains to Bill 36-0136, let's have a dialogue here. Does this bill, by any chance, stop any private citizen from obtaining or obstructing them from obtaining a firearm license?
No, Senator.
Good, because there's, some chatter out there that this bill might be making things harder for them. And all I'm trying to do is secure the community, and by educating our security guards or private investigators and so forth in the community to make things easier, de-escalate stuff. Sometimes we've been in situations, we've been in bars, we've been all over where, at times, if the security guard would only diffuse it a little differently, things would be different. And, by this type of thing now, they'll be able to give the police department be a better witness as well, right? To provide information to the department when things happen. And they'll also be themselves.
Absolutely. Senator, if I may, I have looked into this bill a while back as well. It works in the state of Pennsylvania and Philadelphia. This bill acts as a force multiplier to law enforcement in the state of Philadelphia when I did the research. And not only that, it also assists the security officer or agent to also, not only they have good training, but it also aided them in getting the concealed carry permit for their personal use as well.
Thank you. And it might just be an opportunity now. People might see how good the training is at VIPD and everyone come over on the other side.
Absolutely.
That's it really roughly for me this afternoon. If Harry and I are ready to take action, that's it for me.
Thank you, Senator Lewis. At this time, I'll let the testifiers wrap up. 30 seconds. We can start from the end here at Mr. McIntosh and move along.
Thank you to everyone. Thank you for the opportunity to provide testimony on this critical bill. I trust that the necessary amendments will be adopted and it can be implemented so it can move forward without delay.
Thank you. Sir Gordon Rhea.
Thank you very much. I would just reiterate my support and the Department of Justice's strong support for the pending bills from this session that we just had. So we're definitely in support. And as I said, there may be some necessity for some clarification of a few portions of it, but the idea behind them is quite solid, and we completely support them.
Thank you. Assistant Commissioner.
Yes,
Santos.
thank you, Mr. Chair. On behalf of the men and women of the Virgin Islands Police Department and Police Commissioner Mario Brooks, I want to thank each and every one of you for having us here today. And in support of all the bills that we've been through from this morning. Yes. We appreciate the robust conversations, and we look forward to aiding in any more assistance that we could give to not only here at the legislature, but also to the people of the Virgin Islands. So thank you so much.
Sunil.
Thank you, gentlemen, for having us. And we fully support Bill number 36-0123. We understand that as a territory, we have to abide by the federal regulations. But again, we also understand as a territory, we have to protect the citizens and the visitors. So we are hoping that you guys act accordingly, and we are in full support. Thank you for the opportunity to testify.
Thank you. Do I hear a motion? Motion, Senator Fonseca.
Thank you, Mr. Chair. Mr. Chair, I move amendment number 36-516 to Bill number 36-0123. Bill number 36-0123 is amended as follows. A, Section 1, Paragraph A is amended 1.
Recognize the mic, Senator Lewis.
Yeah. Mr. Chair, I move to amend the reading of the amendment. I move to waive the reading of amendment number 36.516 to bill number 36.0123. I so move.
The motion to waive the reading has been properly moved by Senator Lewis and second by Senator Franklin Johnson. Hearing no objection, so ordered.
I so move. I so move.
The motion for the bill has been, the motion for the amendment has been adopted to bill number 360123. Roll call.
Motion.
Senator Fonseca, could you recognize Fonseca?
Motion.
Senator Fonseca, Mike. Motion.
Thank you, Mr. Chair. Mr. Chair, I move bill number 36-0123, an act amending Title 20 Virgin Islands Code, Part 2, Chapter 43, Subchapter 1, Section 493, making it unlawful for a person who has 0.04% or more by weight of alcohol in his or her blood to operate a commercial motor vehicle, and making it unlawful for a person under the age of 21 years who has any detectable amount of alcohol in his blood to operate a motor vehicle as amended, be voted favorably in this committee on Homeland Security, Justice, and Public Safety, and forwarded to the Committee on Rules and Judiciary for further review and consideration. I so move.
Second.
A motion has been made by Senator Fonseca on bill number, been moved, and second by Senator Franklin Johnson and Senator Avery Lewis. Roll call.
Senator Angel Bolkes Jr. Senator Bolkes absent. Senator Dwayne M. DeGraff. Senator DeGraff, yes. Senator Ray Fonseca. Senator Fonseca, yea. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Franklin D. Johnson. Yes. Senator Johnson, yes. Senator Avery L. Lewis. Yes. Senator Lewis, yes. Senator Clifford A. Joseph.
Yes.
Senator Joseph, yes. Mr. Chair, you have 5 yes, 2 absent.
So the motion has been made by Senator, the bill number 360123. Motion has been voted on favorably as amended and has been approved by this Committee on Homeland Security, Justice, and Public Safety, and will be forwarded on to the Committee on Rules, Judiciary, for further consideration. Motion. You recognized.
Thank you, Mr. Chair. Mr. Chair, I move bill number 36-0136, an act amending Title 23 Virgin Islands Code, Chapter 17, Subchapter 2, by adding new sections 1331 and through 1336, mandating lethal weapons training for security guards and investigators, be voted on favorably in this Committee of Homeland Security, Justice, and Public Safety, and forwarded to the Committee on Rules and Judiciary for further consideration. I so move.
Second. A motion has been made by Senator Lewis, second by Senator Fonseca and Senator Johnson. Hearing no objection to the senators, roll call. for bill number 360136.
Senator Angel Bolkes Jr., Senator Bolkes absent. Senator Dwayne M. DeGraff, Senator DeGraff, yes. Senator Ray Fonseca, Senator Fonseca, yea. Senator Kenneth L. Gittens, Senator Gittens absent. Senator Franklin D. Johnson, Senator Johnson, yes. Senator Avery L. Lewis, Senator Lewis, yes. Senator Clifford A. Joseph Sr.,
Yes.
Senator Joseph, yes. Mr. Chair, you have 5 yes, 2 absent.
Bill number 360136, an act amending Title 23, Virgin Islands Code, Chapter 17, Chapter 2, by adding new sections 1331 through 1336, mandating lethal weapons training for security guards and investigators, has been approved by this Committee on Homeland Security, Justice, and Public Safety and will be forwarded to the Committee on Rules and Judiciary for further consideration. Colleagues, that concludes the business of today's meeting. I would like to thank the central staff of the Legislature, the testifiers that came before us today. I also want to thank my colleagues and my staff for a productive day, for a productive meeting. The Committee on Homeland Security, Justice, and Public Safety meeting of September 4, 2025 is hereby adjourned.